My lord, even the lord, it doesn't permit
Mentioning only on Thursdays and Mondays.
the urgency.
For judgment.
No, please come back tomorrow.
Well, the urgency
Item
is
number
the
one.
tender process.
Please
Is
come back tomorrow. No.
My lord, I'm mentioning for withdrawal, my lord.
No.
Lordship, I want to obtain a leave, Lordship, to file one petition, Lordship. May I? Obviously.
Chair, mentioning for non-prosecution.
Accordingly, WPA 18735 of 2022 is allowed on contest, thereby setting aside the notification number such and such dated January 28, 2022 and quashing the order dated January 27, 2022 passed by the Secretary Government of West Bengal Minority Affairs and Madrasa Education Department. The nomination of respondent number 2 as a member of the Waqf Board, State of West Bengal is thus set aside and quashed. The respondent number 1 is directed to undertake fresh steps immediately for a fresh nomination under Section 14(1)(d) of the 1995 Act in the post left vacant by the removal of respondent number 2 by virtue of this order. It is expected that the respondent number 1 shall take into account the observations made herein above while making such fresh appointment, adhering to the rule of law, principles of transparency, and to Section 14(1)(d) of the 1995 Act in its letter and spirit while doing so. Such exercise shall be concluded at the earliest, positively within 2 months from date. No less to cause urgent certificate.
Grateful, Your Lord.
So grateful to my lord.
Operation of the my lord's order, my lord. On behalf of the
Since-
state respondent, my lord.
Since there are arguable questions involved, on the prayer of learned counsel for the state, the operation of the above order is stayed for 3 weeks from date.
Obliged.
সই করলাম না কেন একসঙ্গে?
My lord. Do we mention item number 2 for release?
Yes.
Your Lordship,
Why release?
Your Lordship, may kindly release the record, Your Lordship, being WPA 8493 of 2020, Your Lordship, since it's pertaining to 2020, and Your Lordship is having determination since 2021, Your Lordship.
Group 9,
Group 9.
দেখি লিস্টটা দেখি।
ও আচ্ছা আচ্ছা। All right. It is pointed out by learned counsel for the petitioner,
Yes, Your Lordship.
petitioner that this court has determination to take up residuary matters from 2021 onwards, full stop, as the matter relates to the year 2020. Let the matter stand released from my list due to lack of determination with liberty to
And-
the parties to mention for inclusion before the appropriate bench.
Your Lordship, one can 2 of 2022, Your Lordship, was missing from the record, Your Lordship. It was earlier mentioned before this court also, Your Lordship. We are giving
Could
a
not trace out, yes. Mention before wherever it appears, yes.
much of.
এই অরিত্র একটু খেয়াল রাখতে হবে 2020 আমারও খেয়াল থাকে না। ঠিক আছে, যেটা আছে সেটা
Extension of interim order, item number 3.
No, I have been of the petition.
when does it expire, the interim order?
Not just 16, Milord.
The interim order granted earlier is extended till February 29, 2024 or until further order, whichever is earlier, full stop. The matter be placed in the list for hearing on January 29, 2024. Along with Can 1. Along with Can 1. Be placed. Oh, acha. Disposing of this can, because that is for extension of.
Yes.
Can such as such is accordingly disposed of with liberty to pray for extension on the prayer made in the writ petition itself.
I for the respondent in this matter.
Yes.
Upgraded matter, item 4.
4, my lord, I am for the petitioner.
The difficulty is just now it was pointed out to me that I have determination from 2021 onwards. It's written in my list, but I missed it out. I'm sorry for that. I'm extremely sorry. I should have checked out. But this 2021 thing is a surprise to me also. Today, this morning, one matter I had to release for that purpose. 2021 onwards. So I'm sorry, extremely sorry. I can appreciate your agony because it was upgraded and all. Yes.
But what can be done, my lord?
Yes, it was pointed out just 2 matters back, so I cannot shut my eyes to that. When the matter is called on for hearing, despite the urgency involved, it is found that the writ petition pertains to the year 2014, whereas this court has determination to take up such matters from 2021 onwards. Full stop. Accordingly, due to lack of determination, the matter will be released from my list with liberty to mention, with liberty to the parties to mention the matter for enlistment before the appropriate bench having determination in the matter. I'm
Deep
sorry.
reference.
Yes.
Deep reference.
পরিচয় একটু খেয়াল রাখতে পরে বলবো।
Item 5,
Now for the petitioner lordship 5 to 11.
5 to
Lordship,
5 to 11.
Yes. Affidavit of service lordship.
Good service has been affected, Mr. Chatterjee, because they're not
Good
appeared.
service lordship was affected earlier. Thereafter, after mentioning lordship, I've given the notice.
Very good.
The state has got the copy. However, there is a private respondent who I wanted to give the physical copy to them. They have not taken it.
Copy of the writ petition.
The copy of the writ petition that has been sent, dispatch lordship is I've already sent. Now, lordship, in a nutshell, the matter, lordship, kindly hear me.
Should we wait for the private respondent, Mr. Chatterjee?
Lordship, this matter can be disposed of, lordship,
What
today.
is the matter about?
This matter, lordship, was filed against, lordship, the West Bengal Housing Board, as
Mr.
well
Chatterjee,
as
when did you send to the private respondent? When was it sent? Just check up.
lordship. Lordship, this was slipped. The
You can
lordship,
take my every doubt. Take both and check up when it was sent to the private respondent.
lordship, these were the copies earlier. The
Earlier copies, when were they sent?
These were sent on lordship 9/5/2023 and it was delivered
Oh, 9/5. About the mentioning, it was sent recently.
recently. So this can be disposed of by, because in a nutshell, the matter is that
Shall file the affidavit. Sir. Yes.
lordship petitioners has approached lordship for the accommodation of flat. They have paid for that. It is the promoters are the West Bengal Housing Board in collaboration with the Imami, Bengal Imami. Now they formed the joint sector company and started this development work as a part of the Rajarhat development. Those are reflected from the agreements. Lordship, if your lordship wants, I can. Now, lordship, what has happened when the petitioners filed this? Lordship, this West Bengal RERA was
Were
not
purchasers of flats.
flats. However, it is HIG, higher income group. Now, lordship, RERA was not operational at that point of the time. Now, lordship, RERA is operational presently. The Housing Development Authority is there. If your lordship want, lordship may dispose it by giving me a liberty to file an application before them and kindly stipulate the time. Because, lordship, what is unfortunate part of this, the first petitioner of the first item number 5, he had a premature death very recently. Now he is no more. Now other petitions are pending. Now again and again, this is basically only two things has to be done. One,
Petitioner number 5.
petition, the item number 5, the petitioner in item number 5 is no more.
এটা কত নম্বর দিলে?
5. There are 6, 7, 8, 9, 10, 11.
5, there is only one petitioner.
One petitioner. He is no more. Lordship, that I have I have
Petitioner number 5. Petitioner in 5.
petitioner in item number 5. Lordship, he is no more. Now, Lordship,
It's better than
then kindly adjourn that matter. Kindly 6 to 11. Lordship has to be taken.
not adjourned. This had abated.
Lordship, kindly,
To 11,
I will just seek the instruction on that, whether somebody wants to be substituted, Lordship. Lordship, in that
Very
case.
well. Item number 5টা আলাদা করে দাও। Item number 5 এর একটা order হবে. Since the petitioner has died in the meantime, as informed by learned counsel for the petitioner, comma, the matter is adjourned for a fortnight to enable the petitioner to take steps for substitution. Push up. Bas, this much. It was 6 to 11. Learned counsel, when the matter is sought to be moved, comma, it transpires that there is an equally efficacious alternative remedy in the form of a challenge before the RERA, full stop. Accordingly, WPA such and such, সবকটা number দিয়ে, are disposed of with liberty to the petitioner petitioners to move the appropriate forum with the challenge as preferred in the present writ petition. Full stop, it is made clear that the merits of the writ petition have not been gone into by this court. Full stop. If so approached within a week from date, comma, it is expected that the appellate authority shall decide the matters as expeditiously as the business of the said forum permits. No orders to call.
Will you kindly stipulate the time? Lordship, maybe please.
You have not yet filed. Preferred
Lordship,
the-
kindly, 1 month, Lordship. The authority is the regulatory authority instead of appellate authority. Lordship, it has to be regulated.
appellate na করে regulated authority. No. Next. Sopkorote affidavit of service. Mr. Chatterjee, please ensure that in all the matters affidavits are
Not
given.
sure.
Service. It has not been given.
I will give. Lordship, 1 minute.
Immediately give it. Otherwise, these orders cannot be signed. First give the copies, তারপর একটা call করো।
দুরমটা বলো, এটা। সুদামা এটা দাও, সুদামা দাও। 5 দিয়ে দিচ্ছ ওটা। এটা দাও, হিরকেরটা দাও। সবাইটা দাও। দিন তো। এই। এটা ছো।
ঠিক আছে? কল করো।
বাকিটা দাও। বাকিটা দাও।
না, তুমি কল করো এবার।
Item 12.
Item number 12, my lord, I am led by Mr. Joyanthan Chatterjee. May I pray for a short pass over, my lord?
No. Either you move the matter or it goes
My lord.
in another normal hearing. You're for the petitioner.
My lord, I am happy.
Yes, yes, move the matter.
My lord, the petitioner is
Please
present.
come closer to the
My
microphone.
lord.
Yeah.
The petitioner is presently serving his sentence of life imprisonment at Lalgola Open Air Correctional Home. My lord, the SSRB rejected his prayer for premature release. My lord, that is at page number 103. I'm sorry, my lord. The rejection is dated 14/9/2022. Lord, may I just read out this rejection, my lord?
Yes, please.
My lord, this is the intimation. It says that this is to inform you that your prayer for premature release has been rejected on the following grounds by the SSRB. An act of a group being a member of a disciplined force, they committed crime against women, following which committed a heinous murder, affected the society at large. Chances of future recurrence of committing crime cannot be ruled out. He is strong enough to commit a crime. The convict intends to start his new business of selling garments. The wife of the victim has strong objection on the proposal of premature release. Kolkata police authorities raised strong objection against release. Considering the above facts and circumstances, premature release is not recommended. This is the rejection.
Who has filed the writ petition?
My lord, the mother of the convict.
What is the age of
Rani
your son?
Goswami. My lord, the age of the convict, my lord.
Convict?
My lord, the age of the convict. My lord, the petitioner is aged about 68 years.
Convict's age is important. Her age is not important.
My lord, the convict's age, my lord, the detention
He was a member of a disciplined force, means which force?
My lord, Kolkata police, my lord. He's serving the sentence under section 302. He was convicted, 302, 34 and 354
While
and
in
30.
service, he killed somebody.
My lord, there was the incident of my lord. My lord, may I place his good conduct? All the documents I have annexed, my lord. My lord, the first is, my lord, he is a regular participant in different cultural programs.
Where is that?
My lord, this is my lord, the mass petition, the Gram Panchayat certificate. It starts from page number 9090.
No, how did he participate in that? During incarceration? He was on parole for something?
He was granted parole several times, my lord. He was granted parole. The Gram Panchayat says at page number 90, I am reading this out.
Yes.
It says that Mr.
Piyush Goswami.
Piyush Goswami, is a resident of such and such, my lord. At para 2 it is saying, but now he is at in Lalgola Open Air Correctional Home. If he will be released from the said correctional home as per any releasing rules of our
This
government.
does not mean anything. The Panchayat
My lord, page number 91, I am reading this out. He is a good football player, present football coach, and presently involved in various types of social works like blood donation, food and water distribution to poor people, etc.
How can we be involved in those? He is in jail.
My lord, during the time he is granted parole, he is involved in all this.
We will direct a reconsideration on this.
My lord, only the detention certificate may I place, my lord, the detention certificate.
What is conduct?
My lord, about regarding his conduct, my lord.
Yes. What is your name, please?
My lord,
Your name?
my lord, Supreme
Not the
Noskor.
convict, your name.
My lord, Supreme Noskor.
You are Supreme Noskor.
My lord.
Acha. Yes.
My lord, the detention certificate is at page number, my lord, 67. This says that he has found trustworthy, disciplined, sincere, diligent, and of fine moral character person of this correctional home. His conduct and performance are praiseworthy during detention period. I wish his success, every success in life.
Please
This is-
consider this and have a. You are for the state. You are not happy.
Item number 8.
Well, what about affidavit?
My
of
lord,
service?
affidavit of service I have, my lord. I have also intimated about the mentioning, my lord.
একটা order করবেন. The affidavit of service filed today be kept on record. Full stop. The mother of a convict who is now in the Lalgola Open Air Correctional Home, comma, has preferred the instant writ petition seeking premature release of her son. Full stop. Next para. The reasons for the rejection of the petitioner of the prayer of such convict for premature release has been annexed at page 103 of the writ petition, which indicates that the primary consideration for such rejection was that the petitioner had committed a heinous crime despite being a member of a disciplined force which affected the society at large. First of the convict intends to start his new business of selling garments, but the wife of the victim has strong objection to his release. Push up next para. It is well settled that the modern criminal jurisprudence demands that the reformative approach gets precedence over retribution. Push up next para. As is well settled by several judgments of the Supreme Court and by judgments of different high courts, comma, while considering the question of premature release of convicts, comma, the sentence review board has to look into, among other things, comma, the current conduct of the convict as well as the possibility of his being reintegrated in society. Full stop. In the present case, comma, the petitioner has annexed a certificate by the superintendent of the Lalgula Correctional Home, comma, the very place of incarceration of the petitioner, which indicates that the convict is trustworthy, comma, disciplined, comma, sincere, comma, diligent, and of fine moral character, and his conduct and performance are praiseworthy during detention period. Full stop. That apart, comma, documents have been produced to show that the convict is otherwise engaged in several social activities, and there is a fair chance of his getting reformed and being reintegrated in mainstream society if released prematurely. Full stop. However, comma, such yardsticks have not been tested by the SSRB while rejecting the convict's prayer for premature release. Full stop. As such, comma, the rejection of the prayer by the SSRB is set aside. Full stop. WPA 7429 of 2023 is disposed of by directing the State Sentence Review Board within bracket SSRB to reconsider the prayer of premature release of the petitioner's son, who is a convict in the Lalgola Open Air Correctional Home, on the yardsticks as indicated above. Full stop. It is expected that such reconsideration shall be undertaken at the earliest, positively within a month from the date of communication of this order to the respondent number 2.
I'm grateful.
In
my lord.
order to cause certain.
I'm grateful. my lord.
Yes.
My lord, only one thing, my lord. May I give my senior's name, my lord, in the appearance?
He is in court.
My lord, he's in court. He's on his legs, my lord.
Yes.
I'm grateful. my lord.
Item number 8, I am appearing on behalf of the state.
8, whatever order has been passed, has been passed. প্রগত কি জাস্টিস ভট্টাচার্য কি লিখছে দেখো না বলতে পারবো বোকা
Item 13.
Yes.
My lord, 13, my lord, kindly take it tomorrow, my lord. I was caught unaware, my lord. I didn't know, my lord, that the matter is appealing.
On the prayer,
Then Milo, kindly take it day after tomorrow, one day more, Milo.
you are appearing for which?
For the bank.
On the prayer of learned counsel for the respondent bank, the matter is adjourned and shall next be taken up on January 19, 2024.
Great.
Same heading.
Fourteen.
Reporter ready to call.
My application.
Yes,
Lord,
Mr. Bachar.
fortunately, my Lord, by now the issues involved in the writ petition are settled, both by your Lordship and the Supreme Court. So, my Lord, hopefully this, my learned friend is a formidable opponent, but hopefully he won't press it. Now, what has happened here is, my Lord,
That's a great certificate, Mr. Rai, from coming from Mr. Bachar.
no, my Lord, he is a, my Lord, he's a hard worker and a fair counsel.
He's a
my Lord.
very hardworking person. Yes.
Now, my Lord, what has happened here, there was a IBC sale of a company, my Lord, which I took over. Now, your Lordship knows the clean slate principle applies. Now, apart from the clean slate, Lord, in this case, Lord, as usual, advertisements were issued. CSC, Lord, the electricity provider to that company, never came and put in any claim. But there is a specific provision in the scheme saying that all electricity dues and other dues, not various other dues, are wiped out completely. There's a specific provision. I'll show that to your Lordship. Now, I acquire it. Now, Lord, I apply first, not for reconnection of the low tension, Lord, supply. I
They're
get
insisting upon the outstanding.
No, I got it. I got it. There was nothing they indicated. Now, my Lord, I set up the factory. I've spent almost 250 crores.
Yes.
I set it up, and Lord, to now get it operational, I need the high tension to start testing and other things. I applied to them. Now, they say nothing about dues. They say we need to set up facilities for providing high tension, and they, my Lord, gave an amount of 4.2 crores. 4.2 crores to set up the, no, not a comical. 4.2 crores to set it up. So I negotiated, they ultimately brought it down to 3.7 crores. Now, when they said this is the amount, they raised a bill, I paid that amount. They accept it. After accepting it, they send a letter saying, look, there are past dues of some earlier entity, not even the entity which has been brought over, which was called Network. I bought over a company called Network. Now, they say that there's some other company by the name of Siltap. Dues of 16 years ago. And they raise a small amount first. I said, look, you never told me all this. Now, then, Lord, they enhance that amount with interest. They say 8 crores till you pay it. They've already received that amount for setting up the facilities. They say till you pay this 8 crores due from some company called Siltap, we will not. Lord,
This
give
was
it.
not there in the quotation.
Lord,
The
no,
quotation was raised
no,
by
no, no,
them.
no.
They
Quotation
paid
was
that
for the
after that.
purpose. Quotation was not only for the purpose of setting up whatever facility are required to give high tension. Now, my Lord, my factory is ready for operation. Without high tension, I can't operate. I can't even do my test run. This is the situation.
But is that communication?
Now,
Mr.
my Lord, yes, ma'am. Now, my Lord, if I can just show your Lordship just 2 or 3 things.
Yes.
Lord, please first come to, my Lord, page 87. This is the portion of the scheme, NCLT. At page 87, your lordship sees on top past dues, if any, with electricity, water, etc., and any other statutory department may create problems. Now, we see the finding. Therefore, not after the table. Therefore, in lieu of the above, on and from the effective date, all claims, including electricity, water, etc., and then, Milord, and Milord, your lordship will also find they will stand extinguished, settled, abated. Now, Milord, in addition, Milord, please also come to Milord page 193. And Milord, sorry, Milord, I should have showed your lordship that this is approved. That's at page 70. Page 70. The ordering portion. Now, Milord, if your lordship would come straight away from there, Milord, to page 186, Milord. So, Milord, I don't really need to show your lordship this other than that, than them saying that, look, we will give you this 33 kVA power through a single meter system and you need to pay. Milord, a bill is raised and a diagram. Now, Milord, after that, Milord, if your lordship comes straight away to page 193, 193. They had raised a higher claim. We talked to them. They said, okay, very well, we'll construct it at 370 lakhs. Page 193. Note second para, in view of your submission, we have once again reviewed the payable service charge for the desired supply and the same stands revised at 370 lakhs. Now, Lord, please note the dates here. It's very important. 25th of January, 2023. Now, Milord, please turn the page. Page 194. Milord, the second email on that page. We confirm acceptance of your offer. So we say we accept it, and on top they say we will raise the bill. The letter and bill will be delivered at your office. Now, Milord, that's delivered. And Milord, please see page 195. So this is where they raise the bill, which is on the next page, 196, 370. And Milord, we make payment that not they accept page 198. So now, Milord, please see the date over here now. 2nd February, he is acknowledging receipt.
Yes.
Now, Milord, please see on the next page, what he does is, he now sends a backdated letter. That I'll show your lordship presently. Straight away. Page 199, letter is dated 31st January. Now, Milord, please come to para 2, the second para of para 2. You are surely aware of the fact that erstwhile high voltage supply at the premises was disconnected for non-payment of electricity charges, a sum of 1,37 crore towards principal and delayed payment surcharges payable are lying recoverable on account of pertaining to the erstwhile HT supply lying disconnected from 12th of February 2007, 16 years ago. Favoring Messrs. Sitlak. Now, I don't even know who Sitlak is because, Milord, I've got this from Network. The company in liquidation was Network. Now, Milord, please turn the page. Now, Milord, please take page 201. Oh, I'm sorry. Milord, I forgot to show you. Page 200, Milord. Now, see when this letter is posted. Dated 31st, but see the date of posting, bottom of the page. Milord, your lordship will have to turn it upside down. The print of the post office is there, Milord, 3rd of February. Milord, right at the bottom.
Here.
Yes. Not that portion where your lordship finger is. Your lordship will find, not it's upside down, but your lordship will find the date 0302 2023.
Just above the stamp.
Yes.
Two lines above the
Yes.
stamp.
So, Milord, dated 31st, sent on 3rd, he has received my payment on 2nd. Now, Milord, look at the clever device. First, take what you can and then hold him in ransom. So, Milord, he has received 3 crores to set up the Milord supply. 3.7 crores. Now, Milord, I write to him, Milord, usual, not saying everything about IBC, not clean slate, you did not come, not the usual, everything is over there. And Milord, for 3 years, you have not raised this claim. IBC gave it to me in 2018-19. They did not go before IBC. All of that is there. Now, my lord, they reply.
Correspondence culminates in the Wakalatnama.
Now, my lord, 20. No, then, my lord, 204, he gives a reply. Now, my lord, here the ground is very clear why he is not giving it. Now, whether it's a legally sustainable ground, my lord, I think now there is no dispute. Please take the second last paragraph.
Yes.
Dues of an erstwhile terminated consumer. This is his claim. In respect of supply at the premises is recoverable from an intending consumer seeking a new supply. So he can get it from the new consumer. In terms of the extant regulations framed under the provisions of the Electricity Act, the fact that the aforesaid letter of 31st January was dispatched contemporaneous to or after receipt of 3.7 crores is merely coincidental and not intentional. Then, my lord, please see the next para. He says the resolution profession did not tell them. We did not receive any communication from IRP or RP regarding pendency of CIRP against network. Notwithstanding the same as stated above, extant regulations permit recovery of electricity dues from intending purchases, provisions of Electricity Act, supreme in the event of repugnancy with other statutory provisions. So, my lord, this is the second point he is relying on. Lord, this is also now settled by the Supreme Court, my lord, and your lordship. Then, my lord, your lordship will see the next page. LT supply to network industries was also resisted owing to past dues at the above premises. The same was provided pursuant to court order as an interim measure. Issue of recovery of our dues was kept open for adjudication. Said proceedings were ultimately dismissed for default, and network had not taken steps for restoration of the same. So, my lord, this is also at least from 2016. Supply to network was live when you took over the same as successful resolution application and is live. However,
No, this LT network owing to past dues court order, these were prior to the
no,
resolution
no, that's the
with network.
that's network for dues of the SITLAB. Lord, as your lordship saw, it was disconnected in 2009, perhaps. Now, however, to affect HT supply, the LT supply will have to be de-energized since existence of two modes of supply are unsafe. And Lord, this is again something Lord he raises for the first time. So now, my lord, that 1 crore 37 claim, he adds interest to make it 8.07 crores. So now he says 8 crores. So from our original demand, my lord, I give one more letter of demand in October, and Lord, I'm before your lordship. They have said, no, I'm not going to give it to you. That's at 208. Lord, this is the situation, Lord. This is the factual basis. Now, Lord, as far as the law is concerned, Lord, I think, Lord, your lordship knows it perhaps better than me because there's a your lordship judgment. Lord, 4 points over here. Just to summarize, Lord, number one, Lord, the clean slate plate principle, Lord, in Ghanshyamdas, Lord, case.
Yes.
Number one, Lord, Supreme Court has adjudicated that. Number two, Lord, section 30, what was it called? 38, perhaps, Lord, of the IBC. Override. 238 is overriding provisions
Yes, yes.
of the IBC.
Yes.
And Lord, resolution plan 30, section 31. Now, the only other question which remains is whether Lord, the electricity regulatory rules, the regulations framed by the Electricity Commission will override. That's the other point raised in his letter. Now, that issue is also now settled. Now, there are two Supreme Court judgments and Lord, your lordship's judgment. I'll just hand those over. Lord, Tata Power. Tata Power and Southern Power Distribution are two of them. Very short orders, but they take care of the point. Tata tea आगे दिया एक other side के दिए तो अच्छा oh see I was right then huh? Well
I think I'll
prepared
hear
Kollam.
Mr. Mukherjee and Mr. Rai separately on this.
Tata Pot कोणता दिली तुम्ही आगे Tata दिली yes now please take Tata Power. In our opinion, the legal issues covered by the judgment in Paschim Manchal with Vidyut Vitran versus so-and-so and the order of this court in Southern Distribution, the appellant Tata Power Odisha cannot insist on payment of arrears which have to be paid in terms of the waterfall mechanism for grant of electricity connection. However, successful resolution applicant will have to comply with other requirements for grant of electricity connection, but I've already done that. The clean slate principle would stand negated if the successful resolution applicant is asked to pay the arrears payable
Next
by
expression was the Hydra head expression. Anyway, so these two.
So, not these two, not your lordship is aware of, not then not your lordship
Yes.
will also take, not your lordship's judgment followed by the division bench judgment, not in the case of not Vasavi Industries.
I think these two will suffice, Mr.
Otherwise, not your lordship's not judgment followed by the division bench judgment in Vasavi. You have copies of it, or you want
একটা
copies?
ডিভিশন বেঞ্চে চারটে সিঙ্গেল বেঞ্চ
আচ্ছা একটা copy. এই
Yes.
Vasavi টা দিয়ে দাও।
রাইট
Now, my lord, I just tell your lordship the urgency is pleaded over here, but I've spent, my lord, I've bought over a unit. That land has been converted or whatever was there has been converted into a factory. Now, I have been setting it up, but I've incurred substantial expenditure. Not by the month of October, we are ready to, my lord, test launch, not or not do testing operations because it's a heavy duty, my lord, machinery running in the factory. Testing needs to be carried out immediately. Otherwise, my lord, the plan itself may fail. But this is the situation. I've spent a huge amount of money. They asked me for not 3.7 crores, which I've already paid for setting up the facility. The facility is ready. There's no reason not to, my lord, now connect it. Those are my, my lord.
Yes.
So far as the legal issues are concerned, Lord, I cannot have any say, Lord, because of the Supreme Court judgments, my Lordship's judgment. Lord, the issue here is, my Lord, on facts. My Lord, if the writ petitioner agrees to pay, my Lord, there is a concluded contract, my Lord, which comes into existence. My Lord, thereafter, my Lord, whether a Lordship will permit him to resign. My Lord, a Lordship will kindly take, my Lord, page 186, which is our offer letter. 86. This is our offer letter, my Lord.
Yes.
My Lord, kindly have a look at page 188. My Lord, clause 4. Obtaining clearance from our senior manager ComHT in respect of outstanding dues lying at the premises, if any. My Lord, this was a part of the offer letter. Now, my Lord, they seek revision of the offer by the letter, my Lord, at page 190. And, my Lord, we agree to it at page 193. And what do we mention, my Lord? Kindly have a look, my Lord, at the penultimate paragraph, or, my Lord, third paragraph from the bottom and top both. All other terms and conditions as mentioned in our earlier offer letter will, however, remain unchanged. We request your acceptance of revised offer in order to raise formal invoice for settlement of service charge payment. My Lord, accepting what has been mentioned here, all other conditions remain the same, my Lord, which include this condition, my Lord, of obtaining clearance from the senior manager ComHT. My Lord, nothing has been placed before your Lordship that he obtained such clearance. Now, my Lord, kindly have a look at page 195. Which is the letter dated 27th of January 2023. My Lord,
Yes.
while, my Lord, we append our invoice, to that also, my Lord, we write in the penultimate paragraph, second paragraph, the other terms and conditions vide are letter number such and such dated 2/11/2022, which was the document which I placed first, will remain unaltered. No, my Lord, all of this is accepted. My Lord, there is no qualm, no quarrel to this. Then, my Lord, when my Lord, they do not come up and say, my Lord, we have obtained clearance. It was their obligation, my Lord, to obtain clearance and say, my Lord, from our own records, when we find this and we write to them on 31st of January 2023, which is at pin 199, that this is what is due, owing, and outstanding. Now, my Lord, to that they reply that it is an afterthought which was placed before your Lordship, page 201. Now, my Lord, kindly have a look at our reply, my Lord, which is at page 204. My Lord, the middle and the end portion was placed. Kindly have a look at the first portion, my Lord. The second paragraph. By our letter dated 2nd November 2022, the offer for the above supply at rupees 4.06 crore was communicated to you. In the said letter, it was stated in express terms that you would have to settle any outstanding dues lying recoverable from the premises in question, which would be communicated to you by the senior manager commercial. Pursuant to your representations and subsequent decisions, the said offer was revised to rupees 3.77 crore, which was communicated to you by our letter dated 25th January 2023. In the revised offer, it was categorically stated that except revision of the service charges payable for the above supply, all other terms and conditions of the original offer remain unchanged, including your liability to settle past dues as communicated to you in the original letter. Under such circumstances, rupees 3.7 crore was never the agreed amount. It was only the invoice, my lord, for the purpose of, my lord, charges. My lord, the outstanding, my lord, would definitely not have been included in it and was rightly not included. My lord, in this factual scenario, my lord, whether your lordship will permit the writ petitioner to resile from the contract, my lord, by way of a writ petition. My lord, this is the only question, my lord, which I pose to myself, my lord. And my lord, my very respectful submission, my lord, the answer will be in the negative.
I'll decide the writ petition right now.
Fine.
No affidavits read. No, Mr. Yes. Since all the material documents have been annexed to the writ petition, have had and has been addressed by both sides, comma, no affidavits are being directed. Push up, it is, comma, thus, comma, deemed that none of the allegations made in the writ petition are admitted by the respondents. Push up, next para. Learned senior counsel appearing for the petitioner argues that the petitioner was a successful resolution applicant and purchased a property, comma, for the purpose of setting up a
Purchased a company.
purchase a company and intended to set up a heavy duty industry. Full stop. For such purpose, comma, the petitioner applied for electricity connection. Full stop. Initially, low tension electricity connection was given. Full stop. Subsequently, when the petitioner sought for high tension electricity connection, comma, the distribution licensee, that is the CSC Limited, gave a quotation of about rupees 3.7 crore as charges for obtaining such high tension electricity connection by the petitioner. Full stop. The petitioner paid such amount. Full stop. Thereafter, comma, however, comma, the CSC Limited raised an additional claim of a huge additional amount by way of alleged outstanding dues. Full stop. Such outstanding dues, comma, even as per the communication of the, where are the details of the dues given? Which page, Mr. Bachar?
Page 99, 199.
199, thank you. Yes. Pertained for a period starting from February 12, 2007, which is about 16 years back. Full stop. Next para. It is argued that as settled by several judgments of the Supreme Court as well as this court, comma, once a successful resolution applicant purchases a property, comma, the said applicant has acquires the property on a clean slate, within double inverted clean slate. Full stop. Next para. Since the approval of a resolution plan under the scheme of the Insolvency and Bankruptcy Code obliterates all previous dues, comma, there is no question of any outstanding dues remaining further. Full stop. Next para. For such proposition, comma, learned senior counsel cites the judgments of Tata Power Western Odisha Distribution versus such and Southern Power Distribution Company such and such of the Supreme Court, as well as Sri Vasavi Industries Limited and another versus WBSCDCL, comma, rendered by a single judge of this court, as well as the division bench order affirming the same. Push up. Next para. It is also argued by learned senior counsel that contrary to the arguments sought to be advanced in their communications by the CSC, comma, the provisions of the IBC overrides the Electricity Act insofar as the obliteration of past dues is concerned. Full stop. Next para. Learned senior counsel also places reliance on section 238 of the IBC, which provides that the said code has an overriding effect of all extant law. Full stop. Section 31 of the said code is also relied on in support of the contentions of the petitioner. Full stop. Next para. Learned counsel appearing for the respondent stroke CSC Limited places reliance on the correspondence between the CSC Limited and the petitioner. First up, it is contended that by way of the communication dated November 2, 2022, comma, it was clearly mentioned by the CSC Limited while agreeing to give high tension electricity connection to the petitioner, comma, that the said agreement was subject to obtaining clearance from the senior manager within bracket commercial hyphen HT bracket closed of the CSC Limited in respect of outstanding dues lying at the premises, comma, if any, full stop. Subsequently, comma, while reiterating the agreement and uh, quoting an amount of rupees 3.70 crore, comma, it was reiterated by the CSC Limited vide letter dated January 25, 2023 and January 27, 2023 that the other terms and conditions remained unaltered, comma, with particular reference to the communication dated November 2, 2022, comma, which spoke about obtaining clearance from the senior manager regarding outstanding dues. Which of next para, thus, comma, in view of the concluded contract between the parties, comma, which obligated the petitioner to pay the outstanding dues, comma, the petitioner cannot now resile from such position in law. Which of next para. A bare perusal of the correspondences referred to by the CSC Limited shows that the provision in the letter dated November 2, 2022 regarding obtaining clearance from the senior manager of the CSC Limited was merely an empty formality. Full stop. It is to be noted that no specific outstanding due was mentioned in the said letter or subsequently prior to the claim first being made by the CSC Limited. Full stop. Hence, comma, mere mention of an unquantified outstanding dues, double inverted with outstanding dues, does not and cannot form the part of any conscious agreement between the parties. Full stop. Next para. In any event, comma, any agreement against the law is also not binding on the parties. Full stop. Next para. The provisions of the IBC as interpreted in the judgments cited by the petitioner clearly provide that when a successful resolution applicant purchases after the approval of a resolution plan, comma, all previous dues get obliterated. Full stop. The purchase is on a clean slate as held by the Supreme Court. Full stop. Next para. Hence, comma, even if there were to be an agreement for payment of outstanding dues, comma, such outstanding dues, comma, under the purview of the IBC, comma, would be nil, NIL, nil. Full stop. Hence, comma, nothing hinges on the said clause in the correspondence relied on by the CSC Limited. Full stop. Another aspect has to be looked into. Full stop. The provision in the said correspondence was merely that a clearance has to be obtained from the senior manager of the CSC Limited, comma, which is not necessary in law or as per procedure. Full stop. Next para. Such obtaining of clearance did not, comma, by any stretch of imagination, comma, tantamount to a specific claim of any particular outstanding due at all. Full stop. Next para. Thus, comma, the said clause did not cast any obligation on the petitioner at any point of time to pay any outstanding amount to the petitioner. Full stop. Next para. On a more basic premise, comma, the claim sought to be raised by the CSC Limited is 16 years old. Full stop. Hence, comma, the same is stale and the proverbial dead wood. Dead wood. Full stop. Next para. The CSC Limited would even otherwise be time barred, comma, both under the general law of limitation and as per clause section 56 within bracket 2 of the Electricity Act from making such a claim. Full stop. Next para. Even otherwise, comma, the CAC Limited has not established any semblance of nexus between the defaulter alleged to have left the dues and the present petitioner for to entitle the CAC Limited to make such claim of outstanding dues in the first place. Full stop. Next para. Thus, comma, the insistence of the CAC Limited post facto, comma, after having raised a specific quotation of 3.70 crore, which has already been paid by the petitioner, comma, by a backdated subsequent letter, comma, is palpably dehoves the law and beyond the authority of the CAC Limited, full stop. Hence, comma, the insistence of the CAC Limited for the petitioner to pay alleged outstanding dues as a precondition for the HT connection being given to the petitioner is required to be set aside, comma, being arbitrary and illegal. Full stop. Accordingly, WPA 26499 of 2023 is allowed on contest, comma, thereby setting aside the communication
Dated 31st January and 4th April 23.
communications dated January 31, 2023 and April 4, 2023, whereby the CAC Limited insisted upon payment of outstanding dues by the petitioner for giving the HT connection to the petitioner. Full stop. Such claim of the CAC Limited from the petitioner by way of outstanding dues is accordingly quashed. Full stop. The CAC Limited is directed to give the high tension electricity connection in terms of the application of the petitioner at the earliest, comma, positively within what will be a reasonable time? Within 3 weeks. High tension. Positively within 4 weeks from date. Full stop. No address to cause urgency.
Lord, upon compliance of all formalities, Lord, accepting
They
the
have
claim, Lord.
complied with
But,
comma,
I do not-
last comma within 4 weeks সেখানে বললাম comma, of course, comma, subject to compliance of all formalities by the petitioner, but without insisting upon payment of any outstanding dues by the petitioner.
Obliged.
Great.
But the matter became much shorter because of my learned friend's
Always,
pen as well.
Mr. Bachchan, it's a pleasure to hear people who are on the. আমার কাজ। Oh. That 15. My lord, I am for the petition.
My lord, I am for the WPA series.
Rejected, Mr. Kudubudu. You have set up a submersible pump?
My
or
lord, I
it's
have
not
set
there?
up but 2018, I have made application, fees deposited, my
Why
lord.
not given?
Till date,
My lord, previously inspection was done, my lord. Again, on 6th December 2023, inspection was made. And it was found that no meter room was constructed and no wiring and STW boring has not yet been completed.
Have you communicated that to them? Not.
That instruction
Submersible pump is there.
is not boring has not been
Pump is there.
Acha, please repeat once again. What has not been done? No meter room,
no meter room and no wiring.
wiring.
And he has not completed his STW boring.
How soon can you do it?
Well, 2 weeks.
Learned counsel for the petitioner contends that the petitioner applied for electricity connection to operate his submersible pump, which has not yet been given by the WBACDCL. Full stop. Next para. Learned counsel for the WBACDCL submits that upon inspection, it has been found that there is no meter room or wiring at the site where the electricity connection has been sought, comma, nor is the STW boring, BORING, complete as yet. Full stop. Next para, learned counsel for the petitioner seeks a fortnight's time for completing all formalities to get such electricity connection as indicated by the WBACTCL, full stop. Accordingly, let the matter stand adjourned till February 1, 2024, when it will be listed under the same heading, full stop. Upon completion of the formalities, the petitioner shall intimate the same to the WBACTCL, which will hold a further inspection to ascertain that it is now feasible to give electricity connection to the petitioner and intimate the court on the next returnable date in that regard.
Great.
Inform them immediately, 1st of February. Inform them immediately, do it as soon as possible.
My lord.
They'll hold an inspection and come.
Great.
16.
I am for the
My
petition.
lord, I am for the CSC. On the earlier occasion, your lordship has directed us to conduct a fresh inspection and submit a report, my lord.
Yes.
Lord, may I submit a report, my lord?
Yes, please.
And my lord, what we have found again, my lord, that the premises under question is a single-storied building, my lord, having several units or rooms. And my lord, the petitioner is occupying one of such rooms, my lord. And my lord, she is being catered sufficiently with a single meter from one of her relatives. So, my lord, this is a clear case of splitting of loads, my lord, which made us refuse her application, my lord. And that has been indicated, my lord, in paragraph 1, 2, and 5 of my report.
Lordship, may I submit?
Go to the JRO.
Lordship,
Yes.
Lordship, primarily when petitioner applied for the connection, the CSC authority rejected Lordship on the ground of annexure P2. Lordship kindly says that they need some certain documents for ownership, which we have produced and also annexed to the writ petition.
No separate.
Of course, let him finish. Yes.
Although I have just received the inspection report today morning, Lordship, I have gone.
No, but the difficulty is, Mr. Haldar, maybe they had said that.
Lordship,
Insisted on ownership.
I'm coming, Lordship.
After that inspection was held and they found out
Yes,
this.
yes, report I have gone through, Lordship. I am pointing
Yes.
out some. On point number 1, Lordship, they have stated that these are single-storey buildings separated into 3 residential spaces and unit. And petitioner is a co-owner of the premises. And Lordship, only 1 meter is there in the name of some Dilip Das, who is the uncle of the petitioner. And my instruction is that during the inspection and till now, petitioner is without electricity.
Your lordship kindly takes up paragraph 5. Not only the petitioners, the other co-sharers of the building
Petitioner
are
is
being
the
catered from the same meter.
petitioner is the co-owner of the property and residing separately.
Go before the JRO.
Lordship.
The petitioner contends that the petitioner has not been given electricity connection independently despite having applied for the same. Full stop. Upon previous direction, the CSC Limited has held an inspection and a report in that regard is filed today in court and kept on record. Full stop. Learned counsel for the CSC Limited points out that there is an existing electricity meter in the name of one Mr. Dilip Das, bearing meter number 3200569, standing in the same premises. Full stop. All residents of the said building, including the petitioner, are being catered from the said meter. Full stop. Hence, the apprehension of splitting of load cannot be ruled out if a new connection is given independently to the petitioner. Full stop. Next parallel, and counsel for the petitioner submits that the said Dilip Das is an uncle of the petitioner, and the petitioner is not being favored with electricity connection from the said meter. However, since a specific objection as to splitting of load has been taken by the CSC Limited upon holding an inspection, it would only be appropriate if the proper authority in that regard decides the issue on facts. Full stop. Hence, WPA 26742 of 2023 is disposed of by granting liberty to the petitioner to approach the concerned grievance redressal officer having jurisdiction in the matter with the dispute as raised herein. Full stop. If so approached, the GRO shall decide the said issue in accordance with law upon hearing all concerned parties as expeditiously as possible, preferably within 4 weeks from the date of such approach being made. No orders to cause urgency.
Great.
Lord, in this matter, Mr. Tiwari is leading me. I'm his junior. Lord, yesterday ROC has requested us and just to appear, and we are yet to receive the official engagement in this matter. And we are
doing he has been appearing for some time. It's your problem. He has served too long back.
Lord, yesterday only we have been requested by ROC. ROC was made a party in this matter after an application.
My lord, I have served a copy of that on the ROC.
How soon can you come back with instructions?
Yes, my lord. I'm just praying for a week's time.
Week. What do you say? Should I keep it on 22nd, next Monday?
Yes, my lord.
21st, my lord.
21st
21st.
It will be difficult.
Yes, fine. Okay, my lord. Obliged.
22nd. On
On
the
my lord, may it be kept on Tuesday, my lord.
is holiday.
Tuesday, 24th, I'll keep it on. Tuesday is also a holiday. I'll keep it day after that.
Obliged.
An adjournment is sought by the ROC, full stop. Accordingly, let the matter stand adjourned till January 24, 2024, when it will be listed under the same heading.
My lord, affidavit be kept.
Affidavit of service filed today be kept on.
Grateful.
18.
Your Lordship, I'll be appearing for the respondent number 3. I'm praying for a day's adjournment, Your Lordship.
Why? On what ground?
We are yet to receive instructions from the department, Your
What
Lordship.
do you? You are respondent 3 is?
IRCTC, Your Lordship.
They are the not main respondent. My lord, this writ petition was filed in December. So notice was served on the 7th of December. Now today, my lord, after my lord, nearly 1 month, my lord, they are coming and asking for adjournment. My lord, the problem is this petitioner is a 70-year-old. My lord, he has been running a bookstall. My lord, he was allotted a bookstall in 1977. My lord, all along, my lord, he has been paying the license fee whenever it was charged, enhanced, everything. My lord, in 2004, there was a policy, particular policy, my lord, came into effect by the railway. My lord, kindly take page 24.
Respondent number 3 is the divisional commercial manager.
Yes, Your Lordship. We don't have any active role pertaining to the
For
store.
the Eastern Railway,
We are for the IRCTC, Your Lordship.
that is not respondent number 3 then.
Um,
Must be respondent number 5 probably.
I'm sorry, Your Lordship.
You don't even know whom you are appealing for.
I'm sorry. I apologize.
Yes, Mr. Bandhavata, can it wait till tomorrow?
Probably she is telling 5.
Yes, Your
Has
My
to
lord,
be-
our stall has been sealed. My lord, 4th December, my lord, we replied the notice.
What is the role of the IRCTC here? They are running now.
They are the my lord, now the managing the stores, my lord, pursuant to a new policy. That is why now.
What is the role of IRCTC? They are the decision making authority.
Yes. No. My divisional commercial manager is the appropriate authority.
So why is IRCTC a party here at all?
My lord, subsequent by virtue of subsequent policy, my lord, this now my stall has been, my lord, sealed.
Allocated to them.
No, they will, my lord, auction it, or they will, my lord, ask for bid for reallocations of this stall.
IRCTC will do that.
Most probably, my lord, IRCTC will do that. My lord, their notice says so, my
Because
lord.
IRCTC is a party here.
Respondent number 5 is the part, my lord.
Yes.
My lord, there is a policy of 2017.
Can you
my
come
lord.
prepared tomorrow?
Yes, Your Lordship.
I'll keep it tomorrow, Mr. Bandhavata. Come back.
Grateful,
Tomorrow
Your
I am not here, my lord. That is the whole
Worry.
problem.
I'll keep it on Monday then.
Monday. Okay.
Monday.
Grateful, Your Lordship.
Obviously, you are grateful.
But surprisingly, my lord, as soon as this notice of writ petition received, they went and sealed my stall in December, 6th December.
Oh.
And I am now out of business from December. And that too without following any process. Simple a notice of evictions, 7 days, and sealed. Even they did not approach, my lord.
I'll record this is the last chance to the respondents to
As
appear.
well, my lord, I have served, my lord,
Affidavit of service filed today be kept on record. Full stop. An adjournment is sought on behalf of the IRCTC. Full stop. The other respondents are not present when the matter is called on for hearing. Full stop. As a last chance to the respondents to appear and contest the matter, and on the prayer of the IRCTC, comma, the matter is adjourned and shall next be listed under the same heading on January 22nd, Monday. On January 22nd, 2024. Please come back. If they don't appear, I put it in my order. Then I'll have to take up expert.
Yes, my lord, I hope, my lord, it will retain its position. My lord. Otherwise, my lord, in fact, it was filed in December.
I also hope.
We were pursuing, my lord, many times, my lord, because he is out of anything now.
True.
19.
I am for the petition, Lordship. Lordship, petitioner is carrying on business and applied for a commercial connection, Lordship. I have annexed the trade license.
Why not, Mr. Mukherjee?
My lord, we have inspected, my lord, firstly, my lord, there was no commercial establishment, not there is any separate accommodation which he can show, and he was deriving supply from the meter of the father, my
He has
lord.
got a permanent certificate of enlistment.
And Lordship,
My lord,
You are not to decide whether there is a
my lord, we have taken photographs, my lord. My lord, we have
maybe
taken.
due to the electricity they are not being able to start.
Lordship.
My lord, it is not possible only, my lord.
Why?
I will show you, my lord, the photographs. Kindly see. It is not, the photographs he has not annexed, my lord, and we have rejected on the ground of splitting of load. my
That
lord.
is a domestic connection.
My lord, this is a ploy, my lord, having a domestic connection, my lord, subsequently transferring into a commercial connection. My lord, in this.
He's wanting a transfer or a fresh connection.
Fresh connection. Fresh connection, my lord. Then the earlier connection is.
How can there be a splitting of load, Mr. Mukherjee? Commercial is rate is higher.
But there has to be a commercial establishment. And kindly see, my lord, this is the heart.
Let me see. At the tailoring business, yes, yes.
Nothing there, my lord. My lord, while then, my lord, if my lord allows me, my lord, I'd like to put in an affidavit to this, my lord.
Learned counsel for the petitioner submits that despite the petitioner having applied for electricity connection, comma, no such connection is being given by the CSC Limited. Push up next para. Learned counsel for the CSC Limited submits that upon inspection, it was detected that there is no commercial establishment at all, whereas the petitioner is seeking for a commercial connection. Push up that apart, comma, since the petitioner is already enjoying a domestic connection at the premises, comma, the present endeavor is to have a splitting of load to the detriment of the commercial interest of the CS Limited. Push up next para. On a perusal of the annexures to the writ petition, comma, it is evident that a permanent certificate of enlistment has been produced by the petitioner to show the commercial nature of the endeavor sought to be started. Pushed up that apart, comma, the nature of the business, that is a tailoring business, comma, does not require much paraphernalia or a huge commercial establishment being set up. Pushed up. In any event, comma, the CSC Limited is not the authority to decide whether a commercial establishment can be established by the petitioner. Pushed up. It may very well be that due to the lack of electricity, the establishment cannot be started by the petitioner. Pushed up. Moreover, comma, the giving of a commercial connection cannot in any manner amount to splitting of load. Pushed up. The very concept of splitting of load is that instead of seeking an enhancement, comma, several connections are sought for the purpose of distributing the electricity charges, comma, which reduces the total amount of electricity charges paid. Pushed up. Such premise cannot be valid in the event a commercial connection is sought, whereas there is an existing domestic connection, comma, since the rates of a commercial connection is more than a domestic connection and the two cannot adjust with each other to form a splitting of load. Pushed up. In any event, comma, since the respondent CSC Limited seeks to use an opposition, comma, the respondents are directed to file an affidavit in opposition within a week from date. Pushed up. Reply, if any, shall be filed within 3 days thereafter. Pushed up. The matter shall be listed for hearing on February 1, 2024 under the same heading.
Great.
On the above questions.
Grateful, Lordship.
I'm grateful.
20.
I am for the petition.
Yes.
Lordship, petitioner is a cultivator and installed a submersible pump, Lordship, and for that petitioner applied for connection, Lordship, in the year 2018. Lordship, the WBACDCL authority issued quotation in favor of the petitioner and petitioner has already deposited the same. Lordship, I have annexed.
Mr. Mukherjee, you have not given connection.
No, they have given connection, Lordship, by using temporary bamboo and etc., not by using poles and the permanent structure. And
why have you given a bamboo connection to them?
6 years has been lapsed.
What happened?
Use something else, wooden pole.
What happened? He applied for the temporary connection. We have given for 125 days.
If he applied for the permanent connection.
He has not applied for
got
permanent.
it. My specific instruction he has not.
Lordship, I have annexed
Entire
the
records.
quotation bill also. They have taken 10,516 rupees.
That is
Where is
from
that
a-
permanent connection application? Page 10.
Lordship, annexure P2, the quotation.
It is temporary.
Show me from somewhere that it's a permanent connection. It's for a permanent.
Lordship.
And same applies to you, Mr. Mukherjee. Please satisfy me from this.
But,
whether
kindly
it's-
see the record.
No, from this.
Yes, yes, yes.
Page 10. Show me where it is indicated. It's a
But
permanent.
that has been stated in my report that this is for the temporary connection.
Your
Then-
report will not do. It has to be evident from this.
For 125 days, my lord, we are taking, my lord, 10,000. That is applicable to him also, my lord, that we have taken.
Oh, the rates have been indicated
Yes,
in
yes,
this
everything.
report.
In the set page.
Apply for a permanent connection, they'll give you a permanent.
Lordship.
The petitioner apostrophe's grievance is that despite having applied for a permanent connection and a quotation having been raised and the amount paid by the petitioner, comma, no permanent electricity connection is being given to the petitioner, whose learned counsel for the WBSCDCL hands over certain documents to indicate that the quotation raised was for a temporary connection being given, which is valid for 125 days. Push up, the amount raised by way of the quotation corroborates with the rates for a temporary connection. Push up, next para. In such view of the matter, comma, WPA 28042 of 2023 is disposed of by granting liberty to the petitioner to apply in appropriate format for a permanent electricity connection. Push up, if so applied, comma, the WBSCDCL shall expeditiously process the same and subject to compliance of all formalities by the petitioner, comma, give such connection to the petitioner preferably within a fortnight from the date of compliance of formalities by the petitioner.
Great.
No less to cost as instead.
The instruction be kept in the record.
The written instruction filed today be kept on. No, the documents filed today be kept on record.
Grateful. Lordship.
21.
I appear for the writ petition.
Yes, Mr.
Yes.
The respondent number is 57.
Anyone wants to pray for adjournment in this matter?
My lord, one complaint, my lord, it is a registered society, my lord. Now, my lord, the
Why was adjournment prayed yesterday for you? You're not in court?
I was in court, I came, my lord. Kindly, my lord, take Spain, my lord, to turn page 156.
Take what?
Pain.
Pain. Page?
156, my lord.
156.
156.
156, yes.
My lord, this is a complaint, my lord, made by my learned senior friend's client, my lord, to the Register of Firms, my lord, 12/6/2023.
Yes.
My lord, the society name is Future James School, my lord.
Right.
That we, the undersigned 5 members, are the majority members out of total 8 members of the last governing body of our society, and Future James Schools duly constituted in the annual general meeting held on such and such date. It is also worth to mention here that thereafter no annual general meeting was ever held or called for either by Mr. Shomen Ghosh, ex-secretary, or Mr. Niranjan Pal, ex-president, as mentioned above in compliance to a salutary mandate as laid down in the provisions of the West Bengal Society Registration Act. Accordingly, no valid governing body of the society was also constituted after the period of 2021-2022. That it is also evident from the records of society and also from the data available in the website of the Register of Firms and Societies and Non-Trading Corporation, West Bengal, that our society, that is Future James School, has been renewed, or annual return of the society was filed before the Register of Society and Firms, West Bengal, up to the year 2021, and the last annual general meeting of our society was held on 24th March 2022, where the last governing body of society was formed and the names of the following office bearers were declared, which was valid for the financial year 2021-2022. Milord, names have been incorporated. Next, Milord, the paragraph 3. That accordingly at present there is no valid committee office bearers in our society since no annual general meeting was held for financial year 2021-2022, and accordingly no governing body was also formed and or declared for the year 2022-3 as yet. That it is also evident from records and the members registers of society that there is no existence of any other member of our society apart from the members of the last governing body as described above. The time again, we, the majority members,
of the society have approached or requested Mr. Soumen Ghosh, ex-secretary, and Mr. Niranjan Pal, ex-president, to take steps to hold annual and general meeting of the financial year 2021-2022 and also to form a valid governing body of the society for the year 2022-2023.
Basu, unless there is anything specific you want to point out,
We have complained.
So you have not held the election for 2022-23.
No, my lord, I said, my lord, my submission, my lord, then show cause was issued, my lord. I take my lord's kind attention, page 161. My lord, it is one page order, my lord, that the register of the society, my lord, he has exercised his power under section 22(1). You are hereby directed to furnish your report, replies, explanation with documents in support thereof to the complaint made via letter dated such and such, which is attached herewith within 15 days from the date of the order, failing which necessary further action as per rules should be initiated. Now, Millard, I obtained adjournment, Millard. Thereafter, I submitted my reply on 8/8/23, page 176. And Millard, personal hearing was given on 18/8/2023. Ultimately, 8/9/2023, Millard, this impugned order was passed. That is at page, Millard, 160, 180.
180, yes.
Now, Millard, the kindly turns page 181, Millard, because that is, Millard, the facts are, Millard, that has been reiterated. It was requested to order for the return filed for the year 2023 by C. Niranjan Pal in consultation with Minister.
Reading from
181, Millard, after clause 12. It was requested to order for.
Yes.
Now, the return filed for the year 2023 by the said Mr. Niranjan Pal in collusion with Mr. Soumen Ghosh be cancelled. The AGM dated 15 January 2023 be declared null and void. The membership of Mr. Niranjan Pal, Mr. Soumen Ghosh be cancelled and revoked in the light of the illegality and fraud perpetrated by them. 4, the members totaling to 8 as declared in the previous returns and forming part of the governing body be declared as the only members of the said society. Directions be issued to conduct a fair, free, democratic election for the governing body of the year such and such at the earliest within a period of 15 days from among the 8 members as admitted in the previous year's return. Now, Millard, the reason, Millard, 182, the decision, the matter of the instant complaint is of the president and secretary attempting to usurp the management of the society. There exists prima facie mismanagement and irregularities in the functioning of the society. The purported AGM dated 15 January 2023 is prima facie illegal and null and void. Yes, and void in the eyes of law. There exists no basis to accept that there are more than 8 members in the society as is otherwise admitted in Form 6 of the said members. Yes, for the year 21-22 constitutes the entire number of members of the society. Moreover, there is no compliance of the provision of Section 17(3) of the West Bengal Societies Act 1961 from the end of the secretary of the society and prior to filing of the annual return for the current year, rendering the annual accounts filed under the financial year 2023 is liable for cancellation. Therefore, AGM as said to have taken place on dated 15 January 2023 is and be declared null and void, and consequently any and all decisions said to have been taken thereto and are also declared null and void. It is further directed that AGM for the year such and such be conducted immediately without any further delay, positively within a period of 4 weeks, following regulations of the society amongst 8 members who form the governing body for the year 21-2022. Millard, I take your lordship, Millard, only, Millard, 2 paragraphs and the other 2 pages. The paragraph number 6. Millard, the paragraph number 6, page 6, Millard. The petitioners understood, Millard, I said, Millard, that the 16th and 17th that we meet, that the respondent number 8, Millard, she is misusing her powers and creating nuisance when 16th and 17th AGMs were filed before the respondent number 2 in the year 2023, which was filed after the death of the former president, late Anup Kumar Ghosh, that is my father, Millard, who had formed this society, and it was duly received by
Who is this she?
Millard, she means respondent number 8, Shoma Ghosh Pal. which is in contravention of
Please
section.
read from para 4, Mr. Ghosh.
Yes.
I can't understand from the
Yes,
middle.
that under the leadership of late Anup Kumar Ghosh, the society was functioning smoothly. But the problem arose when, due to some health and family issues, the respondent number 8 was looking after the school and the society became the manager of the school. And that is when, in the garb of taking responsibility, the respondent number 8 had started siphoning the money of the society and the school and started keeping all vital legal documents and digital signatures under her custody. The petitioners did not mind, since she was a sister of the petitioner number 1 and 4, and the members listened to her since everybody had known her for a very long time, and that is how she started manipulating situations and people. Then, my lord, kindly, sees 5, that my father, my lord, late Anup Kumar Ghosh, was managing and keeping the records of society during his lifetime. And after his days, though the petitioners could recover some of the documents, but not all. Then I said, my lord, the petitioner understood that she is missing, my lord, respondent number 8, her powers in creating nuisance when 16th and 17th AGMs were filed before the respondent number 2 in the year 2023, which was filed after the death of the former president, late Anup Ghosh, and it was duly received in the way the respondent number 2, which is in contravention of section 17 of the West Bengal Society Registration Act 1761. It is further stated that due to COVID, as the custody of all legal documents of the society was with the respondent number 8, the 16th and 17th AGM could not be held, and all the signatures of the petition number 1 and 2 in the documents submitted before the respondent number 2 are forged. The decision taken in the 16th and 17th AGM are illegal. 16th and AGM, respondent number 7 was added as a new member and was made the treasurer, and respondent number 6 was added as a new member, but till date no appointment letter of the respondent number 6 and 7 could be found, as the petitioner number 1 and 2 are unaware of such fraudulent decision. Moreover, in both the AGMs, they have only shown members who are of the private respondent faction and have suppressed the names of the petitioner or founding members. Neither the 16th AGM nor the 17th AGM and all the other returns filed before the respondent number 2 are signed, decided, or taken place at the instance of the petitioner number 1 and 2. The petitioner number 1 and 2 did not have any documents of the society with them, and on several occasions they have requested the respondent number 8 to provide with such documents, both verbally and in written, and one such letter being 8th May 2023. Due to the misdeed of the respondent number 8, the school managing committee has also gone for a toss.
You have
and
settled this?
No. Yes. The petitioner also overlooked, Millard kindly sees, then Millard 7. Millard, the order, Millard, impugned by which, Millard, the 18th general meeting was declared to be null and void, Millard. Millard, my justification, Millard. The petitioners also overlooked such misdeed and conspiracy of the respondent number 8, her faction, since Mr. Anup Kumar Ghosh had passed away shortly and conducted society's 80th AGM and 15 January 2023, after giving proper notice to all the members and filed the same before the respondent number 2. The respondent number 2 denied to receive the notice but attended the meeting, wherein they refused to sign, and when board members of the governing body were selected for the year 2022-2023 with majority. That on 25th May 2023, astonishingly, the petition number 1 received a letter from the private respondent stating that there is no existing board and an election has to be conducted, and the respondent also stated that no AGM was held after 17th AGM, and they were constantly reiterating that they are the majority and they are only 8 members instead of 15 members. In short, the respondents were trying to negate and deny the legal validity of 18th AGM held on 15 January 2023. The petitioner replied to the letter. Now, my lord, I will take my lord's kind attention to page 41. My lord, your lordship will be pleased to find that there are 15 members, my lord, in the register, my lord. In Bengali, it is a English subscription, Mashik Chada. Now, my lord, 67 is the resolution, my lord, dated 8 April 2010, and the AGM, my lord, 1/2010/11. It also, my lord, this meeting also, my lord, suggest, my lord, at least the my lord, here, my lord, only 6 members who attended the meeting.
What is the date of this?
This is, my lord, 8/4/2010. Then, my lord, page 69.
So why is
12.
it relevant?
No, relevant, my lord,
Yes.
that 8/12, my lord, this is the meeting of the dated resolution 29th April 28. This was relied upon by the registrar, my lord, when it granted, my lord, accepted, my lord, the return, my lord, pertaining to that year. Now, my lord, he says that since Form 6, my lord, for Form 4, which I have filed, it only contains 8 numbers. My lord, that is the foundation of the order, my lord, which led to believe him that the AGM, my lord, that was, my lord, held in the January 2023, my lord, was, my lord, illegal because it exceeds 8 numbers.
Not only that, Mr. Bose,
No.
you have exceeded your tenure.
No, it is not only the reasoning, my lord, as that when
was your tenure over? Under normal circumstances?
No, my lord, tenure over was not the issue. It is only issue was, my lord.
Governing body is still functioning because that is the basis of the complaint.
No, complaint, my lord, it said mismanagement. It said, my lord, the
Not
meeting was
mismanagement only. It says that you are not holding the elections.
Yes.
Although the tenure of the previous governing
No,
body
I
is
said,
over.
my lord, the election was held. They were present.
Tell me
They
this, Mr.
refused.
Basu, when is your tenure over?
No.
When was the tenure over?
My lord,
Last election was in 2021.
1 year, my lord.
So, in 2022 sometime?
Yes, my lord, the tenure
Sometime in
was.
2022.
But the election, my lord, the basis is, but the question is, my lord, I will take your lordship, only 2 provisions of the act, my lord, 3 provisions. My lord, the order, my lord, empowering him to declare, my lord, the election null and void. 22.
Societies Registration Act. Let's continue.
Yes.
Section 22.
22.
Right.
Now, my lord, power of register to call information or explanation.
Section 22.
আমাকে দিন,
No, you please continue. That will defeat the purpose of his finding. Please argue. Yes.
Where on information received, the state government is of opinion that there are circumstances suggesting that the business of a society, power of register to call for information explanation, section 22. The registrar may by written order call on a society to furnish in writing such information explanation within such time, not being less than 2 weeks from the date of receipt of the order by the society, as he may specify in the order, in connection with the affairs of the society or any documents filed by the society under this act. On receipt by the society of an order under subsection 1, it shall be the duty of the officer concerned to furnish such information or explanation. For failure to comply with the order, with an order under subsection 1, the officer in default shall be punishable with fine, which may extend to 20 or 20 rupees for every day during which the failure continues. He exercised his power, my lord, if your lordship takes main, to turn the show cause, my lord, which I had shown. My lord, he said, my lord, that if I fail to respond to his notice, my lord, he will take action as per rules. My lord, the power which he had exercised, my lord, under section 22, it only empowered, subject to, my lord, what my learned senior friends will say, and subject to what my lord will say. But for the only power, my lord, which he has under the act, my lord, or the particular section, that if there is a failure, my lord, then, my lord, the officer in default shall be punishable with fine, which may extend to 20 rupees for every day during. Then, my lord, kindly comes to 23. Whereon information received, the state government is of the opinion, my lord, I put emphasis on the term 20.
Yes.
22.
Continue.
23.
Don't get nervous, Mr. by my officer's conduct. Yes.
Whereon information received, the state government is of the opinion that there are circumstances suggesting that business of a society is being conducted with intent to defraud its creditors, members, or any other person, or that the society is guilty of mismanaging its affairs or of any fraudulent or unlawful act, the state government may appoint a competent person, a commissioner for inquiry, to investigate into the officers of the society or inspect any institution managed by the society and report on such matter as the state government may direct. Then, my lord, kindly comes to 2. It shall be the duty of every officer of the society, when so required by the commissioner of inquiry, to produce the records, any books or papers for relating the society which are in his custody, and otherwise to give to the commissioner of inquiry all assistance in connection with the investigation or inspection which is reasonably able to give.
Yes.
Oh, your lordship is rising.
I'm coming back.
Yes, yes. 10 minutes.
7.5. 7.5 to 10. ঠিক আছে। করে দিয়েছো? Yes, Mr. Vasu.
Yes,
Sorry, please.
no, minute. 23 minutes.
Yes.
I was reading minute
Right.
clause 1, where on information received, the state government is of the opinion that there are circumstances suggesting that the business of a society is being conducted with intent to defraud its creditor members or any other person, or that the society is guilty of mismanaging its affairs or any fraudulent or unlawful act. The state government may appoint a competent person as commissioner for inquiry to investigate into the affairs of the society or inspect any institution managed by the society and report on such matter as the state government may direct. It shall be the duty of every officer of the society, when so required by the commissioner of inquiry, to produce any books and papers of or relating to the society which are in the custody, and otherwise to give to the commissioner all assistance in connection with the investigation or inspection which he is reasonably able to give. A commissioner for inquiry may call upon an examination on oath any officer of the society in relation to the affairs of society, and it shall be the duty of every officer, when so called upon, to appear before the commissioner of inquiry for such examination. On the conclusion of the investigation or inspection, as the case may be, the commissioner of inquiry shall make a report to the state government on matters on which he was directed by the state government to report. For refusal to comply with the provisions of subsection 2 or subsection 3, the officer in default shall be punishable with fine which may extend to 250 rupees. On perusal of the report made by the commissioner for inquiry, the state government may give such direction as which may think fit to the society for the removal of any defects or irregularities within such time as may be specified, and on the society making any default in taking action according to such directions, the state government may direct the registrar to remove the court for dissolution of the society. If on a perusal of the report made by the commissioner for inquiry, it appears to the state government that any person has, in relation to the formation, promotion, management, or conduct of the business of the society, been guilty of any offense for which he is criminally liable, the state government may direct the prosecution of such person for the offense. The expenses not. Number section 22 is a power exercised by the secretary, registrar. Now, it only empowers him, but in case of a failure to impose a fine and otherwise mismanagement and other things, defrauding members, creditors, there must be a thorough investigation, the procedural propriety. Now, registrar has to take a decision, and he has to recourse to the journeys envisaged within the scheme of the act, more particularly reflected in 22 and 23. Now, the second question, the 28 page. 28, of your lordship's brief, yes, this is the West Bengal Society Registration Act 61, future regulations, future gyms school. Now, the admission of membership, the signatories to the members memorandum of association and the office bearers of the governing body society shall be the first members of the society. The governing body may admit to membership any persons of any caste, creed, or sex who has attained the age of 18 years and agreed in writing to be found by the memorandum of association and regulations of the society, and who, in the opinion of the GB, will be interested in the advancement of the objects of the society. Kindly comes to page 29. Clause 3 and 6, it speaks about cessation of membership. Any member shall cease to be a member on the acceptance of his resignation from membership, B, on his becoming insane or insolvent, on his conviction of any offense in connection with the formation of promotion, management, or conduct of affairs of society or a body corporate, or any offense involving moral turpitude. 6, expansion and removal. Frequent actions of any members, if it found the governing body is detrimental to the interest of its violation and the rules and regulation. These are the two things, the registrar, while passing the order, did not take into account, the regulations, which he has approved at the time of admission, because he has decided, in his journey, that these persons were not members, because form number 4, which I have filled up, it, does not, it was commensurating or matching, with the membership list. So, we must be confined to the 8 members, whose names were, incorporated in the form 4. So, that was,
Mr. Basu, is it, aren't these provisions regarding cessation of membership of the society itself?
Yes, because cessation of...
Here he has not seized the society.
No, he has not so. But he said, the members my lord, who were allegedly present in the meeting, my lord. The meeting was held, my lord, null and void. My lord, one of the contentions, my lord, which weighed with him, my lord, during the course of, my lord, hearing, that these members were not, my lord, named in the form 4, which were filled up by the society. So, my lord, this was, my lord, absolutely, according to him, my lord, illegal, and that was one of the reasons, my lord, for which, my lord, the meetings were declared null and void. And, my lord, the show cause, my lord, which he had given, my lord, if you're 161, my lord, 161, he said that I have to, my lord, respond to this show cause because it is a power under section 22(1), which I read for, my lord. You are hereby directed to furnish your report, reply, explanation with documents in support thereof to the complainant made with the dated such and such by such and such. Otherwise, my lord, lastly, he said, within 15 days of the release, failing which necessary further action as per rules should be initiated. My lord, in my
So he specifically invoked the power of 22.
22, number one. Number two, my lord, this particular sentence, my lord, in the penultimate paragraph, it takes us nowhere because it is vague, my lord. He was not sure about which action he has to take, my lord, under the, now, my lord, I am armed with the judgment of the Honorable Supreme Court, my lord, reported in 2021 to SCC page 551, my lord, UMC Technologies Private Limited versus Food Corporation of India. My lord, the ratio of this case, my lord, I will hand up. 2021 to SCC page 551. I will rely on, my lord, 21, 20, paragraph 21, 24, 25. It is just paragraph 2. My lord, the law as declared by the Honorable Supreme Court, my lord, show cause notice to constitute the valid basis of a blacklisting order, my lord, the other person was blacklisted. Such notice must spell out clearly, or its content be such that it can be clearly inferred therefrom that there is an intention on the part of the issuer of the notice to blacklist the noticee. Such a clear notice is essential for ensuring that the person against whom the penalty of blacklisting is intended to be imposed has an adequate, informed,
Things
and
have to be clear in the show cause notice. One is what is the exact offense.
exact
Secondly, what is the
offense,
penalty?
So, in absence of this, my lord, this notice cannot be taken care of, number one. And if this notice is the foundation of the order, my lord, which was passed, my lord, on 8 September 22, that must go is unsustainable in law. Now, my lord, the one of the grievances of the the private respondent while addressing, my lord, my client, Mr. Shomen Ghosh, kindly takes pain, my lord, to turn page 167. Has the lordship got it? 167.
Yes.
Now, my lord, it is much, paragraph 4, it is much more astonishing that though you allegedly claimed yourself as a secretary of the society, but you do not know even the office address of a society, that is Future Gem School. With utter surprise, we have noticed that you have purposefully mentioned in the said letter dated 12 July 2023 that society's office address is Machandi Market, Borakachari, society duly approved by the Register of Farm Society and Non-Trading Corporation of West Bengal. Now, my lord, if your lordship comes back, my lord, at page 28 once again, my lord, 23, my lord, sorry, 23.
Yes.
Yes, the registered, clause 2, my lord, the registered office of the society will be situated at Machondi Market, Borokachari Road, such and such. This is same. So, my lord, the paragraph 4 of the complaint, my lord, which says, I was not aware, I do not know even the address of the society, my lord. This also shows, my lord, that the entire she has withdrawn her senses, my lord, from the, while writing this letter.
She had?
Sorry.
No, I couldn't follow you. Sorry. She had?
No.
Please repeat what you are saying, Mr. Bose. The court is asking you what you said.
No, she had withdrawn her sense, my lord. No, my lord, facts, my lord, which they ignored. It does not mean, my lord, facts cease to exist. The society register, my lord, is under, my lord, obligation to, my lord, to
do this to
travel.
all courts. You do this to all courts or specific.
I will forget everything. I have forgotten.
I have forgotten everything after hearing your English.
No, my lord. Kindly, my lord. Kindly, my lord. Again, my lord, the one, I think, my lord, it will be a tiring repetition. The show cause, my lord, I have shown, page 161.
So one is section 22 power.
power. Section
That was-
23, my lord, is an elaborate
Right.
power that in the event, my lord,
That was
if any-
never invoked. 22
never
was
invoked,
invoked.
because if he comes to a decision that there is an element of mismanagement, my lord, then he has to refer to the commission of inquiry. It is the state government, my lord, the specific journey has been envisaged. If the show cause, the foundation of show cause, my lord, goes, then there nothing remains, my lord, because otherwise, my lord, all subsequent actions, even the order, my lord, the impugned, that is 8 September 2022, my lord, is unsustainable in law. And my lord, the registrar at best, because he cannot say now that I have other powers which I derive from the other provisions of law, then, my lord, the power which he had exercised while issuing the so cause under section 22 subsection 1 of the act, my lord, is redundant. He cannot say, my lord, on the one hand that I exercised my power under section 22(1), and if 22(1) is satisfied, at best I am closed with the power to exercise my power under 23, 1, 2, 3, 4, 5.
23 is state government.
State government,
Not the registrar.
not the registrar.
So he can advise refer it to the
adverse
state.
refer to. So all other actions, my lord. So declaration which he has said, my lord, that is absolutely, my lord, he has traveled beyond the power. So this action is ultra virus, my lord. That is my respectful submission.
And Mr. Basu, please also deal with this. Suppose if it is argued by Mr. Dhot that the quotation of the section was wrong in the show cause notice, I mean, dissolution could be there under the subsequent provisions of the act by the registrar.
Yes, 24.
24,
Where, yes, 24. A society may be dissolved if the votes of 3/4 members it passes a resolution
24 is not applicable.
applicable. 25, my lord, the resolution by
registrar
court. The
26.
court
26. 26.
Yes, wherein the opinion of the registrar, there are reasonable grounds to believe that society is not managing its affair properly or is not functioning, he shall send to the society at his registered office a notice.
But this was not the notice.
Not the notice. And if no cause is shown, that means he has to say, he has to express his mind.
Yes, yes.
The foundation is bad.
Right. Fair. Yes.
But, first, the little context, then I will make my best point and thereafter my otherwise submission. The context is, well, as long as the father was alive, it's basically a fight between the brothers. Mr. Bose is representing them, and the sister, who is the respondent number 8, and who are with the sister. The father had business.
You are for which author?
I am for, my lord, the respondent number 3 to 7, who are in this case,
Complainants. The complainants.
who made the complaints, who are also members of the society.
Yes.
The father had business. Father also had a school of up to class 12. During the lifetime of the father, decided all the business should go to the brother, and the daughter should look after the school. The daughter here is the respondent number 8, and there is a particular post in the CBSE is the manager, who is the administrative head. She is the daughter, and the school is running since 2009. And the moment the father died, the brothers wanted to, if I can use the word, take hold of the control of this society also. Well, that's the context. Now my best point, according to me. Student, kindly take paragraph 35 of the plaint. I was expecting this for Mr. Bose to say. Kindly take paragraph 35. There is already a restraint order by the Granite Civil Court on the petitioners. First, kindly take paragraph 35. I just read that in the meantime, the defendant started.
It was an ex parte order.
Yes, because it was an ad interim, but that was on in December. In fact, he is challenging the order of September. Today we are in the month of January.
But he could not have been in the know of this also. May not have known.
I don't have that instructions, but possibly till today he is of the knowing. But I can't
Anyway,
say confident.
Para
And Lord
35.
Shiva, kindly take the civil court's order based on paragraph 35. Now, kindly take 20th December 23, the ordering portion. The defendants.
Milord, Mr. Thor is correct, Milord. My client is aware of this, Milord, subsequently, Milord.
Thank you for the honesty. Thank you for the honesty.
Oh.
Yes.
What you said. So,
না আমি ক্লান্তি জিজ্ঞেস করলাম উনি বলেন আমি জানি জেনেছি পরে
so Lord Shiva, kindly say.
আমি দেখবো আমি জানি না তাহলে আমি একটা দিন
No, he'll read out, you'll hear with me.
I'm just saying in a short order. The defendants and their main and agents are hereby restrained from causing any disturbance or obstructions in the operations of the future James School. That the daughter was running. In fact, my lord, what they want They want to stop the school, they want to have a constructions, they want to promote that. But that is nothing here and there. I may not be able to substantiate that, but I realize this is the difficulty. And I also realize some amount of vulnerability. So I went.
But this, Mr. Dhot, doesn't have any direct nexus with the present dispute. Because here you complained, and on that, the new AG has to direct it.
Now I've answered that.
Yes.
Well, there is a statutory form, Form 6. There is a requirement in the Form 6 to declare the total number of members.
Yes.
The question is why there is a requirement? Because the quorum can be found out by the register. I don't say the register has too much of adjudicatory power, but all I say, the statutory requirement of declaration of the total numbers are there. In that light of statute, Lordship, kindly have a look at page 111. This is his document, this is his signature. Number of members on the date of the annual general meeting. It's not present. It's on that day. What is the total number of members? Page 111.
Yes.
8. Consistently. That is for 22. Lordship, and this is signed by petitioner. Kindly see page 109. Again 8. In fact, from the father, it is always 8. Now, after the father is no more, suddenly, in our absence, what he does, he takes into account some persons and makes it a 14. And he writes that none of us are present, and now he wants to take decisions on that.
These are not members of the governing body. These are the members of the society itself.
I said the members of the society in total 8.
Yes, but might have been others were inducted in the meantime, other 6.
Well, then they have to show that there is a resolution by which they have been inducted.
Very well.
I say that just the year before, the register gets the information. Lordship, may kindly look at this. The register is not supposed to look into in reviewing inquiry, but he is going to receive a Form 6 where the total number of members on that particular date.
Form 6 is an annual affair or one time?
Well, Form 6 is annual.
Has to be, because otherwise.
Yes. Because there are 2 documents have to be submitted. One is the resolution of the AGM. That will show the total number of present in the AGM and whatever discussions are in the AGM. And number 2 is the total number of members.
And this Form 6 was of 24th of March, 22.
Yes. Well, there are page 111 and page 109. And both signed by the petitioners. So I would say, my lord, they are not in clean hand also. In any event, there is a civil court's order restraining them. If Lordship feels that there are other substantial point of 22 or is there, Lordship may pick up the matter, then I have to use my affidavit, but Lordship may not stay any of the order.
But Mr. Thor, the ground Mr. Bose took, 22, this is palpable lack of jurisdiction on the part of the register. Under which provision could the register do it? Why shouldn't there be a stay?
What the register has done.
I mean, this can be stayed without any conflict with this injunction order.
I have seen the order of the registers. I am not going to argue that the register has the power to adjudicate.
Then the entire premise goes.
Now, yes, it is. The time is also a very factor in a litigation. I could have understood that in the month of September, he is aggrieved. He is before your lordship then and there. But today, kindly see my situation. There is an order in September in my favor. Now, rightly, wrongly, he did not take the question of jurisdiction before the register also. I know there is a further point that point can be taken, but it's a fact that he has never taken.
No, register directed a new AGM to be held. Was that held?
No, it is yet to be held.
Then what is the? There will be no.
The only point is the register has said that
yes,
hold it with 8 members because I had the return that previous year 8 members.
But this is palpably Dihor's jurisdiction, Mr. Why shouldn't it be stayed? Please argue on that. Whatever may be, I mean, maybe on the merits, whatever may be there.
May I say this?
If the register could not do this,
I understand.
I can, if you say so, I can set aside this order right now. But if you want affidavits, I'll have to stay.
No, I understand that. Well, I was only thinking of protection of my clients, which are possible in the garb of law. I am not also seeking anything that beyond the scope of the law. I understand the difficulty to justify the power under 22. That I do understand. But at the same time, Lordship may kindly consider that today also in the light of paragraph 35 and there is a restraint order. On what Lordship may do this. May this
Yes.
proposal, if Lordship finds that it is otherwise reasonable on my part to pray, Lordship may declare that the order of the register is a lack of jurisdiction under 22. Therefore, Lordship may set aside that. But what I am apprehensive is that register set aside and the resolution of 15th of January 23 in September 23. Now, if
I can clarify in the order, Mr. Thor, that I have not touched the merits on which the register dismissed. Subject to what Mr. Bose says, of course, and I'll come back to him. But only on the ground of jurisdiction, lack of jurisdiction, I'll set it aside. It will be open to whatever appropriate authority there is. You can make your complaints before the state government, for example, can take steps, or registrar under 26 can take steps, or court can take steps.
In addition to that, I would be only praying if your Lordship kindly also take note in the Lordship's order that there is also a civil court. Well, I can understand the register.
This order, civil court's order.
Yes.
I have to, and I have to clarify that this setting aside will not affect this in any manner. It cannot. In fact, that has no nexus. It is proverbially neither here nor there. I mean, this order does not have any.
When I read it, I found that also that register lacks jurisdiction to adjudicate. That is also my legal finding. So I will be failing.
If it is set aside on the ground of lack of jurisdiction, Mr. Thor, then the other points, I cannot go into the other points, even if I like to.
No, other points I do not want your Lordship.
And I'll have to clarify that.
Yes, my Lord, I am only seeking a clarification of Lordship on this.
Civil court's
Firstly,
order.
so that the whatever benefits that I am getting from the civil, because in the civil court, my Lord, I have also taken the point of 15th of January. I was not made aware of that, my Lord, the meeting itself, and they recorded that we were present and there is no signature. Therefore, they record.
I'll only set it aside on the ground of lack of jurisdiction and not touch the merits. This will not, any observation made herein will not touch the merits of the suit or the order. Because I cannot do that in any.
Only thing is this, once Lordship does that, my only apprehension is that they would be interpreting that total number of members becomes 14.
How?
Irrespective of the return being filed 8.
No, we are not touching the merits of that. I do not validate what has been invalidated by the registrar.
Well, then
if it is for lack of jurisdiction, Mr. Dhar, then everything it's entirely vitiated.
Then Lordship, kindly, because my only
I'll clarify that I am setting it aside only on the ground of lack of jurisdiction, not touching the merits agitated before the registrar or the merits of the matter, or touch. I cannot touch the. All of these are I am speaking within law, Mr. Dhar. I mean, I cannot touch the merits of the suit or the order.
I understand that. My only humble prayer before your Lordship is that so that this running of the school from 2009, because if this suddenly 14% come, my Lord, the school will go away. That's my apprehension.
Definitely.
So, and my situation is that something has come in my favor. I understand the vulnerability, so that's why I have gone to the civil court, and there is an order of the civil court in my favor.
That is the risk of getting a bad order in your favor.
That is the risk of getting a bad order. But this time, my Lord, Lordship would be kindly protect that interest of me. Only that part.
I'll not hold either way on the merits, Mr. Dhar. 814, I cannot go into that.
I
can record the argument.
I want a neutral view on that matter, in a sense, in the judgment of your Lordships, that so that they do not take the point that Lordship has confirmed the membership being 14, because I will agitate much this much. Otherwise,
no.
May I respond without only 2 minutes?
Respondent number 8 is the
manager of the school, the daughter.
But here the name of the society is Future Gen School.
Right.
And the name of the school is Future Gen Academy. So sometimes it becomes confusing.
Yes.
I being the respondent number 8 is the manager of the school. And no way connected with the society. But my father basically was the founder of the school as well as the.
You are the lady.
I'm the lady.
The lady whom Mr. Dhar was speaking of.
Mr. Dhar was speaking
No,
of.
yes. I was appearing for the members The majority members who are supporting the lady.
Mr.
And I
Bose was also
sitting
speaking of the lady. Yes.
But I was that way. But my father founded these two organizations. Basically, school, it was his intention to found a school.
Right.
And since the school can be affiliated by the CBSE, if it is affiliated under the society has also. No, my lord, I have been inducted as an employee, as a manager of the school by my father itself. There was no dispute so long my father was alive. Now, as and when my father died, my lord,
Yes.
well, my brothers, who was the petitioner number 1 and petitioner number 4,
Yes.
but their only intention is to grab the school, oust me, and induct their wives in place of me. Since I am the daughter, I do not have any authority over my father's property or whatever it is institution or. So that is the background. My only difficulty is
You are already enjoying an order from the civil court.
that's right.
That remains intact.
Apprehension is, my lord, if you lordship set aside the register order, then the AGM held in the month of January, that is 15 January 2023, will be held good. And in that AGM, my lord, they have basically hold this AGM, my lord, depriving without giving any notice to the majority members of the society, those who are in the governing body in the last year.
I'm telling you this. Writ court is not the forum which can decide on the validity of the AGM. And neither am I deciding that. Whatever fallout happens, if I set aside the order, will happen. Despite your apprehension or without your apprehension. I mean, even if I set aside an order, suppose by a particular order, the AGM has been held invalid. The moment that order is set aside on the ground of jurisdiction only, it does not mean automatically that that is validated or invalidated. Either way, that AGM has happened, it is a part of history, it remains a part of history factually. Whether it's invalid or valid, now you have to approach the appropriate forum for holding it to be invalid.
That is there.
I cannot either validate or invalidate it. It has happened. That is a factual part of history. I mean, it remains.
Seeking protection, my lord, since that AGM was questioned.
No.
In summer.
No.
Now your lordship.
I am holding that the AGM does not have, that this authority did not have jurisdiction, and I'll hold that that is invalid.
Let it be a status quo as on date.
No, whatever order you have got from the no.
The AGM, they will not oust me illegally without having the consent of the majority member.
They take advantage. You already have your injunction. You can show the injunction order on their face. You already have an injunction from a proper civil court. Why do you need the interference of a writ court's findings?
Kindly clarify that only, but this is my apprehension. This is my.
I've already forgotten what I have to clarify. The list of my clarification. Yes, Mr. Bose, 2 minutes.
Yes,
2.5, 2 for Mr. Dhar and half for.
Milord, Mr. Shaha's milord anxiety or the agonizing spasms, milord, it takes us nowhere.
I'm
Milord,
not on
sir,
spasms.
milord,
What
kindly
is your
only
plan?
1 minute.
Let us
Milord,
not be on spasms.
he says, milord, if the court finds that there is an element of illegality, court will not think about consequence. So his prayer for clarification, milord, is absolutely, milord, irrelevant. Second, milord, Mr. Dhar has said that 109 to 111. I have specific instruction, milord, these signatures, this has been forced, and paragraph 6, milord, 109 and 104. And milord, milord, I have 2 documents just now, milord, my client has handed over. I can today, milord, since your lordship is going to set aside the order, milord, of the register, milord, the 16th and 17th AGM, milord, it contains the phone number of Mr. Shaha's client, Mr. Dhar's client, milord. If I have, milord, filed a return 16th and 17th, milord, which they said to be valid, which I said, milord, in paragraph 6 and 7, that they forged my signature, milord, it is not my signature 109 to 112, 11. And milord, the AGM 16th and 17th AGM, milord, it contains the phone number of the respondent.
So what?
As the applicant. So, milord, if I was in the charge of, milord, the affair 16th and 17th, they are question 18th.
What would the phone numbers?
The phone number, because if I have filled up, I would have given my phone number.
You expect me to decide on the phone numbers?
No, I am not saying. I'm saying that 109 to 111, she said that it was my signature. I said no.
So what would the phone numbers? How would the phone numbers help?
Phone number, I said, milord, because this applicant, this is the applicant's basic information which I was required to file. 16th and 17th
Phone numbers.
No, someone has to, milord, the person concerned, the applicant has to give.
What would they do with the phone number? Call you and say that you have.
No, call for the purpose of communication.
How are you?
No, 16th and 17th meeting are specifically stated, my lord, these meetings, the signatures that were submitted to the authority, that was not my signature. And 109 to 11 also that. And my lord, so if it lacks of jurisdiction, my lord, then it goes to the root of the matter. So other clarifications, other consequence, my lord, that is absolutely unnecessary. That is my respectful submission.
Mr. Dhar, I am not directing affidavits in. That would not inure to benefit of either party. In view of all the material documents being annexed to the writ petition and arguments having been advanced on all issues, comma, affidavits are not being directed in the matter, full stop, it is, comma, however, comma, deemed that none of the allegations made in the writ petition are admitted by any of the respondents. Full stop. The gamut of the present dispute is the order
Page 80.
Yes, thank
Sorry,
you.
180.
Order dated September 8, 2023, passed by the Registrar of Firms, comma, Societies and Non-Trading Corporations, West Bengal, whereby the AGM of the concerned society, that is the Future Gems Society, Future Gems Society.
School
No. You said there is a distinction between school and society.
The name of the society is Future Gems School.
Namely, the Future Gems School was declared to be null and void, and consequentially, any and or all decisions said to have been taken thereto were also declared null and void. Full stop. Consequentially, comma, it was directed that an AGM for the year 2021-22 be conducted in respect of the said society immediately without any further delay, positively within a period of 4 weeks, following regulations of the society among the 8 members who formed the governing body for the year 2021-2022. Which of learned counsel for the petitioner contends that the said order was passed pursuant to a purported show cause notice dated June 15, 2023, annexed at page 161 of the writ petition, which was admittedly issued under section 22 within bracket 1 of the West Bengal Societies Registration Act, 1961, push up by placing reliance on the said provision, comma, it is argued that it was dehors the powers of the registrar to hold an AGM null and void and direct fresh AGM to be held. Full stop. The sole scope of the powers vested on the registrar under section 22, comma, it is argued, comma, was calling for information or explanation pertaining to the affairs of the society. Full stop. Under subsection 3 of section 22, comma, a failure to comply with an order under subsection 1 of section 22 would at best, at the worst, be attended by a punishment with fine which may extend to 20 rupees for every day during which the failure continues and no further. Full stop. Simultaneously placing section 23 of the said act, comma, learned counsel argues that the appropriate provision for investigation into the affairs of a society are provided under the said section, comma, which is to be done by the state government and not the registrar under the said act. Full stop. As such, comma, the petitioner challenges the impugned order and the show cause notice, which was the genesis of the same, on the ground of lack of jurisdiction on the part of the registrar. Full stop. Next para. It is further argued that from the concerned minutes of the meetings of the society, comma, all particulars of the members were very much available. Full stop. As such, comma, the finding of the registrar in the impugned order that there were only 8 members was palpably bad in law and in fact. Full stop. Next para. It is argued that the show cause notice ought to have clearly indicated the penal action contemplated for non-compliance of the same, as well as the exact offences committed by the petitioner, comma, which was not disclosed in the said notice. Full stop. In support of such contention, comma, learned counsel places reliance on UMC Technologies Private Limited versus FCI and another, reported at 2021 2 SCC 551. Full stop. Next para. Learned senior counsel appearing for respondent numbers 3 to 7, comma, who were the complainants before the registrar, comma, argues that in terms of Form 6, comma, it was consistently maintained by the society that the number of members were 8, comma, as rightly held by the registrar. Full stop. There is nothing on record, comma, it is argued, comma, to show as to what prompted the petitioner from showing the number of members to be 14. Full stop. No proof of induction of additional members have been placed before this court, comma, it is argued. Full stop. In support of his contention, comma, learned senior counsel places reliance on the filing of annual and other returns by the society under Form 6 of the extant regulations, which are annexed to the present writ petition. Push up. Next para. Learned senior counsel then contends that a suit has been filed by the respondent numbers 3 to 7. By the respondent numbers 3 to 7, where the petitioner is inter alia one of the defendants. Full stop. In view of the specific allegations made in particular in paragraph number 35 of the plaint thereof, comma, an injunction order was passed in favor of the plaintiffs, whereby the defendants, comma, including the petitioner and their men and agents, were restrained from causing any disturbance of, or obstruction in the operation of Future James School and Future James Academy, and also from alienating or otherwise creating any third-party interest over the scheduled property. Pushed up. Next para, it is argued that the present endeavor of the petitioner is to frustrate the order of the civil court, comma, which cannot be prayed before a writ court. Pushed up. Next para, the apprehension of the respondent numbers 3 to 7 is primarily that the smooth functioning of the school, comma, which is going on in due adherence to law, comma, would be hampered in the event the order of the registrar is disturbed. Push up. Next para, learned counsel appearing for the respondent number 8 also submits that the order passed by the registrar was passed in accordance with law and keeping in view the actual factual scenario in the said society. Pushed up. It is reiterated that the number of members is 8. Pushed up. In the event any order disturbing the order of the registrar is passed, comma, it is apprehended by the respondent number 8 also that the functioning of the school may be adversely affected. Pushed up. Next para. Upon hearing learned counsel for the parties, comma, it is evident that the injunction order obtained in connection with the civil suit by the respondent numbers 3 to 7 has no direct connection with the dispute involved in the present matter. Full stop. The limited conspectus of the present writ petition is the legality and jurisdiction of the registrar under the 1961 Act to pass the said order, comma, in terms of the show cause notice dated June 15, 2023. Full stop. Next para. Ex facie, comma, the petitioner is justified in arguing that the limited powers vested on the registrar under section 22 of the 1961 Act can at best be visited with imposition of a penalty of 20 rupees for each day of infraction. Full stop. Subsection 1 of section 22 provides that the registrar may by written order call on a society to furnish in writing such information or explanation within a particular time as he may specify in connection with the affairs of the society or any documents filed by the society under the 1961 Act. Full stop. However, there is nothing in the four corners of the statute which provides any sanction or measure in case of non-compliance of such direction, apart from the imposition of fine in subsection 3 thereof. Full stop. Hence, since the genesis of the impugned order passed by the registrar on September 8, 2023 was the show cause notice dated June 15, 2023, which was mentioned to have been issued under section 22 of the 1961 Act, the consequence which fell from the issuance of the notice is disproportionate with the powers vested in the registrar under section 22. First up, since section 22 itself does not contemplate to confer any power on the registrar to intrude into the affairs of the functioning of the society, let alone set aside the hold that an AGM held in the society is null and void and direct fresh AGM to be held, the consequential order dated September 8, 2023 is bad in law. Full stop. Next para. Learned counsel for the petitioner is also justified in relying upon UMC Technologies Supra, since it is well settled law that a show cause notice, to be valid, has to clearly disclose two components, hyphen. First, the exact offenses which are alleged to have been committed by the accused person, and secondly, the exact measures or sanction which will be taken against the addressee of the show cause notice in the event the show cause is not satisfactorily replied to. Full stop. None of such ingredients are present in the impugned show cause dated June 15, 2023, which vitiates the consequential order dated September 8, 2023 as well. Full stop. Next para. Insofar as the apprehension of the respondents that any order passed in the present writ petition might affect the functioning of the society and or have a material bearing on the suit or the order passed therein, such apprehension is baseless, since the limited gamut of the present writ petition as indicated above is the veracity of the show cause notice issued by the registrar and the consequential order passed by the registrar. Full stop. Next para. In the event this court either affirms the order of the registrar or sets it aside, the said act itself would not either validate or invalidate the actions which were set aside by the registrar. Full stop. Such consideration will be independently taken care of in the civil suit pending between the parties. Full stop. In fact, all parties herein may approach the appropriate forum for taking action against each other in the event there is perceived contravention of any provisions of the 1961 Act or any irregularity or illegality in the functioning of any of the parties with regard to the affairs of the society. Full stop. This court does not touch upon the merits of the allegations and counter allegations made by the parties against each other or which are sub judice before the civil court and or which were dealt with by the registrar. Full stop. Next para. Since in the opinion of this court, as held above, the registrar did not have jurisdiction at all to go into the issues, the findings rendered by the registrar on all the issues before it automatically go and are neither validated or invalidated hereby. Full stop. In view of the above discussions, WPA 28049 of 2023 is allowed on contest, thereby setting aside the show cause notice dated June 15, 2023 annexed at page 161 of the writ petition, as well as quashing the order dated September 8, 2023 annexed at pages 180 to 182 of the writ petition passed by the registrar on the ground that the registrar did not have jurisdiction or authority in law to pass the said order. Full stop. No rest to cause certain certified copies.
Deeply obligement.
বইটা বোধহয় ওদের। Mr. Basu, you also have a book, 61 Act in your home, or dependent entirely on your juniors like me? Yes, Mr. Kudu.
My lord, I'm for the petition.
Yes.
Well, this is, quotation has not been issued, my lord. Everything is complete. Earlier temporary connection was given.
Doctor, I am asking for the respondent number one. Doctor, I am praying for not mistake on the ground of the learned counsel appearing on behalf of WBACDCL.
Who?
Mr. Stovik Ray. He is out of town. I am praying.
This is
for
an
not-
innocuous matter. You should take instruction.
My lord, I am.
Moreover, Mr. Kutubuddin is appearing. How dare you ask for time? He is an authority on this subject. Yes, Mr. Kutubuddin, what do you say?
My lord, take to instruction, my lord.
On the prayer of the WBSCTCL, the matter is adjourned for the week and shall next be listed on January 22.
Great.
22. Affidavit of service filed today be kept on.
Great.
हाँ सेमी ठीक है इस 2 मिनट है
23.
Yes. You are an authority in the rest of the matters, apart from submersible pump.
My lord, there are a total of 4 matters.
Copies have been served. I hope it has not been served.
My lord, we've served, my lord. My lord, I will not start, my lord, by saying, my lord, your lordship may take the trouble of turning the page. My lord, that's when I walked in.
That was pain.
Yes. Yes, pain.
That's
correct.
pain specific. Trouble is all right. Pain is pain specific.
Yes. So, my lord, there are, my lord, 4 matters. My lord,
This is the first one.
my lord, this is the first one. My lord, then, my lord, which is Bank of India. Then, my lord, we have, my lord,
Bank of Baroda.
Bank of Baroda.
Yes.
This is Bank of India, this item.
And Union Bank of India and SIDB.
Yes.
Items gulo bolo.
Bank of, there are different banks.
Yes, different banks, my lord. Basically, my lord, it's the same, my lord, item 23, 28, 29 and 34.
Mr. Mehta, are you appearing in all the matters?
No, my lord, I am appearing in Bank of Baroda matter.
Which is that item?
I beg to appear.
All right. Yes. Mr.
My lord,
Dewan is
that's
there in the other
28.
matters? Yes.
My lord,
Yes, but I am appearing in the rest of the 3 matters.
Very well. Very well. Then all are represented.
yes. Now, my lord, here, my lord, the point, my lord, is really, my lord, short.
Yes.
My lord, the writ petitioner, my lord, used to be, my lord, a director of 2 companies. My lord, one, my lord, is Srei Infrastructure Finance Limited, which, my lord, has been referred to right through as SFIL. And, my lord, Srei Equipment Finance Limited, referred to as SEFL. Now, my lord, the Reserve Bank of India, my lord, is the regulatory authority as far as, my lord, these entities are concerned. My lord, being, my lord, NBFCs or, my lord, non-banking financial companies. My lord, as part of a regulatory measure, my lord, it superseded the board of directors, my lord, of both these companies. And, my lord, appointed, my lord, an administrator as far back, my lord, as on 1st of October 2021.
So US superseded.
Correct. My lord, the writ petitioner, who was, my lord, one of the directors, my lord, was, my lord, superseded. And, my lord, corporate insolvency process, my lord, of both these entities, my lord, were, my lord, started. My lord, before, my lord, the adjudicating authority, which is the National Company Law Tribunal, my lord, Kolkata in this case. And, my lord, by separate orders, dated 8th of October 2021, my lord, if I may use the expression, CIRP process, my lord, commenced because, my lord, the petitions, my lord, were amended. Now, my lord, during the course of the proceedings, it came to, my lord, our knowledge that, my lord, one KPMG had been appointed, my lord, by the consortium of bankers of, my lord, both these, my lord, entities to conduct a forensic audit, my lord, of, my lord, the loan accounts of, my lord, both these entities on 13th of April 2021.
That was in the CIRP.
My lord, while CIRP was on, my lord, this was, my lord, at the lenders meeting, my lord, a decision was taken, my lord, to conduct, my lord, a forensic audit. Now, my lord, on the ground, my lord, that this could not be done while a CIRP process was, my lord, in place, my lord, we filed an application before, my lord, the adjudicating authority, seeking a restraint, my lord, on KPMG from proceeding, my lord, with this, my lord, forensic audit. Now, my lord, in this matter, my lord, ultimately, my lord, we did not succeed because, my lord, the ground given, my lord, by, my lord, the adjudicating authority was that the appointment was, my lord, under, my lord, the master directions issued, my lord, by the Reserve Bank of India. Therefore, my lord, it would have no jurisdiction, my lord, to interdict, my lord, the process. This is, my lord, really, my lord, the background. Now what happens, my lord, is on the basis of this forensic audit, my lord, without, my lord, hearing, my lord, any of the entities, including, my lord, the writ petitioner, my lord, orders were passed declaring, my lord, the account, my lord, of, my lord, the two, my lord, corporate entities as, my lord, fraud accounts under, my lord, the master circular. Now, my lord, your lordships, my lord, are aware, my lord, of, my lord, the judgment, my lord, in, my lord, the State Bank of India case, my lord, which was, my lord, delivered, my lord, sometime, my lord, middle of, my lord, 2023. My lord, that, my lord, it said, my lord, that this declaration of, my lord, an account, my lord, as a fraud, my lord, cannot be done straight away. It was, my lord, a measure akin, my lord, to blacklisting and, my lord, akin to, my lord, declaration of an entity as a willful defaulter. So, my lord, a personal hearing, my lord, had to be given. My lord, on that basis, my lord, a challenge, my lord, to, my lord, this adjudication of fraud account, my lord, was, my lord, allowed, my lord, by the Delhi High Court on 12th of May, 2023.
But Mr. Mukherjee, while during pendency of a CIRP, I mean, what locus standi does the director have for a hearing? I mean, are you in any way?
No, now, my lord, all this is over. Right. Now, my lord, after the Supreme Court judgment, yes, my lord, I've just given your lordship, this is the background. Right. Now, my lord, all this, my lord, the story is over now, my lord. Yes. Now, my lord, apropos, my lord, CIRP process, etc. The present writ petition, my lord, challenges, my lord, a show cause notice, which has been issued, my lord, after, my lord, the Supreme Court judgment. Now, my lord,
CIRP is still on.
It's been resolved. My lord, it's been resolved. My lord, the resolution applicant, my lord, has, my lord,
show cause notice against you.
Yes.
And this is regarding director's identification or what?
No, my lord. Now, correct. Now, my lord, what is important is, my lord, the show cause notice, if your lordships, my lord, have a look at, my lord, may I trouble your lordships, my lord, with, my lord, item number, my lord, that's the one, my lord, which I had marked if I'd known, my lord.
Please just give me the writ petition number.
Yes, so my lord, the writ petition number, my lord, is 236 of 2024. My lord, it's the least bulky, which is why I had chosen that. My lord, I didn't know, my lord, that the learned Solicitor General, my lord, was in, my lord, a previous matter. I would have, my lord, then
you would have chosen the most bulky.
Yes. My lord, item 30.
It does not depend on the weight of the council.
No, not at all.
But my lord,
it would have been convenient for my learned friend, my lord. Because he, my lord, I see, my lord, the way, my lord, he is having to function, my lord, is, my lord, I think 20 times more, my lord, than in terms of effort, my lord. That
so Diwan is physically more sleek, so the
yes, my lord,
slimmer one will do.
Yeah.
Yes.
Now, my lord, if your lordships, my lord, take, my lord, the, my lord, show cause notice once.
So this is WPA 236.
236, my lord.
Right.
Show cause notice, my lord, in two other cases are identical. And, my lord, the basis of the show cause notice, yes, my lord, is, my lord, the forensic audit report. My lord, that is the only annexure to the show cause notice. And my lord, that is, my lord, formed, my lord, the basis. And the forensic audit report, which is an annexure to the show cause, my lord, relies on, my lord, apart from, my lord, information in the public domain, various other documents, my lord, which are not, my lord, which have not been annexed to the show cause notice. I'll tell your lordships, my lord, very briefly, my lord, what my lord, two, my lord, points. There were 30 points taken, my lord, but I think, my lord, two focus points are, my lord, the show cause notice, and my lord, is being issued, my lord, after, my lord, the Supreme Court direction. So, my lord, an opportunity of hearing has to be given. My endeavor before your lordships would be first, my lord, to demonstrate that, my lord, the show cause notice, in effect, my lord, does not, my lord, provide for, my lord, an effective opportunity to show cause. And, my lord, I'll tell your lordships why I say that. My lord, is, my lord, the documents, my lord, which have been relied on, my lord, are not part, my lord, of the show cause notice. And, my lord, they are fully aware that, my lord, the writ petitioner before your lordships, from 1st of October 2021, when the administrator took over, has no access, my lord, to, my lord, these, my lord, documents. And in fact, a request made to the administrator, my lord, during the pendency of the CIRP process, seeking, my lord, particulars, where all the banks were also there, my lord, as parties, my lord, has, though a direction was issued, my lord, by the adjudicating authority to make over these documents to us, has not been made over. So, my lord, there is really, my lord, no, my lord, opportunity to, my lord, effectively show cause. Second, my lord, your lordships will find, my lord, the forensic audit report, my lord, at the end of the day, my lord, is an opinion. Is an opinion based on, my lord, certain facts. My lord, any, my lord, expert agency, whenever they are engaged, my lord, when they give a report, my lord, it is at best, my lord, an opinion.
That is not conclusive, independent finding.
Correct.
That is not been.
No, my lord, not there. My lord, in, my lord, if your lordship,
show cause notice.
in the show cause. And, my lord, third, my lord, the report, my lord, on which reliance has been placed. My lord, if your lordship see, my lord, the disclaimers in the said report, my lord,
as usual in all the affairs,
my lord, and your lordship's orders are there, my lord, apropos that, my lord, it cannot be the basis. My lord, if it is, my lord, if the disclaimers are such, my lord, which ensure that no form of responsibility, my lord, is being taken on any issue.
Frankly speaking, Mr. Mukherjee, on the second and third points, I am not very inclined till now to interfere at the show cause stage. But the first point is very German.
Yes.
Because documents, if those are not given, it's a not fair opportunity.
Correct. My lord, your lordships will kindly permit me to urge, my lord, all 3 points, my lord. Yes. My lord, I've, my lord, done it, my lord, in chronological order on, my lord, knowing, my lord, which is the, my lord, strongest point first. Now, my lord, kindly, my lord, see, my lord, the, my lord, show cause notice. Yes, my lord, kindly take, my lord, annexure, my lord, P18, page 661. My lord, I'll give your lordships, my lord, the page numbers 661 to 678. It's in volume 2.
Right.
I don't know if your lordships, my lord, papers are in volumes, but my lord, it's...
Yes, they are.
Yes.
661 I have got.
Yes. Now, my lord, 2 things, my lord, I wish to point out. My lord, apropos, my lord, this show cause notice is concerned.
Yes.
Your lordship will find, my lord, item 3, Hemant Kanoria, who's a writ petitioner, my lord, on the first page.
Yes.
In his capacity as director, promoter of SIFL, SEFL, residing at so-and-so, collectively so-and-so, hereinafter referred to as SRL. So, my lord, in my capacity as director, my lord, this is being given. Now, my lord, kindly see the subject. Declaration of accounts of SREI entities as fraud as per... So, my lord, it's the declaration of the accounts of SREI entities. My lord, the master circular relates, my lord, only to, my lord, the borrowers. what can be done with their accounts? My lord, a director, my lord, can get, my lord, roped in later, so to say, my lord, that, my lord, if, my lord, the account is rendered fraud, then, my lord, if, my lord, any proceedings are initiated, my lord, on that basis, my lord, naturally, my lord, the directors, my lord, can be proceeded with, my lord, in criminal proceedings. And, my lord, over and above that, my lord, what happens, my lord, to, my lord, the entity is, my lord, several other civil consequences cannot approach the market, very much like, my lord, a willful, my lord, defaulter, my lord,
So you say there
reputation.
is no scope of issuance of this sort of a show cause notice or applicability of the fraud directions on directors.
Directors. There's none. My lord, that is a side wind really, my lord, because, my lord, but
Obviously.
except what has happened in two cases. Because in two cases, which I'll show to your lordships, my lord, during the pendency of the writ petition, my lord, the individuals have been declared fraud and perpetrator of fraud. When, my lord, show cause notice didn't mention it, it's a one-line, my lord, response.
Then what is declared as fraud? It's the account which is...
Account has to be, but I have been individually declared a fraud and a perpetrator of fraud in two other matters, my lord, not this one. The two matters are also before your lordships. Yes, my lord. Out of the four, my lord, 23 and 28, which are before your lordships, my lord, I'll show that, my lord.
Language is probably accounts have to be declared to be
Correct. Absolutely, my lord. Absolutely.
All right, anyway, yes.
My lord, but the result is, my lord, at the end, my lord, accounts declared fraud, yes, one thing. I have individually been declared a fraud, and, my lord, in one case, a fraud and a perpetrator.
Been declared as fraud.
Yes. Now, my lord, kindly come to, my lord, the subject ones, my lord.
Yes.
My lord, declaration of accounts of SREI entities as fraud as per master directions on frauds, classification and reporting, so and so, dated 1st July and its amendments from time to time, and RBI master directions read with the judgment of the Honorable Supreme Court of India in State Bank and Rajesh Agarwal. So this is, my lord, the opportunity which is being given to SIFL and SEFL, which are now, my lord, in the control and management, my lord, of the resolution applicant. My lord, I have, my lord, nothing here. Now, my lord, your lordship seen this is being given, my lord, in my capacity as a director. Your lordships will make another note. There is no allegation. There is no allegation, my lord, against the writ petitioner. My lord, my lord, the show cause notice. In fact, my lord, on the face of it, ex facie, I'll only request your lordships to read paragraphs 1 to 6, which is, my lord, starts at, my lord, page 661. My lord, goes up to page 662. My lord, your lordships will find that it's the accounts which are being referred to, and it's based on, my lord, a review and detailed analysis of the forensic report shared by the auditor, forensic auditor. Paragraph 6, your lordships will find.
Yes.
My lord, it is, my lord, the accounts, my lord, which says nothing, my lord, against, my lord, the, my lord, writ petitioner. And, my lord, at the end, my lord, of the show cause notice, at page 674.
Yes.
Kindly see paragraph 8.
Right.
In view of the foregoing, you are hereby called upon to show cause as to why accounts of SREI Infrastructure Limited and SREI Equipment Finance Limited should not be classified as fraud under the RBI master directions. You are directed to make your submissions in writing within 15 days of receipt of this notice. In case you fail to make submissions within the period of time provided as above, the bank shall be at liberty to proceed further in the matter in absentia, as per the RBI master directions and the judicial guidelines in this regard. Please note that the instances highlighted above are not exhaustive and are merely indicative based on the forensic report. Kindly note this. They are all based on, you are hereby called upon and directed to provide responses to this notice. Now kindly note, and all the other findings in the forensic report against you. The notice is without prejudice, so and so supersedes earlier letter. But earlier letter no longer.
This was issued after the CIRP was over.
Yes.
Obviously, yes.
Yes. And, my lord, I am, my lord, as a director, my lord, asked to, my lord, respond to this. Now, my lord, the show cause notice, my lord, the reason why I said, my lord, that this is, my lord, least bulky is because I have not annexed, my lord, the uh, forensic audit report, my lord, to this particular writ petition. It is annexed in all the others. I've prepared, my lord, a chart. My lord,
All the writ petitions have been filed by several directors, different directors.
no, my lord, the same director, my lord, and my lord, show cause notices by different banks.
Oh, acha. Similar show cause.
Yes, yes, my lord.
Premise is the same affair.
Yes, my lord, the same, my lord, forensic audit report is, my lord, the basis of all. And that forensic audit report, my lord, makes, my lord, reference to other than, my lord, domain information in the public domain, my lord, documents both of these, my lord, of these two entities as well as others.
So, Mukherjee will continue after this.
Yes, yes.
My lord, with unconditional apology, my lord, I am compelled to mention one matter. My lord, item number 9 of today's list. Now, my lord, this matter was listed before your lordship as item number 1301 in the monthly list. I am for the state respondents. My lord, lordship has been pleased to dispose of this red petition. But my lord, this has been upgraded, lordship, kindly consider without any notice. From item number 1301 of the monthly list, today it is appearing as
Publication in the list is also sufficient notice, Mr. Ward.
Sir, kindly appreciate, my lord, it will go down as my carelessness and incompetency. My lord, matters appearing, lordship, kindly think, my lord.
Give a
whatever
notice to
has
the
happened-
give a notice to the other side, mention tomorrow morning, I'll consider. But the order has been passed in open court, it has to be uploaded.
Yes, my lord, the order has been passed that, my lord.
Give a notice to the other side, come back tomorrow, let me
My lord,
see.
item number 5.
No further mentioning, please. Yes.
My lord, আমি একটু মেনশন করতে
না,
চাইছি।
এখন মেনশনিং আওয়ার নয়।
মানে আমার আইটেম
এখন মেনশনিং আওয়ার নয়, কাল সকালে আসবেন। Yes.
3
Mr.
নম্বর
Mukherjee, please continue.
আমার রয়েছে ম্যাটারটা রয়েছে
Yes.
অরিজিনাল সাইডে ম্যাটার রয়েছে মাই লর্ড 3টের সময়।
আপনি আসুন। Yes, Mr. Mukherjee.
My lord, I was, my lord, arguing on the point, my lord, that it's not an effective, my lord, opportunity to respond, my lord. And I had shown your lordship, my lord, the show cause notice, my lord, the last, my lord, page of the show cause notice, my lord, at 678. Page 678.
678, yes.
Yes, your lordships will find, my lord.
678 or
My lord, it's volume, my lord, 2. My lord, it's actually one volume, my lord, before you.
yes.
Sorry, 674, my lord.
4, yes, right.
Lordship will find paragraph, my lord, 8, my lord, onwards. In view of the hereby called upon as to why accounts of so-and-so should not be titled as fraud under RBI, directed to make your submissions in writing within 15 days. In case you fail to make submissions within period of time, the bank shall be at liberty to proceed further in the matter in absentia, as if the RBI master directions and the judicial guidelines. And please note, instances highlighted above are not exhaustive and are merely indicative based on the forensic report. Kindly mark, Miller. It's based
Mr.
on
Mukherjee, the premise of this is that the account of the company, the borrower, would be marked as fraud, not your account.
No.
There is
cannot-
no personal allegation. Since
No,
you are the
none,
director,
none.
you have been called.
None at all. And I've been asked to give, my lord, this information.
Yes.
And
Because
my
the
lord,
company does not have, I mean, it's a juristic entity. So you are a director. That's why.
while director, I have no access to the
Yes,
company now.
right. Now the CIF.
Yes, my lord, this is why, my lord, it's, my lord,
All right.
now, my lord, then it says, my lord, what I want to, my lord, really highlight here also, my lord, is that the entire thing is based on the forensic report. They have admitted it, my lord, here, my lord, paragraph 10, please note above are not and are merely indicative based on the forensic report. You are called upon and directed to provide responses to what? To this notice and all the other findings in the forensic report against you. My lord, then notices without prejudice to rights of banks, etc., supersedes, etc. So, my lord, this being the position, I wanted to show your lordships, my lord, the FAR, if I may use that expression, my lord, the forensic audit report. Kindly, my lord, take, my lord, I have, my lord, arranged for your lordships, my lord, convenience, my lord, volumes 4 and 5, my lord, of, my lord, the item number 23, my lord.
Yes.
Which has, my lord, the forensic audit report, my lord, as part of, my lord,
Yes.
my lord, kindly take, my lord, my lord, volume, my lord, 4 first,
Yes.
my lord, which is, my lord, page 776. My lord, kindly have a look at clause 4. And it's the same, my lord, FAR, my lord, in which all the banks have relied on.
Yes.
And my lord, it's identical language, my lord, the show cause notices in 3 of the cases. My lord, my lord, Union Bank of India, Bank of Baroda, and Bank of India. It's separate, that's what I'm saying. Now, my lord, kindly have a look at clause 4. Sampling approach and methodology during the forensic review. Kindly see, my lord, how, my lord, the sampling approach starts. My lord, according to software maintained by SRA entities to record outstanding loan portfolio as on etc. Then considering the volume of contracts open, close, various parameters were considered to identify and sample high priority and high value to both SRA entities as samples to be reviewed for the forensic audit. So, my lord, it's based on, my lord, a method of sampling. Now, my lord, kindly come to clause, my lord, C. Performed searches in Ministry of Corporate Affairs 21 database maintained by another similar to identify companies and LLPs falling under the same group of companies, whether their shareholding structure, directorship, loans granted to such identified group were considered for review. Analysis of loan portfolio to identify instances wherein disbursement and collection entries have been passed amongst loan contracts pertaining to borrowers falling within the same group of companies. Now, kindly come to G. Apart from the above analysis, Various aspects of the operational and financial data of both the SREI entities were considered. Then, my lord, first, loan contracts whose balances were written off during the review period. 2. Loan contracts of body corporates wherein investments have been made by SREI entities. 3. Closure of loan contracts wherein interest was not served for a prolonged period. Loan contracts of entities identified by RBI for additional provisioning as on 31st March. Loan contracts considered for provisioning as per expected credit loss, so-and-so, provisioning as per RBI norms as and when applicable during the review period. Then kindly see 4.2. Sampling approach and methodology adopted for review of other in scope areas. Kindly see clause C. Journal entries and book adjustments in the ledgers of entities forming part of the SREI group. Material adjustments and reclassifications at the end of reporting period evidenced year on year during preparation. Sampling based on analytical procedures by year on year figures suggested material variation. Sample transactions that suggested material disposal, revaluation of fixed assets, investments, etc. Sample transactions that did not appear to be at so-and-so. And transactions with entities that have material adverse public domain information. My lord, neither is the domain, my lord, indicated. My lord, where, my lord, one is to get it from. Now, my lord, kindly turn over the page to 770. For each sample selected, documentary evidence was tested to support the journal entry recorded. Example, invoices, journal vouchers, authorizations, approvals, agreements, proof of delivery of service, bank statements, and other to assess the completeness, existence, and accuracy of the transaction. My lord, none of this. And the admitted fact is, I have no access to this. My lord, from October 2021, my lord, administrators have taken over. Now, my lord, kindly come to, my lord, the volume 5, my lord, page 969. My lord, it's all part of, my lord, the report. My lord, this is, my lord, section 8, my lord, of the FAR, my lord.
Yes.
The heading is scope of work, key procedures performed, and limitations. My lord, I'm not troubling you afterwards fallen from your lordships, my lord. Let's not go into, my lord, FAR limitations, disclaimers, etc. My lord, I'm on, my lord, an effective opportunity. My lord, that's, my lord, what is, my lord, most important. Then, my lord, kindly come to my lord, second bullet point against item 1. Sample transactions under each of the policies were reviewed to verify whether accounting treatment is in accordance with applicable policy as has been considered. Compared the accounting policies adopted by SREI entity.
Sorry, this is which page?
969, my lord.
969, yes. You're continuing.
Yes, my lord.
Second bullet point, right?
Yes, my lord. The second bullet point, my lord, against item 1. Item 1 is verify what the company has adopted, etc.
Right, right.
My lord, accounting policies, etc. My lord, now, my lord, kindly see, my lord, 3. Reviewed and analyzed on sample basis, my lord, second column, my lord,
yes, yes.
on application of funds, revenue, capital, and operating expenses during review period for review of bad debts, impairment gains, losses, incomes, including provisions and reversals, expenses, current fixed asset registers, investments, and other current liabilities. Sample transactions were selected during a considering a threshold value of 25 lakhs and supporting documents. To ascertain the completeness, existence, and accuracy. Documents reviewed include invoices, vouchers, so and so, so and so, so and so. Now, my lord, that is the strain, my lord, everywhere. Kindly come to 4. My lord, kindly see bullet point 2. Reviewed related party transactions with directors and key managerial persons to identify transactions, of any, for payments other than salary, directors, so and so. My lord, this is all on sample. My lord, we need to know which one of these, my lord, happened. Then, my lord, kindly come to 6. Second bullet point, my lord. Reviewed and fixed on sample basis the source and application of funds, revenue and capital and operating expenses during review period. For review and impairment of gains, incomes, including provisions of reversal, etc., etc., Sample transactions were selected and supporting documents were reviewed to ascertain. Documents reviewed include so and so, and other, my lord, vouchers, proof of delivery, others as to act, my lord, on genuineness. Then, my lord, 8, my lord, loan term sheets and documentations as executed with various bankers. My lord, first bullet point against item 8. Similarly, my lord, 9, loan term sheets, documentation as executed, none of which I have. Then, my lord, 12, reviewed and analyzed the books of accounts and records maintained by SRAI entities. And, my lord, in the FAR, the SRAI entities are these 2 entities. Then, my lord, kindly come to 13. To bring out the weakness in internal controls by using analytical procedures, substantive, etc. Now, what were looked into? Kindly see, my lord, the last 4 lines in that page. My lord, 25 lakhs and above is what is being scrutinized. Supporting documents were reviewed to ascertain completeness, existence, and accuracy. Documents reviewed include interview, vouchers, proof, so-and-so. My lord, not interviews, invoices, vouchers, delivery, and other supporting applicable. Now, my lord, similarly, my lord, kindly turn over, my lord, to the next page, item 16. My lord, kindly see, my lord, the last 3 lines. Documents reviewed include invoices, vouchers, proof of delivery, and other supporting, etc. Then, my lord, similarly, your lordships will find, my lord, at page 973. I'm, my lord, just giving, my lord, examples, my lord. Rather than take your lordships through, my lord, every sentence of, my lord, the FAR, my lord, item 20. My lord, in the second column, first bullet point, 4th line, reviewed the bank books, bank statements of SRAI entities on sample basis to verify inflow, outflow of funds from 2 such related parties. So, my lord, what was the sample? I need to look at it. On sample basis, you're looking at books. Let alone, my lord, that, my lord, I don't have access to any books. Then, my lord, conducted public domain searches to identify directly or indirectly linked related parties which were outside the purview of disclosure and reviewed transactions with such, reviewed and analyzed on sample basis rents paid to related parties along with security deposits, etc. Then, my lord, kindly come to 22. The loan portfolios were analyzed, second sentence, my lord, in the to identify customers, review sanction amounts, disbursements, and so and so, so and so. My lord, no, my lord, details, my lord, on this. Similarly, my lord, 24 and 25, and my lord, kindly see 27. Documents reviewed in, my lord, last line, include invoices, vouchers, proof of, my lord, the usual refrain for, my lord, under each head, which I don't have. Similarly, my lord, 28. Documents reviewed, last 2 lines, my lord, your lordships will find. Then, my lord, 30, analyzed on sample basis trade receivables, including debtors to whom assets have been given on lease, reviewed supporting documents for such. Then, my lord, kindly come to 977. My lord, again, my lord, 33, 34, 35. My lord, this sampling which is happening, my lord, I don't even know, my lord, who's being chosen. Then, my lord, kindly come to, my lord, page 978. Reviewed and analyzed on sample basis loan portfolio based on review and public domain analysis, identified customers possibly linked to the trust funds associated and other based on such, I were away, etc.
Is there any gist given in the entire show cause notice indicating as to what were the exact fraudulent acts committed by you?
Yes, so my lord, kindly have a look.
Please show me the
Yes, my lord, kindly have a look at, my lord, the show cause notice. My lord, from, my lord, the thinner brief, my lord, at page 661, my lord, which your lordships were looking at. Lordships were at page 674,
right,
my lord, which I showed your lordship.
Yes, because Mr. Mukherjee, it may not be feasible and proper to direct them to hand you over each and every voucher. And
my lord, I'll tell your lordships.
It has to be specified.
Yes, now, my lord, correct. My lord, now, my lord, if it is based, my lord, on those, my lord, what they have indicated in the show cause notice.
Yes.
Because your lordships would have noticed that, my lord, the FAR is part of the show cause notice because I have to respond to, my lord, every finding, my lord, in FAR, which are, my lord, a total of 20, how many loan transactions were there?
280.
280 transactions, my lord, which have been gone into. 280
In the FAR.
in the FAR. Now, my lord, kindly have a look. My lord, the instances, my lord, at page, my lord, 661, my lord, of my lord, Union Bank, is where the show cause notice is, 28th December 2023. Lordship has that, my lord?
Page 661.
661, my lord.
Yes.
Yes. Now, my lord, it's dated 28th December. Your lordship has that?
Yes.
Yes. Now, my lord, kindly come to, my lord, straight away, my lord, paragraph 7.
Yes.
The indicative, my lord, your lordship wanted, my lord,
Yes.
narrowing it down. The indicative and non-exhaustive list of major observations and findings made by the forensic auditor as recorded in the forensic report are mentioned below. Now, my lord, instances of issues related to credit exposure to customers internally categorized as high risk. So the allegation is, look, you had a loan exposure to high risk candidates. Now, my lord, kindly come to clause 2. The amount outstanding in this category as on 30th September is so-and-so. List of loans to customers whose ICR was SREI 8 as poor credit quality is enclosed in Annexure A. So we have, my lord, these, my lord, customers. Loans were given to customers with so-and-so as loans, EMTA, new rate.
Mukherjee, specifics have been given. They've called out from the forensic.
Correct. So, my lord, I have to have those documents.
This annexure indicates the list of loans to customers.
Yes. Now, my lord, kindly have a look, my lord, after these are given. Kindly see what is your specific response to the above illustrative loan cases where loans were extended to borrowers internally known to be high risk and highly vulnerable. Why were loan extended to customers with poor quality rating? Now, kindly have a look at Annexure A. Annexure A. No, it's here to the show cause. My lord, 675.
Yes.
This is it. Now, I need to know, my lord, the loan agreements. This is just a table.
For transactions that happened way back during the scope period.
But even in a plaint, Mr. Mukherjee, the entire evidence need not be produced.
But here it has to be because I have to respond. You've relied on certain documents to come to a conclusion.
The details have been given, all the details. The loan contract number.
So I have to look at the contract number. If I were in the company, your lordship's right. I have no access, my lord, to the companies.
But in that case, in no event where the company is with the administrator, can any show cause be issued under the fraud circular?
No, of course they can. My lord, with, my lord, the details. My lord, if I were, my lord, responsible in running the affairs of the company, my lord, during that period,
yes,
then, my lord, certainly, my lord, I could be asked to explain. But, my lord, where administrators have taken over, my lord, I have to be given those documents. My lord, which they have access to. Because, my lord, they have pushed, my lord, the resolution. They were the committee of creditors. They selected the resolution applicant. They had full access, my lord, to, my lord, the documents. And I, my lord, write to the administrator to give details, none of which comes.
Defend without evidence.
And, my lord, if I don't have an explanation, my lord, to this, without, my lord, the primary documents on the basis of which, my lord, this has been shown, then, my lord, there is no, it's not, my lord, I'm not saying you can't issue a show cause notice. Of course you can. But, my lord, I have to have, my lord, an effective opportunity, my lord, to respond. It can't be illusory, my lord. That's my only submission before your lordship. In fact, your lordship's aware, my lord, in several cases, my lord, including of the Supreme Court, they've said the documents were 4,000 pages. My lord, they were not, my lord, annexed. They said that you should actually annex it. And, my lord, in today's day and age, my lord, where everything is happening electronically, even people like me, my lord, are having to make a switch. And, my lord, if your lordships, my lord, had made the switch as an institution, my lord, your lordships would not have the pain, my lord, of turning pages.
Mr. Mukherjee, alternatively, access can be given to you for the limited purpose of having inspection or all.
Yes, it can. And if I need anything, my lord, for my lord photocopies, then my lord, then my lord, they can certainly, my lord, provide for it. What I'm saying right now is this show cause, please don't expect a response. It's 15 days given to me, my lord, to my lord, give a reply. Otherwise, it will be proceeded with in absentia. Because I have to explain, my lord, the verticals in the company, my lord, who was responsible for these loans. If I am not the correct person.
15 days is over. They have not done anything after that.
In this, in my lord,
These matters,
Union Bank, my lord, they have not. Others they have done, which I'm coming to now.
Oh,
which I want to show your lordship now, which we brought on record, my lord, by way of, my lord, supplementary affidavit.
What have they done?
My lord, in one, my lord, I have been described as a fraud and a perpetrator. And my lord, in another one, my lord, I have been declared, my lord, as, my lord, fraud. Perpetrator. And my lord, as far as, my lord, my lord, Small Industries Development Bank is concerned, SIDB, my lord, they have relied on 2 other reports. Even those 2 reports have not been made available to me, which is the worst case. Here, at least, my lord, the report has been made available, but my lord, not, my lord, the documents on the basis of which, my lord, the report was prepared, and I am asked to respond to the findings in the report. Other than this, my lord, here, my lord, they have highlighted certain portions, my lord, as far as, my lord, the report is concerned, and said, please answer these queries. But, my lord, over and above that, they've also said deal with every finding in the FAR.
There are 4 matters now.
4 matters. My lord, I am Union Bank is item, my lord. Please come on, remember. Item 34.
Item 34. So at present, let me. What about the other banks? They are also on similar footing. They have not taken any subsequent steps.
No, they have.
The other 3 have.
My lord, first I'm dealing with Bank of India and Bank of Baroda. Union Bank, my lord, is no steps taken till now.
All right.
My lord, in fact, when we mentioned, my lord, for urgency, my lord, we said during, my lord, pendency, my lord, these 2 banks, my lord, had taken
Bank of India and Baroda.
Yes.
23 and 28.
23 and 28, my lord.
Very good.
Now, my lord, here I want to show your lordships, my lord, the supplementary affidavit, my lord, in Bank of Baroda case, my lord, which is item number 28, my lord.
Sir, you have filed some supplementary affidavit, sir?
Yes, my lord, not, my lord, we affirmed a supplementary affidavit, and my lord, will just that. Everything else is the same.
Sir, sir, have you filed any supplementary affidavit?
Yes.
Today or?
Served a copy earlier. We're just taking leave to file it now. They've not made it available.
No, I don't have that.
So, my lord, they have been served, but my lord, knowing my learned friend, my lord, the Solicitor General, he'll take 1 minute, my lord, to respond to it. My lord,
No.
He has to have a copy.
Yes,
not if you have filed it.
Yes.
Not if you have filed it. It's not 1 minute.
No, Mr. Mehta, are you equipped with a copy of the subsequent steps taken by you? Because they have annexed a 22nd December 2023 letter communication.
Yes, my lord.
If you have that, then Mr. Mehta, if you are ready today, we can continue with the hearing now.
No, my lord, if I can have, my lord, a day, my lord, by maybe say tomorrow, I'll go through it, my lord. 22nd December later, yes, I have, my lord.
Achha.
Does he have?
No, I have asked.
This is the subsequent step, Mr.
My lord, 29 December, your lordship
29.
has page 16.
Oh, I'm sorry.
Or my learned friend can complete, my lord. I'll assist your lordship tomorrow. But since he's in the flow, my lord, I would not like to, my lord, discuss.
Fair enough.
Lordships have also been taken through, my lord, several things.
Right. Yes, Mr. Mukherjee.
Now, my lord, kindly have a look at page 16.
Yes.
My lord, the supplementary affidavit, which is, my lord, the letter of Bank of Baroda dated 29 December 2023.
Yes.
Kindly see, my lord, we refer to show cause notice served to you on 7th. No, kindly have a look at, my lord, the subject first. Reasoned order for declaring your name as perpetrator to RBI on account of fraud committed in the accounts of Srei Infrastructure Finance Limited and Srei Equipment Finance Limited. Now, my lord, dear sir, we refer to the show cause notice served to you on 7th, received by you on 11th, as per online posted delivery, etc., etc., and observe that you have claimed that you were not associated with Srei and Srei since 4th October and have no knowledge about its operations. However, we bring to your notice that the observations made in this pertains to transactions and conduct of companies' accounts for the period so-and-so during which you were associated in the capacity. You have not addressed any of the observations in your reply, and you have based your reply on the plea for your non-association. Hence, your reply is not sufficient to nullify the observations stated in the show cause notice. And in view of the Special Investigation Team Committee, the reply is not satisfactory. Further, the observation stated in the show cause notice indicates diversion of funds, siphoning of funds, and other violations like evergreening round which constitute elements of fraud as per RBI Master Direction. Considering the above, Special Investigation Team Committee is of the view that the seriousness is grave and substantial evidence against you, Mr. could be corroborated for classification as fraud. Hence, we declare your name as perpetrator for your act of fraud to Reserve Bank of India. Now, my lord, kindly have a look at the subject of the show cause notice, which is identical. Nothing, my lord, regarding, my lord, terming me as perpetrator. Nothing, my lord, terming me, my lord, as, my lord, the, my lord,
the show cause notice of the Bank of Baroda.
it's identical. I'll show your lordship, my lord. It's at page, my lord, 654 of, my lord, the Bank of Baroda.
28980.
28980.
Page টা বার করে দাও, page টা বার করে দাও।
654.
654, my lord.
We have to shift to paperless, Mr. Mukherjee. We have to shift to paperless.
My lord, I have been.
Because it's becoming very cumbersome.
Yes, my lord. And my lord,
better for everybody.
My lord, one is, my lord, environmentally, it's not that, my lord, this does no damage to environment. But the fact of the matter is, my lord,
Definitely
paper,
environmentally
my lord,
also.
yes, my lord, it's, my lord, I remember once, my lord, being, my lord, if I may just digress for a moment, my lord, being, my lord, juniors, my lord, we were always wary of, my lord, what a particular court might think of suppression. So, my lord, in a special leave petition, my lord, I had, my lord, keeping that in mind, my lord, annexed, my lord, everything, my lord, with the list of dates. My lord, the learned judge who took up the matter said for the damage that you've caused to the environment, it needs to be dismissed.
So but I hope it was not a pollution matter.
No, it wasn't. But my lord, this is, my lord, what it was. Now, my lord, kindly have a look, my lord, at, my lord, the subject. Declaration of accounts of Srei entities as fraud, 654. As per RBI master directions on frauds, etc., read with judgment and order. Then, my lord, for an these are the accounts which are referred to. My lord, kindly come to page 665, my lord.
I suppose this is identical.
It is, absolutely.
Apart from the letterhead.
Yes, my lord, it's identical, absolutely, my lord. Kindly see, my lord, paragraph 8.
They belong to a consortium of banks.
Yes.
That's why obviously.
Yes, my lord, I'm not, my lord, that's another matter, my lord, on non-application of mine, but I'm not, my lord, everything's mechanical. It's the same.
Yes, but that can be.
Yes, it's possible, my lord, because as, my lord, the Joint Lenders Forum, they have appointed the same forensic auditor.
Right.
They all get the same report. My lord, it's expected, my lord, that they would, my lord, my lord, be act in concert. My lord, that, my lord, they would, if they're accepting the report, it would take, my lord, a bold bank to not accept, my lord.
Exactly.
Yes. So, my lord, let's, in view of the foregoing, you are hereby called as to why Srei so-and-so should not be classified as you're directed. In case you fail to, the bank shall be at liberty to proceed in absentia. So-and-so exhaustive merely, you are called upon to everything. Notices. My lord, there's nothing to indicate that, my lord, if I, my lord, cannot give an explanation, my lord, that I am, my lord, going to be, my lord, seen, my lord, as, my lord, a fraud and a perpetrator. Now, my lord, here, my lord, I say, my lord, first, my lord, that this finding which they have arrived at, my lord, is contrary, my lord, is beyond the show cause notice. That's number one. Second, my lord, it's contrary to the Reserve Bank of India Master Circular. And third, my lord, in effect, the last line which your lordships looked at.
Corporate Twitter.
Yes, my lord, this is my lord. My lord, considering the above, committees of the view that the seriousness is grave and substantial evidence against you. My lord, that's missing. My lord, from my lord, the show cause explanations have been sought from me. Substantial evidence against you could be corroborated for classification as fraud. Hence, we declare your name as perpetrator. And this, your lordships will find, is not addressed to the SRAI entities at all. It is addressed to me.
Yes.
Which is why, my lord, I say, my lord, that this is totally beyond the show cause notice, contrary to, my lord, the master, my lord, circular, which, my lord, is concerned with, my lord, the accounts, my lord, of the borrower entities. And, my lord, even that is on record, which I'll show, my lord. But, my lord, before that, I must show your lordship, my lord, Bank of Baroda now. Bank of India.
Yes.
My lord, kindly come to, my lord, page 15 of that.
Bank of India, Mr. Dewan, you are representing Bank of India also?
My lords, I am representing only Bank of India.
Bank of India.
Yes, my lords, and there are, insofar as Bank of India is a matter where there is an order already passed. So Bank of India I am representing. The learned Solicitor General appears for Bank of Baroda. I also appear for two other writs, but there no order has been passed.
Very good. Thank you.
Now, my lord, kindly have a look at this, my lord. My lord, this is the order which is passed on 2nd of January, 2024.
Right.
My lord, this is addressed, your lordship will find, to the writ petitioner alone. And, my lord, the subject matter is order for fraud classification of borrower, account of SRAI equipment, SRAI so-and-so. Then, my lord, kindly come, my lord. My lord, this is, my lord, summarizes, my lord, again, my lord, what was there, my lord, earlier. My lord, in the show cause notice. And now kindly come to at page 29, paragraph 6.
Yes.
The competent authority has felt that borrower notice has to be given a chance to make their submission in the interest of nature, consequent to which a show cause was issued to the notices herein seeking the finding observation. SA was served on the notice number 3 on so-and-so and so-and-so, detailing there is observations find. No written submission is received within 15 days of issuance of show cause. Fraud monitoring group has carefully examined the so-and-so internal investigation report, non-receipt of written submission and facts. FMG has come to the following conclusion based on the above. Then, my lord, the above indicates clear diversion, siphoning of funds, utilizing of funds for purposes other than so-and-so, and wrongful gain to notices with the intention to defraud the bank, causing loss of public money. Committee also finds that Hemant Kanoria was the promoter director at the time when transacted and cannot be without their consent and connivance. Further, notice number 3 has not been able to prove that the transactions have taken place without their knowledge or consent. In the light of the above facts and after providing above opportunity to notices to make their submission, bank has decided to classify Hemant Kanoria being notice number 3 as fraud on account of fraudulent transactions carried out in account of SRAI, so-and-so. Accordingly, bank shall report the same before various authorities, including filing of complaint before law enforcement. Above order shall come into force with immediate effect. And this is, my lord, again, my lord, beyond show cause, contrary to the circular, because, my lord...
I'm sorry. Mr. Mukherjee, have you annexed the master directions anywhere?
Yes, my lord.
So, master directions, does it contemplate the classification of a director as fraud?
No. No, that's, my lord, why I say, my lord, is completely beyond, my lord, the master director.
It does, my lord, it does. But in my turn, my lord, we'll point out. It does.
Yes, Mr. Mehta. That's why I'm putting the questions very clearly so that you can also
Yes, it does.
Yes. Very good. Yes.
Now, my lord, 3 points here. My lord, the show cause notice, my lord, had no allegations.
Against you as a director?
Yes.
All right.
Number 2, my lord, show cause notice does not say, my lord, that, my lord, if my lord, do not respond, I will be declared as a fraud. In fact, the subject matter of the show cause notice is, my lord, the SREI entities accounts, my lord, being declared as a fraud. Third, my lord, and this is very important, my lord, the master circular, and I say this, my lord, does not provide for, my lord, an individual entity, be promoter or director, being declared, my lord, any of his account or him personally, my lord, being declared as a fraud when he's not the borrower. So, my lord, it's contrary to, my lord, the directions as well. Now, my lord, kindly have a look at the master circular. Straight away, my lord. My lord, kindly take Union Bank. My lord, it's, my lord, volume 1, page 87 to 121.
For me, your worst clause, Mr. Mukherjee. The worst clause against.
My lord, there's none. My lord, the consequence.
Yes.
My lord, my learned friend, my lord, might be, my lord, making, my lord, the consequence of, my lord, an account of, my lord, a borrower being declared as fraud, my lord, can result in proceedings, my lord, against, my lord, directors.
It's obvious.
My lord, that is, my lord.
That is not under this direction, this master direction.
No.
General law.
Yes, no, not just that. My lord, after the report comes in, my lord, it's forwarded to law enforcement agencies, who then, my lord, can take, my lord, the, my lord, necessary steps. But, my lord, here, to declare, my lord, a, my lord, director, guarantor, etc., my lord, as, my lord, a, my lord, fraud, my lord, that, my lord, is not, my lord, in my respectful submission, from the language, my lord, is, my lord, a provision, my lord, here. Now, my lord, kindly come to, my lord.
Was 8.12, no?
I'm also anticipating, Mr. Mukherjee, an argument on piercing of corporate veil. Although directly it does not apply here, vis-a-vis a director and a company. Yes. No, it cannot. But even then, I mean, for the purpose of this circular.
Show cause notice doesn't say that.
Show cause doesn't say anything.
No, doesn't.
8.12 clause, my lord.
I'm coming to. My lord, I will.
My lord's question may be answered. That's all.
Yes, yes. My lord, I will rely, my lord, from, my lord.
Fair enough by Mr. Mehta to point out so that you can also deal with that when you.
Yes, yes, my lord, I'm coming to that straight away.
Right.
My lord, kindly come to
penal measures.
My lord, 8.11 first, my lord.
Very well, yes.
My lord, that, my lord, is at, my lord, 104. 106. No, 107. Ah. What are you doing?
113.
Oh, what am I looking at?
113. Go to 113.
8.12.1 includes the promoter directors.
1. Yes. 8.11.
8.11.
There is no 8.
My lord, 8.12. My lord, let us have a look at it.
1 is page 113.
Yes. Now, my lord, 8.12. My lord, I'm coming straight.
1 is what you said.
Yes.
Law enforcement agency.
Yes. Now, my lord.
8.12.1 is what Mr. Mehta is.
Yes. Now, my lord, let us have a look at it, my lord.
Yes.
8.12.1. In general, the penal provisions as applicable to willful defaulters would apply to the fraudulent borrower, including the promoter and other whole-time directors of the company, insofar as raising of funds from the banking systems or from capital markets by companies with which they are associated is concerned, etc. In particular, borrowers who have defaulted and have also committed a fraud in the account would be debarred from availing bank finance from scheduled commercial banks, development financial institutions, government-owned NBFCs, investment in for a period of 5 years from the date of full payment of defrauded amount. After this period, it is for individual institutions to take a call on whether to lend to such a borrower. The penal provisions would apply to non-whole-time directors like nominee directors only in rarest of cases, etc.
You were a whole-time director?
My lord, I was a director, my lord, whether whole-time.
Yes. Anyway.
I was. No restructuring or grant of additional. My lord, all that I'm saying is, my lord, I can't be declared a fraud or any account of mine. And my lord, 8.11, your lordship will find, my lord, these are, my lord, the penal provisions. Banks are required to, with the law immediately on it. There should not be any delay in filing complaints, since delays may result in so and so.
8.11 may be over and above 8.12. Now,
can be.
Maybe. But Mr. Mukherjee, how do you explain this? 8.12.1, in general, the penal provisions as applicable to willful defaulters would apply to fraudulent borrower, including promoter directors. Because the company is a juristic entity, it has to have its limbs through the directors. Now, therefore, the penal measures are applicable to willful defaulters borrowers, including promoter directors. How do you explain this? That includes you within the purview of the entire gamut of this circular. Because that, if that be so, you can also be declared to be a
But the show cause notice must state that.
That always remains, yes.
Show cause notice must state that.
Very well.
Show cause notice, my lord, doesn't, my lord, say that at all, my lord. And my lord,
as per the purport of this, it is presumed that you have involvement, in the sense that the penal provisions applicable would apply to fraudulent borrower, including the promoter director. Although you may have a point in saying that your involvement should have been indicated in that. But that is arguable. Let us see what they say. Yes.
Because, my lord, there is no charge, my lord, against me anywhere, my lord, in these two show cause notices.
Individually, no, but if you are in charge of the, if you are...
So that has to be, my lord,
read
into it, my lord, assuming that to be the case, then, my lord, I have to have an effective, my lord, opportunity to, my lord, make a representation.
Very well.
Now, my lord, then now, my lord, SIDB's case. My lord, where, my lord?
Yes.
29027. Two show cause notices.
Bank of India.
SIDBI. Bank of India नीचे sir. Please come to page 90.
Kindly come to, my lord, page 91. My lord, this is, my lord, writ petition
29027 of 2023, item 29.
Item 29, my lord. Yeah.
Page 91. Account US account.
Forget that, yeah. Just have they annexed it or no?
No. Now please come to page 92.
Yes.
Now, my lord, kindly come to, my lord, paragraph 6 at page 92.
Yes.
Further, an auditor was assigned to undertake portfolio audit of receivables book debt assigned to SIDBI on exclusive charge basis by the company as of 31st March. Auditor has furnished the report on 13 December and its summary as under. Now, my lord, all these are mentioned from the report, etc., etc., etc.
What has not been given?
The report itself, my lord, is not there. Apart from, my lord, the documents, my lord, which is the case, my lord, in all the other, my lord, matters. Here, my lord, the report itself has not been made available.
But if the details of the report were given and the report is the same as the others.
No, this is not, my lord, my lord, it's a different auditor who has done the.
Not KPMG.
This is not KPMG.
All.
This is not KPMG.
Here, no copy of the FAR.
No. And my lord, the next one,
Page 97.
Is page 97, my lord.
Yes.
Page 98, para 6.
Paragraph 6, my lord, kindly have a look.
Why two show causes?
One is Hemant Kanodia.
Yeah. My lord, here your lordships will find.
Why are the two show cause notices?
My lord, there are two. My lord, one is, my lord, they are, my lord, identical. My lord, I guess one is meant for, my lord, the dates are different. No, both are to address to both. My lord, your lordships will find there are two individuals here, Sunil Kanoria and Hemant Kanoria.
Acha, very well. No, both are to Sunil.
One is
Both are to both.
Both are to both.
one is
Yes.
CSL.
Only the
one
date is different.
My lord, the two companies are different. My lord, one is to Shrey Equipment Finance.
All right, very well. No, that is also same.
No. Shrey Equipment Finance at page 91
and 97.
and 97, my lord, kindly have a look.
Shrey Equipment Finance.
Same.
Same.
Date is different.
Date is different, I know.
Only the date is different.
Huh?
We received two identical show cause.
My lord, these are two identical show cause notices which have been received,
Anyway, yes.
issued on separate dates. And here also, my lord, it says, my lord, further an auditor. Auditor has furnished this report on 13 December.
Yes.
And then 91, your lordship will find. It's
91
identical.
and 97 are
Exactly the same.
Only the Azadi Ki Amrit Mahotsav is a bit smudged in the second one. But that may be due to your photocopy.
And my lord, no, not just that. My lord, the auditor, my lord, I don't know if it was the same.
No, it's not.
May or may not be an auditor.
An auditor,
very
so
good.
my
That
lord,
was- that was-
maybe, my lord,
Yes.
that, my lord, could be, my lord, the
Right.
distinguishing, my lord, feature.
Here, no subsequent steps were taken by this.
No.
No. Good.
Otherwise, my lord, everything, my lord, is, my lord, the same.
Similar.
Now, my lord, on documents,
Yes.
my lord, I just wish to, my lord, rely on. My lord, the first case that I wish to rely on, my lord, is Neptune.
Both Mr. Mukherjee and Mr. And all of you, Mr. Dewan as well as Mr. Mehta, if he's there, I'd like to ask you, because if all the documents are annexed here substantially, should I decide the main writ petition? Or should I, am I hearing it for interim orders? Whatever all of you decide. Definitely, if I do that, I'll have to record that none of the allegations are admitted and all. But please take your call, Mr. Dewan. Please ask Mr. Mehta, convey to Mr. Mehta also. Let me hear Mr. Mukherjee in the meantime. So take
Yes, Lord, I will take instructions. I will take instructions.
Mr. Mukherjee also. Let us hear Mr. Mukherjee for the timing. Yes.
My lord, kindly take, my lord, the decision reported in.
Yes.
My lord, 2020, volume 20, Supreme Court cases 106.
Right.
My lord, kindly come straight away to paragraph 32.
Yes, Mr. Mukherjee.
My lord, kindly see, my lord, para 32. We have no doubt that a proper show cause notice was served on respond number 2 herein. The moot point, however, remains as to what is the effect of not serving him with documents he sought for and within the compass of time which was given to him to respond. Once again, it may be stated that a large part of the documents would have been within the custody of 2 herein, or for that matter with 1. However, this would not encompass all the documents. Now, my lord, I pause here. My lord, here none is in my custody.
Right.
Then, my lord, not only that, when reliance is placed on as many as 4,000 pages of documents, it would not be fair to expect that party in question ferrets through its own record trying to locate the documents. Yeah, even if I'd done that, my lord, I would have got nothing. When on basis of, in question on records, when on basis of information of an opinion for issuance of show cause notice, logic and requirement of law both would dictate that the show cause notice should be comprehensive enough with full supporting documents being handed over. The answer cannot be that they're free to inspect 4,000 pages on their own. My lord, this is, my lord, what had fallen from your lordships, my lord, apropos, my lord, inspection. In fact, in so many terms, ultimately, most of those documents were made available, and it would not be appropriate to go back into the issue of whether documents should have been supplied or not. In a sense, that chapter is closed with supply of documents, even though some more documents were sought. We fail to appreciate why there should have been a cussedness in handing over mere copies when serious allegations and serious consequences which would flow to the respondents hearing. Not only that, the endeavor to conclude the proceedings within a span of 2 weeks thereafter cannot, in our view, said to be an adequate opportunity as has been found. An opportunity of hearing is not a mere nicety, but a valuable right. That it does not fall in a straitjacket formula is no doubt the accepted legal position. The question is whether there was substantial compliance, etc. Here, my lord, none. Here, of course, my lord, in Neptune, my lord, all the documents, my lord, were ultimately made over. And my lord, there was, my lord, a possibility of, my lord, a response, my lord, being given. But, my lord, this is, my lord, what was noticed, my lord, by, my lord, the Supreme Court. ठीक है बाकी सुधार
Inconclusive FAR will be
Hmm?
inconclusive FAR.
Hmm. And my lord, the FAR, my lord, I'm really not troubling your lordships with it after what's fallen from your lordships, my lord, regarding disclaimers.
Disclaimers, yes. All the affairs have disclaimers.
Yes, my lord, all the FARs have that. And in fact, your lordships, my lord, have, my lord, said, my lord, that that cannot be the basis.
But Mr. Mukherjee, the question in you, this particular case will be whether, I mean, at the show cause stage, whether, because FAR is an indicator, that is a trigger for them. So whether we can set aside the show cause notice itself on that ground. Because FAR, yes,
No,
may
no,
not
I
be
know,
conclusive.
my lord, which is why I'm.
Which has to be
My lord,
weighed.
it's.
But in any event, the document, your
Yes.
argument on document,
Yes.
that is very substantial.
Yeah.
And bolstered by this also, strengthened by this.
Yes. Now, my lord, the place where, my lord, the FAR, my lord, becomes relevant are the two, my lord, matters where the decision has been taken.
Yes. Yes.
There it becomes, my lord.
Because it on the basis of
Yes.
that it has, right.
So, my lord, apropos that, my lord, I just want to.
Yes.
Yes. Kochi.
These are the only two matters in which you have handed up two supplementary evidence. These are the only
Only
two matters.
two, my lord, where
it
there has
been
been, my lord, the decision.
Right.
Kochi. My lord, one is, my lord, Amit Kumar Kejriwal, my lord, that's 18 December 2023.
But they won't be having a copy of this.
Of course.
We'll just give it.
Okay, email karo.
If we can just give the citation, that would be enough. We'll take out the copies.
No, no, I've given it. Mr. Solicitor General, I've given a copy.
Yes, sir. Otherwise also, it need not necessary. Citation is enough.
Right.
Now, my lord, kindly have a look, my lord, at page 3 of, my lord, this judgment.
Yes.
The forensic audit report as his evidence was not only inconclusive but full of disclaimers, which robs the same of any conclusive value. In any event, the forensic audit report could at best be a piece of evidence which would initiate a further detailed inquiry by the respondent authorities prior to declaring the petitioner to be a willful defaulter. The same have not been done by the respondents. The impugned orders as well as the show cause notice are vitiated. So, my lord, this not having been done by the impugned orders as well as show cause. Now, my lord, kindly see, the inconclusive FAR could not be a valid premise of the show cause notice or the orders of the committee. In fact, the show cause notice, apart from quoting the provisions and observations in the FAR, did not independently make any allegation of particular acts done by the petitioner within the purview of the master circular. Then, my lord, kindly skip a paragraph. then also the premise of both the committee orders was the FAR itself. And here again, my lord, the order which I've, my lord, given your lordships, my lord, the two orders are the, my lord, FAR. Since the FAR was inconclusive and full with disclaimers as rightly contended by the petitioner, in the absence of any further independent material to indict the petitioner on the allegations as made in the show cause notice and the said orders, both the committees acted dehors the master circular in declaring the petitioner to be a willful defaulter. Moreover, the contention of the respondent bank that the document annexed to the writ petition as the order of review committee was
different.
Yes. Now, my lord, the yes, my lord, the next one also your lordship kindly sees, which is my lord Prashant Botra's case. Just give a copy.
Mr. Mukherjee, can you cite anybody else's judgments? There is a tendency among judges to repeat their own judgments to justify their previous.
My lord, I'll do that. My lord, I'll do it on the next day. My lord, I am.
So because all of these are my judgments,
Yes.
naturally there will be a tendency that I'll follow this. And if there's a reverse bias, it goes against you.
My lord, I'll.
So Supreme Court judgment, there are certain Supreme Court judgments.
Yes, my lord, I'll, my lord.
Very well, I'll take on record because you're citing. Yes, very well.
In fact, my lord, you're. Yes.
Because I naturally repeated my own things unless it was proved to be wrong.
My lord, these were, my lord, in fact, kindly ignore this. My lord, I'll go, my lord, by my lord Amit Kumar's judgment, my lord, for the simple reason that's the most recent one. My lord, of this court. And my lord, your lordship might have noticed, my lord, that I am in effect making, my lord, one, my lord, with prejudice concession that, my lord, at show cause notice stage, my lord, I'm saying if documents are made available, then, my lord, it can, my lord, proceed. So, but where the decision has been taken, my lord, I'm only relying on it for that purpose. Your lordship's judgment, my lord, covers show cause as well.
I've become stricter now. Very well.
So, my lord, that's, my lord, how, my lord, I look at it, my lord. I'll get the either Supreme Court or another High Court or another, my lord, decision which is not your lordship.
This point remains unless
yes, this point, my lord, remains. And my lord, I just wanted to, my lord, indicate one thing to your lordships. My lord, the standards, my lord, to be followed, my lord, in, my lord, declaring an account to be fraud, and, my lord, for, my lord, a willful defaulter, your lordships will find, my lord, in the SBI case, my lord, JAR developers has been relied on and, my lord, followed. So, my lord, it is, my lord, very similar, my lord, to, my lord, an opportunity, effective opportunity of hearing.
Yes, effective opportunity is a sine qua non.
Yes, my lord, that is also what JAR, my lord, says. And, my lord, that case has been quoted, my lord, copiously, my lord, in, my lord, SBI's case. My lord, I can give your lordships, my lord, those references, if your lordships, my lord, want. My lord, 2023.
6-1.
6 SCC, page 1.
Yes, I checked that in the recess.
Oh. So, my lord, paragraph 49 and 50 to 98, my lord. And your lordships will find, my lord, from the para 60 something onwards, my lord, JAR, my lord, is, my lord. My lord, JAR, my lord, is referred to.
No, it's only one indulgence, my lord, with the permission of the court.
Yes.
Permission of my learned senior, my lord. My
Yes.
learned senior very fairly said that it is kind of a concession. That show cause notice, they can proceed. But with two caveats, as I understood his submission. A, the supply of documents.
Yes.
And B, the decision which is taken, which would come in his way. Lord, subject to your lordships, my lord, being convinced, Lord, I can say the documents will have to be supplied to him. According to us, they are supplied to him, but if not, can be supplied to him and should be supplied to him.
Yes.
So far as decision which is taken is concerned, it is decision taken at the level of the bank. The next step is to communicate that decision to the RBI. Lord, we can supply the document, keeping all his contentions open. He can reply to the show cause notice And my lord, till then we may not send it to the RBI.
No, Mr. Mehta, the difficulty is there is very little to interdict your formation of an opinion and sending it to the RBI. I mean, RBI, there is no further step in between. Your decision is conclusive. If the decision is taken at your end, the RBI has to put it up. So that
So
decision,
then it becomes public, my lord. Then it becomes public.
the RBI does not have any further distinction to hear on that or take any.
No. Hearing will have to be given by me.
Right. If that be so, Mr. Mehta, then the conclusive decision which has been taken by you, unless that is stayed, I mean, the operation has to be stayed then, what you were saying. Or that has to be set aside if I am convinced finally.
I get it, my lord. Let me, my lord, come back to your lordships. I have understood what is falling from my lords, my lord, and what is conveyed by my learned senior.
Thank you. And Mr. Mehta, I asked a question when you were not there, whether
No, I'm there, my lord. I just switch off my video.
I'm sorry. I asked a question whether I am hearing this for final conclusive hearing with the rider that none of the allegations in the writ petitions are admitted or for interim order, because substantially I am hearing the entire matter.
But I think, my lord, it would be final disposal only, my lord.
I think so, because all the documents are annexed, and I'll definitely record somewhere that the allegations are not admitted by you. I have to do that.
Yes, because unless, my lord, some allegations are made, my lord, we have not controverted. That's all.
Let Mr. Mukherjee conclude, then you will take your decision. And I'll ask Mr. Mukherjee also.
Please, my lord.
Yes, Mr.
My lord, I have really, my lord.
You have submitted on the merits of all the matters. So this is all.
Yes, my lord, I'll only come back, my lord, on the next occasion before my learned friends.
No, not then. That is not required. With judgments of
Yes,
other courts.
My lord, just.
No, that was just a passing over. These are the judgments we're relying on.
Yes,
I'll
my lord,
take
no,
all of
if I find one, my lord, I'll hand it over. That's all that I'm saying.
with prior notice to them.
Yes. My lord, only thing is, my lord, Learned Solicitor General is thinking about keeping it tomorrow. My lord, I know that both of us are against each other, my lord, in the Supreme Court tomorrow, and a matter which my learned friend has got fixed.
We can do it virtually from my chamber. I'll invite you.
Oh, no, I'm not traveling to Delhi after the troubles, my lord, one is having with flights.
No, I would also suggest don't travel. Don't travel.
Because, my lord, it can be a 10-hour, my lord, travel now.
Yes. So,
my lord, kindly keep it tomorrow in case, my lord, my lord, then it can go on Friday, my lord, because subject to your lordship.
Subject to my lord's convenience.
And I'll keep it tomorrow at 3 or not at 3. I mean, any time which suits you, because substantially.
Whatever. My lord's convenience and convenience of my learned senior.
Mr. Mehta and Mr. Diwan, because Mr. Mukherjee has concluded. Now I have to hear you only. So, whichever time suits you. Up to 3 p.m. From 3 p.m. I take up original side matters. This is an appellate side matter. So,
can it be at 2 o'clock, my lord?
2 o'clock would suit me. Very well.
Yes, 2 o'clock is all right, my lords.
2 o'clock tomorrow then, Mr. Mukherjee? Yes, right. After order record, heard in part for further hearing tomorrow at 2 p.m. Thank you. Please come back.
Lord, I have, my lord, heard your lordship's questions also. I keep the video off, my lord. That's all.
No difficulty, Mr. Mehta. But please take care somebody does not impersonate you and make arguments which are.
Lordship, now, my lord, the deep fake is a very dangerous thing, my lord. Deep fake is a very dangerous thing.
It is very...
Just, my lord, beside the point, but somebody made a deep fake of Zelensky in this Russia-Ukraine war, and the fellow who is posing as a Zelensky, or name maybe I am mispronouncing, he told his troops that we have declared a ceasefire, and now there is no point in fighting the war again further, and therefore I call my troops back. And the troops started coming back. It's really a scary situation.
Yes, exactly. So if I'll take a cue from this, Mr. Mehta, if tomorrow somebody says that you are withdrawing, then I'll be careful.
Yeah, not sure that right.
Right, let us come back tomorrow too. Thank you.
Yes, grateful.
আচ্ছা তুমি এটা গুছিয়ে যেটা যেখানে আর এইটা না একটুখানি কোথাও স্টেপল করে রেখো, যেটা একটা জায়গায় স্টেপল করে যেটা উপরে এইগুলো যেখানে থাকবে
for extension of time to file affidavit. My affidavit is ready, my lord. I have given by mail. They are not accepting unless lordship is giving an extension.
Please give a slip. This will appear as to be mentioned tomorrow. I'll extend the time. Give a notice to the other side also.
Yes,
My lord,
Listed
my lord,
matter.
I'm opposing.
You are the other side.
My lord, but item, it is already running in my lord's list.
Oh,
Time has expired on 15th of December. And my lord, they have thought to give it to me by WhatsApp today. That is why I rejected.
No, I sent by clerk also. He was
let us not be on these. Let us not be on these. These are petty matters.
My lord, I have the order by which my lord extended the time. My lord has it in observation.
Let this appear as to be mentioned tomorrow. We'll deal with this.
Item number.
Item number
18.
8.
এটা কালকে উপরে to be mentioned.
Item number 1.
Yes.
Anima Shamanto versus Hinduja Leland Finance.
This is the matter in which my lord was pleased to appoint a special officer, my lord, and special officer.
Oh, you are this. Right. You have got your remuneration. Got your remuneration.
Yes.
What was the matter about?
My lord, the point was, my lord,
Yes.
I am a tenant and in occupation
Yes.
of the second and third floors. Admittedly, my lord, the ground and the first floor are secured assets. my
Oh,
lord.
whether there is an
Yes,
you are on the second.
Second, I'm on
Second
the
and
second and third floor.
What is? Yes, ma'am. Special officer. What did you see? Is it possible?
Yes, sir. My lord, the petitioner can access the second floor and third floor through the back entrance without hampering the position of ground floor and first floor by the respondent that can be visible through annexure 8.
You have not got a copy? Oh, I did not direct circulation.
Signature.
Where you will take a copy and come back tomorrow then? Please circulate copies among all.
My lord.
We already did.
The report filed by the learned special officer today be kept on record. Full stop. Copies thereof are circulated among learned counsel for the parties. Full stop. Let the matter be listed tomorrow under the same heading. Day after tomorrow there will be difficult. There is some pressure. Come back tomorrow if you are in difficulty. Go. Tomorrow under the same heading for passing further orders. Please consider this. If it's possible, then I'll pass directions accordingly.
I'm so grateful.
My presence is necessary tomorrow.
Please remain present tomorrow also. Should your remuneration be increased? Further remuneration? What is the remuneration given?
15,000.
15,000.
At the first instance, 15,000. Since she's appearing on two occasions, I believe
I think it will be. একটা line add করে দিন. In view of the requirement of the learned special officer to be present on several occasions, further remuneration of rupees 10,000 be paid by the petitioner to the learned special officer by tomorrow.
I'm grateful.
Item number 2. Anirban Rai Chaudhuri and others versus State of West Bengal and others.
Yes, so what is it?
In this matter, I appear for the suspended board. And in the third matter, my lord, with the next matter, item 3, is where I appear for the petitioners. Here I appear for the respondent, but this matter now, my lord, was for my removal, which has been achieved through the competent authority. So if your lordship hears item 3 first, that might help.
I think that will be easy. Yes.
May I submission one thing? I am state respondent. Already in fact.
Number 2, that is what Mr. Thakkar also said, and Mr. Bhattacharya substantially agrees. I mean, there was a prayer in item number 2. You prayed for his removal.
Yes.
I prayed for an order, my lord, directing appointment of an administrator.
Mr. Thakkar's client was the administrator.
No,
He
Mr.
was the
Thakkar's client
previous.
was the board.
I was the board.
You were
He wanted removal of the board.
Correct.
Now, during pendency of the writ petition, the board was removed and an administrator was sought to be appointed for 3 months. On the 17th of October, he came to your lordship's court by way of the third writ petition, item number 3, assailing the order of removal.
If he wins, then your petition revives.
Yes.
Yes.
Apparently, yes.
So not infructuous right now. Let me hear three first.
Very good. And in item, in the first matter, my lord, I am told a reply has been
He will
served.
oppose in all the matter.
Not with Mr. Bhattacharya, but because of his elevated status, I am compelled to stand on the same side as him.
Why elevated status?
Lordship knows.
I mean, in general.
How we address him.
Yes, Mr. Bhattacharya, anything to say on that?
My lord, Mr. Bhattacharya was putting me in between two of them. I moved to the side. I can't handle one. How to speak of two?
Physically as well as figuratively.
Both ways, my lord.
Physically and figuratively are the same here.
Certain answers need not be given in court, my lord. I'll give it
Figurative
outside.
is physical.
Yes.
Yes.
So, my lord,
May I take my seat?
first of all, my
Seat
lord,
or leave?
no, no, he said.
Safer for Mr. Thakur. Yes. Yes, sir.
Well, first of all, madam, I'm sorry I wasn't on time yesterday.
No, no.
Grateful for the accommodation. Now, madam, the scope of this writ petition is very limited. The propriety of the action taken by the competent authority to remove a duly elected board. That is all. That is the short point. If your lordship kindly takes, I don't want to go into the history of the previous litigation. All that is not relevant. Although all those papers are annexed, but all that is not relevant. I don't want to unnecessarily trouble the court. Kindly come to my lord page. The incident of
This is 1755. WP.
please, my lord, 1755.
Yes. Which page?
Page 317 is the copy of the show cause notice. Yes, state is the primary respondent. I'm sorry, the competent authority.
There was a direction.
My replies also. Respondent number 2 is the competent authority, my lord. I am only concerned with his actions.
Right.
That is all.
Yes.
And they have used an affidavit of 10th of January. Now, my lord, on 5th of January, there was an unfortunate incident. There was an altercation between a resident who was a tenant of a particular flat, which is Horizon 3. The tower is Horizon 3, Unit 1801. The resident of Horizon 3, Unit 1801, Dr. Praveen Kumar. There was an altercation between him and the security guards.
Right.
That altercation turned ugly. There were FIRs and counter FIRs. The security guards say that he misbehaved with them. He says that the security guards physically assaulted him. That there was an altercation. The altercation snowballed into a gherao by certain members of the certain occupants of that housing complex. Gheraued the board of managers, and the situation became very ugly.
In support of Mr. Praveen.
In support of Dr. Praveen Kumar. Yes. So they gheraued the office of the association. The situation became very ugly, and the members of the board, 40 out of 48, there were 45 elected members. 36 resigned en masse. 36 resigned en masse. The president submitted the resigned on 7th. The incident of 5th, FIRs and counter FIRs on 6th. This incident of Gherao on 7th. And the president and 36 out of 45 resigned en masse. The president submitted his informed, because the president is the competent authority, my lord, is not like an authority to whom a resignation is to be submitted. It is just an intimation or information. The resignation is to be submitted to the board itself. The president is from the board, answerable to the board. The authority is just to be informed of any election or resignation. President informed the competent authority of his resignation by an email of 9th. On 10th, now, my lord, your lordship sees now kindly in this backdrop, which is uncontroverted. These facts
for the president and the board.
I am for, no, my lord, the president does not wish to continue. The board wishes to continue. The vice president has come up before your lordship. Now, my lord, on 9th, now kindly come back to these facts are not in dispute. These are not controversial. Kindly come to, my lord, 317. Whereas this authority has received a petition dated 9th October 2023 from, your lordship kindly marks this, aggrieved resident complainant residing at University so-and-so, being a member of the Kolkata University City Apartments Owners Association, the association. I kindly make a note here, my lord. Complaint is from one individual who is specifically identified, name not given, but resident of so-and-so, and he is described to be a member. First point I make is, my lord, one complainant, and the description of him being member is incorrect because a member of an association can only be a flat owner. Otherwise, this gentleman is not a member, he's a tenant, and he does not meet the description of owner. Otherwise, that is a lessee who holds it for more than 30 years. My lord may kindly make a reference to 3IA of the Apartment Ownership Act. Owner means a person owning property, deemed to be owning, promoter, or a lessee having a lease for more than 30 years. This gentleman does not meet any of these descriptions, so he is not a member. That is the first error in this show cause notice. Now he says, for redressal against assault, for redressal against unlawful activities, including physical assault, grievous injury caused by so-and-so, in the pretext of collecting common area maintenance, apparently at the behest of the office bearers and the few board members of the association, as narrated in the instant complaint petition. A copy of the said petition is enclosed.
This tenant was Dr. Kumar.
This tenant was Dr. Kumar.
Yes.
So he made a complaint. The competent authority treats him as a member, which is incorrect. And the competent authority in the show cause notice, it's actually a show cause notice, but styled as an order, says a copy of the petition is enclosed. Then, my lord, whereas in view of the fact narrated in the petition, it prima facie appears that the function of the president and the board of managers of the association is detrimental to the interests of the association of apartment owners or of the apartment owners, or is against public interest. This is a replication of 16B. 16B2 of, my lord, the 16B2 of the Apartment Ownership Act. 16B2 of this is a replication. Then, my lord, now in exercise of powers concerned, now I'll kindly see the president of the association is hereby directed by this authority to show cause as to why he should not be removed, or the board of managers be not superseded, or such other action be taken as prescribed under 16B. So two things, my lord. President is directed to show cause why he should not be removed, or the board of managers be not superseded. Two persons are being targeted. Two distinct identities. One is the president, the other is the board. His written reply with respect to the complaint petition. Now, my lord, kindly make a note. He has to reply to the complaint petition with copies of all supporting documents should reach the undersigned within 3 days through email only. He is directed to appear before the competent authority at such and such time under so-and-so. Now, my lord, where it is sent, your lordship kindly notes, it is sent only to number 1, Mr. Partho Chatterjee, President, Kolkata so-and-so Apartment Owners Association. It is not addressed to the board. It is sent to a gentleman, Partho Chatterjee, who has already resigned 1 day prior to the date of issuance of this notice. 9th October, Partho Chatterjee sent his resignation, which I'll show your lordship. I am grateful that the competent authority has come up with an affidavit in which they've narrated the facts and they record that 9th he had resigned. So it's sent to a president who is no longer a president. And it is not addressed to the board, to whom also, which also is sought to be superseded. So the board is not given any notice. Now, my lord, Partho Chatterjee responds by his email of 12th. Kindly come to 319. Kindly note paragraph 1. And this is addressed to the competent authority. Please note, I was holding the post of the president association till October 7th, when I was made to resign forcefully under duress by certain members and their tenants of the association. 2 is not relevant. Kindly come to 3. The fact that I have resigned on 7th October was intimated to your good office vide my mail dated 9th October.
So he had resigned actually on 7th.
He had resigned 7th, intimated on 9th.
The competent authority itself.
Yes, sent to competent authority at 1:55 p.m. show cause notice to remove president who is no longer president, or to supersede board addressed to a person who is not competent to represent the board, and no notice to the board. So, my lord, he says, I have resigned on 9th October. Now, my lord, kindly read further, very important. In fact, as would appear from the said email, I have already intimated to your good office that Mr. Vikas Kumar and Mr. Akshay Prakash have accepted the responsibility of discharging their respective duties. So, these are two other board members. So I have the president, when he resigns, informs that Vikas Kumar and Akshay Prakash have accepted the responsibility of discharging their respective duties post my resignation in the afternoon of 7th October. No notice given. Then, my lord, it is pertinent to mention that my decision of resignation remains unaltered, and I am no longer a president of this association. So far as my knowledge goes, at present is led by Ram Kumar Jha, who has withdrawn his resignation. Not so relevant. Now, my lord, kindly comes to 5. In the circumstances as stated above, in the event your good self, however, still wants me to assist any further in my individual capacity, I shall render my cooperation and assistance to your good office and submit all documents available with me and reply to the show cause notice which has been issued by your good office, provided that a copy of the said complaint is served upon me at my address mentioned herein above.
A copy was said to be enclosed with that.
It was not enclosed. My lord, not only was Partho Chatterjee not favored with a copy of the complaint to which he was to show cause, that courtesy has not even been extended to your lordship. The complaint made by this tenant has not been disclosed by the competent authority, even in the 2 affidavits in opposition which they have used, one to the petition itself, one to my supplementary. Now I have relied on Partho's letter here. Partho's letter says, and he reproduces that part, and I reproduce this in the supplementary. He doesn't say that the contents of this email are wrong. Copy of the petition was duly sent. A copy of the complaint was duly sent. So, my lord, A, the affected party is not given notice. The person who's given notice, he's asked to reply to the complaint. The show cause says you must reply to the petition, not to the show cause. The show cause itself doesn't have the grounds. It just has a summary of what the complaint is ostensibly. But the show cause is very clear. His written reply with respect to the complaint petition. Complaint petition does not see light of day even till today.
But the show cause says that a copy is annexed.
Show cause says copy is annexed.
Disputed by Partho, obviously.
Partho disputes it. Now it was for the respondent, competent authority, while dealing with this email of Partho to say that the contents of this email are wrong. Look here, this is my email. This has the attachment. Doesn't say so. I'll show your lordship the 2 paragraphs in his opposition where he deals with this. Now, may I read further?
Served authority order show cause notice was not an email. It was a
by email.
That was also by email.
That was also by email, but I don't. At the forwarding email I have now, it was not on record then. I have copies. But I don't want to trouble with copies which are not there, lest they take time that I want to deal, etc., etc. Now, my lord, it was said, address mentioned here, the mail received from your end at my personal email. So, the email which was sent was not even sent to the email of the association. So, the association did not have any knowledge. Does not have a copy of the complaint. The screenshot of the email received is enclosed herewith for your reference. Then so and so. Then he says 7, further request you, in the event once a detailed reply to the show cause, the same may be issued to the vice president, namely Ram Kumar Jha, who's now the head of the board of managers, present in charge of the office of the association, in the absence of any president. Kindly adjourn tomorrow's hearing. Now, my lord, hearing is not adjourned. An order is made. Kindly come to, my lord, page 322. Whereas this authority received a petition dated 9th October 2023. Now, my lord, kindly notice the difference here. From aggrieved residents, Dr. Praveen Kumar and Surya Narayan Bhattacharya. Where does Surya Narayan Bhattacharya come from, my lord? I ask myself. Your lordship has seen the show cause, identifies the complainant as the resident of a particular unit. Surya Narayan Bhattacharya does not find name. In the opposition which is filed, I'll show your lordship, He says the competent authority, kindly come to the opposition straight away, please, my lord. Where he says who filed the complaint.
That I could just refer and please give me the page number of the
Yes.
opposition.
Yes, my lord. Just kindly give me a minute.
Opposition. Please copy the opposition.
তুমি তো লিখেছো জানো না
হ্যাঁ আমি লিখে দিয়েছি কপি তো আমি লিখি কপি দেব
হ্যাঁ
কপি তো আমি লিখি
হ্যাঁ that is subsequent. There the opposition makes it even better. I'll just show your lordship my lord, just read down. I'll show your lordship what he said in the opposition even better. Now my lord, kindly read further in the order. Surya Narayan Bhattacharya, the petitioners. The petitioner is only one in the show cause notice. Then my lord, residing at University Horizon 1801. 1801 is, my lord, where Praveen Kumar resides for redressal against including physical so-and-so. Now, my lord, kindly see. 3 resident owners, namely Harsh Jha, Manish Chaudhary and Surya Narayan Bhattacharya met with the undersigned on 10th October 2023 and narrated several complaints against the working of the present board of members, including the events that occurred on 5th. No notice given of what. This is something which the competent authority takes into consideration. But no notice of this complaint is given either to the president or to the board who sought to be superseded. So this is traveling beyond the scope of the show cause notice. Next, whereas in view of the facts narrated in the petition dated 9th October, it prima facie appeared, there is prima facie satisfaction recorded, I'm not troubling you. Then next is the notice which he issued. Then he was directed to give his written reply. Then now I'm going to kindly see the 4th last paragraph on the page. 2 aggrieved residents, namely Surya Narayan Bhattacharya, having been authorized by 13 members of the association and Dr. Praveen Kumar, appeared before the competent authority on such and such date and explained all the events that occurred on that fateful day. Now, whereas a complaint letter dated 13th October was received from Shri Surya Narayan, Praveen Kumar and Amit Suleiman on the date of hearing, that is 13th October, further complaint lettering. All this is has a bearing on the outcome. Now, if a further complaint is received on 13th, which he again takes into consideration, this further complaint should have been given to me before an order is passed taking into consideration this complaint, or he should have rejected the complaint that this is too late in the day. I am not going to consider this. So, 2 acts beyond the show cause, and the show cause itself does not give the complaint. Then, whereas the president of the association did not appear at the time of hearing, now kindly note, instead he forwarded his resignation letter via email on 12th October to the email ID. This is incorrect. Resignation was given on 9th. 12th was only an intimation that I've already told you I've resigned. Your lordship has seen that letter of 12th. So this is not resignation. Now, my lord, even if I take it that he makes a bona fide error, he receives a resignation on 12th. So now, my lord, he cannot proceed. There's no precedent for him to proceed against. Then he has to proceed against the board after receiving president's resignation, although it was not. Then he should have given notice to the board after 12th that, look, I've given notice to a president who's no longer there. I want to remove you. I'm giving you notice. Doesn't do that. Now, whereas it is also learned that a number of other BOM members have also sent their resignations via email to the competent authority, and present BOM has become kaput, non-functional and ineffective. So, my lord, I don't know, he's fond of German, but this is now something which is again beyond show cause. This was known to him on the day he issued the notice. But this is
still for the state will explain the expression.
Yes, they will. The kaput, I don't know that. I couldn't find that. I could have looked up Google, but so, my lord, now third new ground beyond show cause, and all this he knows on 9th. He doesn't make. He could have, my lord, made this a supplemental ground to his show cause that a complaint has come. So many people have resigned. What do you have to say? Doesn't say that. This ground comes in for the first time in the order. Your lordship knows, man, it's well settled that an order traveling beyond the show cause is invalid. The order has to be on the basis of the cause which is sought or allegation made in the show cause, the authority cannot make an order beyond the grounds sought in the show cause. So now we have 3 grounds. Whereas it appears that in the interest of the proper functioning, so and so, it is imperative to super. This is the conclusion. Now, my lord, he doesn't find any, he expressed prima facie satisfaction when he issued the notice. That is the ground of the issuance of show cause. Where is his final conclusion here that what is said in that petition, I find it to be true and correct? No reason. He has to express his satisfaction here. That was only prima facie for issuance of show cause. Now I don't come and I don't reply. He has to record a conclusion here that you have not come. I find no reason to disbelieve the petition of complaint. No recording. Only reason here is kaput. So I become kaput.
Probably he meant bomb when he said BOM, not board of members.
The
B is missing.
Yes. Bomb which didn't go off. It self-imploded. Kaput. Self-imploding bomb. So, Malad, this is so much for the order made by a competent statutory authority. Now, Your Lordship sees the opposition. Kindly come to paragraph 5. Page 4.
Yes.
Broken and useless. Kaput means broken and useless.
Which phone?
Hey?
It may vary from version to version of phone.
That kaput was a German word. I'm not very sure, but where it comes from. Etymology ta ki comes from where? Anyway, paragraph 5.
Kaput is used in a slightly different context.
Nice. With reference to paragraph 4 of the said writ petition, safe so my lord, kindly see the third line. I say that the order passed by the competent authority on 17th October 2023 was not only on the basis of the alleged complaint dated 9th October 2023, but also on complaints narrated by the 3 resident owners, namely Harsh, Manish, and Surya Narayan, against the working of the then board. So, my lord, my reading of the order was not incorrect.
Yes.
Then, my lord, then he says, served notice on 10th October. Then, President, next paragraph, hearing was, judgment, the hearing was scheduled by the competent authority, so-and-so, asked to attend, 2 aggrieved residents. Neither filed his reply. Now kindly see next page, very interesting, page 5. As none appeared for the scheduled hearing on 13th October at the office of the competent authority, the competent authority heard the matter in the absence of the representative of the Board of Managers. It was then noticed, now kindly see, it was then noticed, so then meaning on 13th October, he says, it was then noticed that the president had already informed about his resignation with effect from 7th October through email to the competent authority on 9th October. So, my lord, 9th October email he notices for the first time on 13th. Very conveniently ignores the erstwhile president's email of 12th. Everything he does. Whereas he also includes a list of board members who had resigned. Now, from the list enclosed by the president, it appeared that on 7th October, out of 48 bomb positions in the board, there were 45 elected. From 45 elected, 29 had resigned on and with effect from 7th October. 7 had resigned and only 8 remained as on 9th. On 10th October, further 3 bomb out of the remaining 8 bomb informed about their resignation through email to the competent authority. Now everything comes back. It's like a flashback. Now, let's kindly see next. Thus, only 5 board members remained as members on 10th October. As such, for the interest of the apartment owners of the said association for maintenance and so on, it was anomalous for uninterrupted services during festive season. So now he brings in festive season also. It was felt necessary by the competent authority to appoint him. None of this finds case in the show cause notice. And now, if 5 board members remain, the Act provides that if there is a casual vacancy created in the bomb by resignation of members, that vacancy has to be filled up by special election. I can understand that this is an unprecedented situation. Out of 45, 40 are gone. 5 are left. Then he has to call upon the remaining members or hold an election. Why? remove 5, and he knows, my lord, why would he? When, now kindly see, my lord, he says on 5 board members remained as members on 10th October. He knows that only 5 are there, then why supersede the bomb? Then that should have been a ground in his show cause notice, that now there are only 5 of you left. Either you, then the act provides, my lord, then election has to be held. He should have directed election. How could he have superseded the other, removed the other 5? He knows everything. Kindly see, my lord, section 10B, my lord, 10B of the bylaws. Removal of managers. Manager may be removed from office, etc. And any other casual vacancy in the office of any manager by resignation or death shall be filled up through a special election for this purpose. 10B provides for it. And he had the authority under 16B1 to give directions. 16B2 is a very severe step which he takes. So 16B1, he could have issued directions that you hold election. Doesn't do that. So on 10th, now on 10th, when he knows there are only 3 left, and all these, on 9th, he knows that only 8 are left. None of these 8 are given notice. The 8 remaining bomb, whom the president has informed him that these are the 2 gentlemen who are now discharging my duty. Please give them notice. Now, nobody is given notice. And Lordship sees now everything, he knows everything. Then, my lord, kindly come to paragraph I have referred to volume 1. Kindly come to page 18 once, please, madam, of this reply. He annexes the letter of resignation. Now, this is sent, your lordship sees, from an official email ID. Kindly see president at KUCAO in. That is the whatever is the designation of the office bearer, that precedes the, my lord, at the rate of. So if it's sent by president, sent to press secretary, this is the official email ID for communication purpose. And president has made himself CC to his personal email ID. The notice is issued only to him in his official email ID. The deliberate attempt, my lord, not to, my lord, give notice to the association. The president has already gone. Let me give him notice on his personal email ID. If he doesn't inform the board, very good. My purpose is served. I've given a notice, a perfunctory notice. And then your lordship sees, as you can see, then this letter itself is recorded. This is the letter which the president spoke of, my erstwhile president. As you can see from the resignation letter, Mr. Vikash and Mr. Akshay, managers of the board, accepted their responsibility. This letter records whatever the president said in his communication of 12th. He referred to this email. This email records, if he had to give notice to anybody, he could have given notice only to Vikash and Akshay. And that too at the official email ID of the association. It doesn't do that.
Or maybe to the vice president.
Or to the vice president. If the vice president is also not there, at least it has to be given, my lord, to a person who's competent to represent the board. So notice not given, complaint petition not given.
Did the board have any official email?
Well, this is the officially, this KUCAO, that is Kolkata University Association of Apartment Owners Association, is the official email ID. And your lordship sees the next page where this, he's right, everybody is writing to this only, president or from whatever. So the post which is there, my lord, whoever is the office bearer, secretary, treasurer, they take in that name first. Now, their contention is this, that the vice president, whom the president said that you address, so president says 2 things, the erstwhile president says 2 things. One is Vikash and Akshay. Notice should have been given to Vikash and Akshay, because there's no question of removing a president who has already resigned. So the first notice should have given to Vikash and Akshay. Then president says you give to Vikash and Akshay, and you also give to Ram Kumar Jha, who is continuing as vice president. He had submitted his resignation, he has withdrawn. There, the competent authority only says that Ram Kumar Jha resigned his resignation was not withdrawn prior to this. As on the date of my issuance of notice, Ram Kumar Jha was still vice. But that still doesn't meet the test of removing the board of members. The board of managers, who's a duly elected body, should have been given notice, proper notice. There's no notice, there's no complaint petition, and the reasons for the order, as admitted, as showing from the order itself and as admitted in the affidavit in opposition, go beyond the charge in the show cause notice. So this order, my lord, is so he annexes all the resignations. He knows who is there, who is not there, but doesn't give effect. And my lord, there is no averment. Now kindly see once just the affidavit in opposition to the supplementary. Kindly come to one paragraph of the supplementary, which is paragraph where he deals with this kindly take my supplementary affidavit once, my lord, where I have set out in extenso the contents of the email. Paragraph 8 of of Ram Kumar Jha's supplementary affidavit sets out in extenso.
Yes.
In paragraph 8, if your lordship kindly turns to page 4.
Yes.
About 6 lines from the top, my lord. And he also mentioned that he did not receive a copy of the complaint filed by Dr. Praveen Kumar, so-and-so. Where he mentioned Surya Nayan is incorrect. This is draftsman mistake. The complaint was only by Praveen, dated 9th October before the competent authority further requested.
This paragraph, I'm sorry, the paragraph?
This is, my lord, paragraph 8 of the supplementary affidavit. Ram Kumar Jha supplementary.
Ram Kumar Jha supplementary. Eight.
Page 4.
Page 4, yes.
Yes. Lordship kindly sees about 6 lines from the top.
Right.
On the right hand side, after 11th October, and.
Yes.
And he also mentioned that he did not receive a copy of the complaint filed by so-and-so before the competent authority. This is all that I want to show you, Lordship. He said in his email, I have not received. Now kindly see how it's dealt with in the opposition filed by the competent authority. Competent authority does not deal with this, does not say that no copy of the complaint was given. Kindly see paragraph 6 of the affidavit in opposition, the supplementary affirmed by Shiuli Banerjee on 9th January. Now, my lord, paragraph 6 deals with paragraph 8 at page 4, your lordship has.
Yes.
With reference to paragraph number 8 of the said supplementary affidavit, save what are matters of record, I deny and dispute all allegations which are contrary thereto, inconsistent therewith. I say that on so-and-so at about 11:48 p.m. in night, the president had informed the competent authority to issue the show cause notice to vice president and sent a copy to the petitioner herein. Why it is also evident that on 11th October, the vice president informed the competent authority about his resignation. Having been informed about the said resignation of the vice president, issuance of show cause on 12th to the vice president would have made no sense. Doesn't say that what is narrated here of non-receipt of the complaint petition itself to which show cause was to be replied was given.
They say that because of the resignation.
Yes, that is the only reason. There's no question of serving show cause again on the vice president. But I'm not on vice president or president. The whole initiation of the proceeding is bad. If you don't inform the person to whom you are issuing show cause, what is the cause which he has to, what is the allegation which he has to make? The initiation is bad. I need not even show your lordship the infirmities in the order. The initiation is bad. A, no notice to the person who's to be removed. B, even if it could be, by some stretch of imagination, it could have been contended that president and erstwhile president bomb, they all one and the same. We inform the president. So that is deemed notice to the entire bomb. Even that cannot be made out in this case because complaint petition itself was not given. And there is no denial. The competent authority could have, my lord, disclosed the email by which this petition was sent, I mean the show cause notice was sent. Kindly also make a note of paragraph 14, my lord. All these are, my lord. He says, why the reasoning of removal. Kindly see paragraph 14 once, please, my lord, of this. I say that the competent authority had to pass an order dated 17th October, since it appeared that the strength of the Board of Managers was reduced drastically, and keeping in view of the complaints narrated on 11th October by 3 residents regarding the mismanagement of the daily affairs. Mismanagement of the petition, the show cause was one incident of the security guard manhandling this particular member. These daily affairs regarding mismanagement, this gentleman, this competent authority has already ruled in my favor, which led to the writ petition of number 1700. Did not find any ground to remove me. And now the same competent authority says regarding mismanagement of daily affairs. Those are my respect. My lord, just for the sake of formally citing, my lord, fairly well settled proposition of 58 Supreme Court 300 show cause notice, my lord. Khemchand, my lord. Paragraph 19 to summarize. The reasonable opportunity envisaged by the provisions under an opportunity to deny his guilt and establish his innocence, which he can only do if he's told what are the charges leveled against him. 19A. And the allegations on which such charges are based. Never informal. The rest of it doesn't come into play at all. Then there is one more citation. I'll hand over a copy of the text. It's 2020. I'll just give your lordship the citation. I'm sorry, the print is not here. Just says that the order made beyond the allegations or the charges in the show cause notice cannot be sustained. The order of whatever is the disciplinary action or order imposition of tax, any order basis a show cause notice cannot travel beyond the reasons given in the show cause notice. That is 2018 7 SCC 443. This principle holds good, I find, in all jurisprudence, whether it is administrative, whether it is revenue, in all jurisprudence, this principle applies, Those are my responses. The competent authority, has to meet these charges,
Yes. Who is for the competent authority? You spend more time in coming here than Mr. Thakkar took to argue the matter.
My learned colleague points out, I'm so sorry, Malad.
In the meantime, you resume your, transit. Yes.
Let's section, kindly make a note of 7.2 of the bylaws, my lord. The number of managers of a board shall be equal to 1/3 of the number of the apartment owners of the property concerned, but in no case it shall be less than 3 or more than 48.
I don't understand. Why this?
So, my lord, it was anyway more than 5, but it has to be 1/3. So that he has to anyway direct election. He could have only directed election if it falls under this.
This does not help you.
Please, no. I'm just, since he says I should be fair to show everything, that is all.
My lord, as regards to service of complaint, my lord, it was not done, my lord. It was missed out in mail. I have checked. I told them it was not served.
So let me pass my order.
My lord.
Let me pass my order then. What else? Yes, continue your arguments.
My lord.
If you did not serve the complaint, what is the basis of their show cause?
Well, it was missed out, my lord. Actually, they written in that it was enclosed in order, but in annexure they.
Thank you. Fair enough. Fair enough.
They failed.
Yes. What else?
And my lord, according to us, my lord, they did not have the strength of that board members. It was drastically false when we came to know, my lord, when president sent us a mail along with the annexure attachment. There they disclose that now this is our strength of the board of member, only 5 are remaining.
So why didn't you direct re-election, special election?
My lord, election has been notified, my lord, by the administrator.
Why did you appoint the administrator in the first place? The board could not be removed. Board does not automatically get removed if it falls below the requisite number. Is there any provision that if the numbers are not met, substantially people resign, then automatically the board gets removed?
No. My lord.
Or becomes defunct? Is there any such provision?
My lord, section 17B.
What was the provision for special election, you said?
Well, it's 16, kindly give me, in the bylaws.
T1.
No, no, well, it's 10B. 10B of the bylaws, my lord. Any other casual vacancy, the removal and casual vacancy by resignation.
Right. The number has to be equal to 1/3 of the number of apartment owners. If it does not, if the number is not met, you have to bring in other members by way of election. And here there was actually a casual vacancy on the resignation.
Casual vacancy.
And Mr. Thakur is right on that apparently. So leave it on the usual refrain. Leave it on the court. No, you have anything else to argue? Then argue.
No, my lord. Complaint has not been sent.
Right.
It is.
Yes, yes. Mr. Bhattacharya, you have to add anything in support of the competent authority?
Support. He cannot support, you said.
So do that so that I can record the collusion. Let me pass my order now then.
Kindly, your lordship has not heard me.
Do it quickly.
Now, this order at page 322 is subject to my writ petition. First, your lordship would also have to examine who is before the court. Whether the 5 persons who admittedly did not put in their papers are before the court. Who is before the court? There is a dispute with the writ petitioner and his resignation. He resigned on a particular date. The records reveal that he resigned. Now please come to page 316 of the writ petition. The writ petition argued by Mr. Thakur.
Yes.
On Wednesday 11, not the one below.
Sir, Bhattacharya, you are for respondent number?
I am for the respondent number.
In this, Mr. Thakur's.
345.
Yes. Please continue, page 316.
I, Ramkumar Jha, elected BOM member and Vice President of Kolkata Uniworld, hereby tender my resignation from the said position with effect from 7th October 2023. The resignation was forced upon me under duress by few owners who cast aspersions and abuses on me. It has hurt my credibility and put a question mark on sincere efforts that I put in during my tenure as a Vice President and elected BOM for the betterment of this society. Being an ex-naval officer, I have never been subjected to such sudden. In view of the foregoing, I requested to accept my resignation with effect from 7th October. Now, my lord, the same gentleman, the top, on 14th October 2023, says, refer to my mail below. It is to inform you that I have withdrawn my resignation, which I was forced to give under duress. I continue to be a member of the BOM and vice president. So, this gentleman, by virtue of this precarious situation, has carried a writ petition to your lordship's court, allegedly being pleading that he has been authorized by 350% or 250%, but appending a signature of 72%, out of which most are not presidents. Or, if I may take Mr. Thakkar's argument, non-members. Most of them are non-members. The entire list, the pleading in the writ petition, paragraph 1. Now, please see, I invited your lordship's kind attention to paragraph 5. The instant writ petition, I'm sorry, page 4, paragraph 5 of the writ petition.
Yes.
The instant writ petition has been filed at the behest of more than 350 flat owners residing at the said complex who are members of the association and who are seriously aggrieved by the said order dated October 17, 2023, passed by the respondent. A copy of the letter dated 17th October, signed by the said 350 owners, 350 flat owners, is annexed. Please see annexure P1 now, in support of this. We have taken this point.
71.
The writ petition,
Total 71.
Total 71. And out of them, I have indicated in my affidavit in opposition, that most of them are not presidents, non-members, non-owners, non-members, double signatures.
Double signatures also?
Yes, I'll just show you lordship here and now. Double signature. Page 19A to 19D. একটা double signature দেখাতে হবে।
Anyway, very well. This
Now, it is a proceeding under Article 226. Apart from looking into any infirmity, one issue which has to be examined by a court exercising powers conferred under Article 226 is who has come to the court and how is his legal right violated. My learned friend is not amongst the 5 remaining members who, if at all, were removed. The board has been made defunct. I agree with him to the extent of the position in law 1/3 or minimum 3, maximum 48. There were 5. Have those 5 persons come? Those 5 persons are not before your lordship's court.
Yes, you have said that. Yes.
Now, apart from that, this order at page 322 has been, premised. Apart from looking into the complaints, relying on the complaints, the grievances, it, hinges on the premise that, there were resignations which the competent authority in courts, duly received from various members. And, in view of the 45 members, kindly note this. There were total 45 members, not 48 here. Out of the 45, 40 members had put in their papers. There is no quarrel with that. And out of those 40...
You are counting the present petitioner within that 40.
I am counting the present petitioner within that 40 because it is not explained in the writ petition as to whether he comes within that 5 or whether he is outside 5. Because, I tell your lordship, returning back to the attention of your lordship's court was invited to the affidavit in opposition, not used by me, but by the state. Kindly seize the state's affidavit. Page 13. 13.
ওইগুলোর মধ্যে দেখুন পরিত সিনার ব্যাকশিট দেখছি এখানে
My learned friend
yes
invited your lordship's attention to page 18, which is, my lord, the same as page 13. Attention of your lordship's court was invited to page 18. 18 and 13 are the same. My lord, 13 kindly comes. It's the same thing. But what is, my lord, there is, as you can see from the resignation letter, my lord, the resignation letter is a handwritten document at page 14. Lord, page 14. The President, Kolkata University Apartment Owners, Lord, it is being addressed to, owing to the moral responsibility of the security incident that has happened, whereby one of the residents, Dr. Kumar, Lord, no question regarding, Lord, whether he is a member, whether he is a owner, whether he is anything. One of the residents, Dr. Praveen, was assaulted by security guards after an altercation and a demand by a group of members. I hereby tender my resignation from the post of President with immediate effect. It is not subject to a particular incident apart from whatever is recorded here. It does not refer to a ruckus created. It does not refer to any, Lord, forceful, Lord, that he was subjected to any physical or, Lord, mental trauma which prompted him. This is not recorded in this resignation. It's unilateral. I request you to follow. I request my fellow board members and the group placing the demand to file or the responsibility at the earliest, that is 8th October 23. Then, my lord, sincerely yours, Partho P. Chatterjee. Dear Mr. Sanjeev Shanchetti and Mr. Harsh Jha and others, I have explained to you all that there should be a proper handover takeover to ensure that the facility operations do not suffer in any manner, and going with going work gets completed. Ongoing work. I'm sorry. Thank you. So so that the association do not suffer any longer. Despite that, since you are insisted that we should resign from, this portion from the Board of Managers also with immediate effect, I am tendering resignation for me, for the Board of Managers as well. Please accept the resignation, and Milord, kindly sees page 17 now. (31 to 44). Milord, serial number 31, 35, 39, 40, 41, 42, 43 and 44 have apparently not resigned, and the remaining 1 to 37 have put in their papers.
Including Ramkumar Jha.
Including Ramkumar Jha.
Who is the author of this? I mean,
this author is.
This is the state's affidavit.
Yes, this is the state's affidavit. The state has appended this document. The author is Partho P. Chatterjee. And
where do we get that?
The handwritten document, page 14. At the bottom, thanking you. There are 2 signatures.
Yes, but how is this? This was never referred to in that letter.
No, this is not referred.
This is something else. This was, yes.
This is the original resignation letter of 7th October.
While sending Mr. Bhattacharya was sent a mail along with these attachments.
Achha. But Partho Chatterjee writes to the president.
President of Kolkata, yes.
Page 14.
Of the owners association, yes.
Who was the president himself?
Partho was the president in that I cannot explain.
The capacity of president.
I cannot explain, Milord. Whatever be the.
One else, so he gives the resignation to
himself.
Yes,
there is no one else, Milord. He is writing to the president of the Uniworld Apartment Ownership Association.
That is, this is Partho's,
Yes.
not
And-
Ramkumar Jha.
Not Ramkumar. Ramkumar, I'm showing. Ramkumar, I showed your lordship.
Yes.
Ramkumar, I not invited your lordship. That is page 316.
Yes.
Now,
On 11th, he says I resign. On 14th, I resigned on 7th.
7th.
And on 14th, he
And
says, no, I don't.
this document, page 17 also suggests that Ramkumar has, Ramkumar Jha, the writ petitioner before your lordship, has put in his papers, resigned on 7th.
But he says that also.
That also he says for the first time on 11th. On 11th at page 316 with effect from 7th.
But both are after the show cause notice.
Both are after the show cause notice.
And before the final order.
Before the final order. Now, one thing. Now, kindly come to the show cause is dated 10th.
Yes.
Mr. Jha's, the writ petitioner's letter is dated 11th. So, as on 10th, nothing was before the competent authority apart from this communication addressed to the competent authority at page 13 of the affidavit, appending documents indicating Ramkumar Jha has demitted office, or rather has resigned from 7th.
Page 13 of what? There.
Of the affidavit used by the state.
That does not say Ramkumar has resigned.
Yes. Page 17.
Page 13 you said.
13 is enclosing documents. List of board managers and their status as on 7th October 2013. Page 17, kindly sees.
This was a part of this.
Yes.
Page 13.
Please come to page 13 or page 16 or page 18, whatever
13.
suits your lordship. It is page 13 has two attachments, as my lord very kindly got it at the top, after the date. Two attachments would indicate
one is
I am hereby enclosing the list of BOM who have resigned as on 7th. Before thanking you.
Yes, right.
So that indicates, that.
Right.
So, on October 9, a communication was made to the competent authority indicating that Mr. Jha has resigned on 7th. What we gather is, from the records, that Mr. Jha has annexed a document at page 316 of the writ petition, annexing an email of 11th of October 2023.
Reiterating that.
Reiterating his position that he has resigned on 7th. Because apparently, my instruction is, I may be wrong, but Mr. Jha was perhaps not there on the 7th. Physically. I do not know, I do not. This is, maybe, incorrectly.
So what would be the effect of that, Mr. Bhatt?
The effect is, A, show cause has been served now. 2, after the incidents complained of. Now, here, what we...
Bhattacharya, wouldn't that be ridiculous? Because the president says, I have resigned. Along with that, I have also annexed a list of other persons who have resigned.
Yes.
Knowing that fully well, on 10th of October, a show cause notice is issued to the president himself in his personal email.
Milord, the show cause notice.
Let us forget Ramkumar Jha for the time.
Yes. Milord, the show cause notice has been served on the 10th. Milord, on the president. Yes. Milord, he says that it has been.
He is meticulous enough to look into those lists and ascertain that yes, Ramkumar Jha is no longer there.
Yes.
But then he overlooks the letter itself and issues it to the president.
Milord, I put this question to myself. Milord, the president's resignation was before the competent authority. But at the same time, the competent authority, in order to arrive at a conclusion, he had to act in some manner so as to give effect to his decision. So, my lord, rightly or wrongly, my lord, he has written to the president, and the president also has responded to this by saying two things. One thing is, my lord, this written complaint not given to me, and the other is, I am agreeable to cooperate if you give me the complaint.
But I am no longer the president.
But yes, indicating, my lord, that is his letter at page 319. Now, my lord, here he has said that the written complaint does not form a part of this previous page 318. The written complaint, the attachment is not a part of this, so you kindly furnish me a copy. My lord, thereafter comes 322, my lord, which is an order of 17th of October 2023, which takes note of all this, but this order is not based on those complaints. It has not decided either way. The order is that since all the persons are no longer there for the running of the association, an election is to take place, and I appoint Mr. X to conduct the election within a particular period of time to fill up the blanks. But in the process, my lord, he also, having regard to the gravamen of allegations, my lord, supersedes the board with a rider that this order is subject to my writ petition. Now, my lord, my learned friend has not even, my lord, he feels that I am a non-entity, therefore he does not want to use my affidavit or any of its contents. He has not even placed before your lordship that, my lord, these allegations, my lord, the complaint of the complainant might not have been attacked, but there were at least 10 to 15 financial allegations against the functioning board, which prompted me to come to your lordship's court at some previous point of time. Apart from anything else, my lord, there was also an issue of election. Your lordship did not accept my point regarding election, but my lord, relegated the entire issue before the competent authority for decision. That decision is a subject matter of challenge in my writ petition. Now, my lord, please see that decision. It's a part of
That cannot be looked into for this. This only concerns the order removing this board. Suppose this board, if they win here, then the board is reinstated.
Well, then your lord.
Still then, your writ petition, that's why I did not accept the contention made at the outset by the state that your writ petition has been
my humble submission to your lordship is looking at a writ petition at the instance of the persons who is not affected. He is not amongst those five or amongst those remaining.
Point you have argued already.
My lord, so therefore, my lord, whether he has the locus to ventilate the grievances of the remaining managers, and that too by appending a letter not.
Let us come to a larger issue for that, the regarding locus standi. What, according to you, is the point of time when a resignation is said to be final?
My lord, legally, it is to be final, my lord, when it is tendered. Unless there is a specific element.
Which law? Show me.
My lord, that is the general law regarding service jurisprudence, unless the relevant regulations specify.
Service jurisprudence.
My lord, that is the law. The resignation ordinarily flows from that principle. The principle is whenever you tender, it is effected on the very same day, unless there is a, my lord, corresponding obligation for the authority to accept it. If there is any law which says that one has to accept the resignation is immediate. It is not subject to any acceptance.
Achha, the resignation letter.
I'm sorry. I never interject, but since there's a question from your lordship, I shouldn't answer it in reply. And since Mr. Bhattacharya is still submitting, the statute provides 13(2)(b) of the bylaws.
Is immediate.
Has to be accepted by the general meeting.
What is this, Mr. What is this? You're asking for some document? I love the gesture.
No.
There's a royalty about it.
I'm sorry.
That is what Mr. Chaudhary was remarking.
No, it's just like.
My lord, Mr. Mukherjee points out, that
Yes.
This pertains to resignation of office bearers.
All of us are office
My lord,
bearers.
office bearers. So
President,
therefore, the
secretary-
president, secretary, or any other elected, but it presupposes, my lord, an immediate acceptance. And a meeting is to be called on receipt of the notice. The board.
Come again. It presupposes an immediate acceptance.
My lord, it is recorded on receipt of the notice. The board shall, as early as possible at a meeting, consider the matter, and on the resignation being accepted, shall forthwith elect another of. But here, my lord, here the resignation was immediate. The language, the tenor of the letter. But if there is no board, if the board as a
There
whole,
was a board. 5 members at least were there.
my lord, there was no board. My lord, there was a complete, my lord, mismanagement in the entire situation. The situation warranted an immediate interference by the competent authority, which, my lord, irrespective of hearing or no hearing, my lord, competent authority in terms of, my lord, the bylaw 16B, section 16B2, my lord, section 16B2. Though, my lord, in the language, some element of natural justice and a hearing is contemplated, which apparently is also not, my lord, undone here. My lord, there was some element of hearing afforded, but the persons who
Hearing is the got to be given.
My lord,
Tender resignation that has to be accepted. Need not hear.
not that is not
13B does not contemplate in hearing necessarily.
Members are not office bearers.
My lord, please do not mind. My lord, I am once again not relying on section 16B2, which says
Not 16B. 16B2 is something else.
16B2 is, my lord,
The resignation.
removal.
Yes.
Now, in the resignation part,
Now, are you addressing the resignation or something
my
else?
lord, resignation part, my lord, your lord,
Resignation, your locus standi point is on resignation.
my lord, my respectful submission on the issue of resignation is, my lord, there is a, my lord, difference between a BOM and a office bearer. Office bearers are, my lord, appointed from amongst the BOM. All the office BOM are not office bearers. My lord, kindly fall back to regulation 13. The president, secretary, or any other elected officer. My lord, this resignation, with all humility, is restricted to office bearers. My lord, because this whatever, my lord, bylaw 13 deals with election of office bearers and removal of office bearers.
Right. Because they have been mentioned also in 13(1)(a).
Yes.
Right.
And, my lord, in these bylaws, my lord, please see, my lord, regarding the constitution of the board managers and its function. Then, my lord, paragraph 7 or my lord, bylaw 7.
Yes.
Then is, my lord, election of the board, managers of the board. That is, my lord, this 1/3 or 3 and 48 is relatable to board managers. These board managers. Meeting of the board in the absence to be elected amongst by the managers present. My lord, C9, kindly see 9.
All managers are members.
All managers, my lord, BOM is the board of managers.
So there is nothing as such as members. They are managers.
They are managers, my lord. These
Out of them, some of them are office bearers.
Some of them are office bearers.
Which is spoken of in section 13 also.
Yes.
Bylaw 13.
Yes. In addition, there shall be following office bearers: a vice president, a secretary, one or more assistant secretaries, treasurer, one or more assistant treasurers. All the office shall be elected and from the managers of the board. And this is relatable to this resignation of office bearers.
How do you deal with this, Mr. Bhattacharya? 13.2a. The president, secretary, treasurer, or any other elected office bearer of a board. I mean, that means the assistant secretary, treasurer, and all those.
Yes, yes. Or any other elected office bearer is relatable, falling back to 13.1a.
Right. Because the following office bearers have been specifically enumerated.
Yes.
Right. So
Now,
this resignation pertains to them only.
Yes.
And therefore, there is no provision as to
board of managers, ordinary board of managers, who is neither of these. No. Neither the president, neither the treasurer, it does not apply. It is an automatic decision. And as indicated, again I repeat, page 322 may prima facie appear to be on the basis of the complaints and the counter complaints.
Mr. Bhattacharya, is anything on record to show that they had actually tendered a resignation?
Yes.
I mean, just show me that you showed me something.
Page
apart from that list, that resignation letter itself.
Page 14 of the affidavit in opposition used by the state.
No, this is not the petitioner's resignation.
And page 13 of the affidavit, enclosing a list of resignations.
List is given by the president.
Fine.
Is there anything to show that Ram Kumar Jha in his handwriting or
Ram Kumar Jha's in his handwriting is page 316 of the writ petition.
Only those two emails?
Yes.
It is not disputed, Mala, that I had tendered. That is not in this.
You tendered?
I tendered my resignation on 11th by that email, which I withdrew on 14th. That is...
No, 11th you said that I had tendered my resignation on 7th.
No, with effect from 7th. I had not tendered anything on 7th, my lord. My learned friend is right. I was not present physically on 7th. Volume 316.
Oh, hereby tender by resignation?
Yes.
Request you to accept
with effect from. With effect.
Right.
With effect. He was not.
So this was after the show cause.
This was after show.
I'll hear you in reply, Mr. Thakur, on the effect of this.
Yes.
After resignation, whether you can.
Yes.
Anyway, because that depends. Your locus standard depends on that also. Apparently.
I have a one-line answer.
Yes, Mr. Bhattacharya, quickly finish.
Now, my lord, then this order,
yes,
at page 323, is not premised on, my lord, the complaints and the counter complaints, or, my lord, it just records. It is premised on this. It appears that in the interests of the proper functioning of Uniworld, under this act or the bylaws, it is imperative to supersede. This is the reason.
So this is the only reason.
This is the only reason, not the complaint. Because, Lord, it may be a foundation, but ultimately, Lord, at page 322 bottom,
the complaint issue, the indicated in the show cause, Mr.
My lord, your lordship is correct.
Was only Dr. Praveen Kumar's complaint.
Yes.
Or maybe with Praveen Kumar, somebody else was also there, which
my lord,
proved in the order.
My lord.
That was the only basis. On the basis of that, is this a correct conclusion?
Lord, with respect, please see 322 bottom once. Kindly see.
Yes. Resignations.
It was learnt there are a number of other BOM members and have also sent their resignations via email to the competent authority. Present BOM has become non-functional and ineffective. I am not using the other word, kaput or whatever. And then is this decision. It is no one's case that there was no resignation.
No, 40 were there.
It is no one's case that, even
the resignations, the mass resignations themselves are
that
sufficient.
impelled the competent authority. I am not, justifying whether
no.
I am just
that
speaking
was a valid ground.
That is a possible ground. These lines of decisions are there. I need not trouble your lordship with that. That natural justice at times becomes an idle formality. because my lord, giving a hearing will not change.
It becomes a formality if the judge is idle. That is
No,
the
no,
form
no,
of it.
no, not that. My lord, when the facts are so glaring that, my lord, whether a hearing is given or not, my lord, the ultimate decision will boil down to the same thing. Then natural justice at times becomes.
Mr. Bhattacharya, an elected board is there, board of managers is there.
My lord, elected board has all resigned.
The removal of that, here it cannot be an
Lord,
idle form.
kindly, with deepest of respect to your lordship, events which happened in course of
What event?
Milord, events.
A particular security personnel threatened a person.
No, not threatened.
Apart from that, what is
Milord, they were not threatened. There was a physical assault.
Even if
Criminal cases there, counter cases there.
Even if there was a physical assault of a particular person by a security person, which is fully amenable to criminal jurisdiction, and cases are probably going on in there.
Yes, yes.
Now, for that, the entire board will be removed.
Milord, for that, the entire board is being removed because of the previous nature of the order, where I have already invited from the court an order.
No, that has not been reflected here. Also.
Yes, the last sentence.
What is that?
The last sentence of page 323.
What is that? Read out.
The order will take immediate effect and will be subject to the orders of the Honorable High Court in such and such.
Saying that this means that pendence of the writ petition is a ground.
Milord, not pendence of the writ petition is a ground. But, Milord, this order is of course subject to the orders passed in the other matter, where a specific invitation has been made.
Happen even if this line was not there.
Correct. Yes.
Milord, irrespective.
But this does not have anything to do with the reasons for it.
Milord, with deepest of respect, the other
hits a person. Bad. Steps are taken. For that, the board will be removed. That is the only ground.
Milord, the board will be removed because of. It appears that Milord, board will be removed on these 322 last paragraph, 323 first paragraph. Those are the two grounds. Milord, without looking into the color of anything else, 322 and 323 are the two, Milord, are the foundation of removal. And Milord, today, my learned friend says that he could have ordered election. Milord, that is what has been ordered. Milord, a fresh election, Milord. The
fresh election for the entire board for the vacant positions.
That is always provided in the statute. The statute says that, that to fill up vacancies, Milord, it has to be done. So, Milord, today.
You cannot create a vacancy by removing.
No, I am not creating any vacancy.
You means the competent authority cannot create a vacancy by removing the board existing.
Milord, the question is whether these 5% who remain as board managers and who do not, Milord, demit office or who have not put in their papers, whether, Milord, a writ petition, not at their instance.
That we have been from the inception.
Not at their instance, will be, Milord, entertained so as to, Milord, obviate an election.
Let Mr. Tucker answer that. Yes.
Milord,
any other point, Mr. Bhattacharya?
Milord, my writ petition, your lordship will kindly, Milord, because
we had after this.
No, because, Milord, today, if your lordship, assuming, Milord,
if I set aside this order, then the board is revived. If your writ petition is allowed, then the board again goes.
Yes. The order. Then he's against the competent authority. Here he's trying to justify the competent authority.
I'm not trying to justify, Milord.
But that will be on independent ground.
Yes.
Your writ petition, if that succeeds, that will not be on the grounds.
Milord, where, Milord, please pardon me in saying this, where there are, Milord, exemplary grounds.
Mr. Bhattacharya, those grounds are only amenable to that writ jurisdiction. I mean, the hearing of
1700 item 2.
Milord, I would humbly request your lordship to kindly, Milord, hear that matter together with this and not independent of each other.
I'll hear it immediately after this.
As your lordship, please.
Yes,
I cannot.
Milord, may I just hand over the judgment which I referred to? Paragraphs 25, 26, 27. Any order on reasons beyond the show cause is bad and liable to be struck down.
Locus standi.
25 and my lord, locus stand. I am, my lord, a resident of the complex. I am entitled to be administered by the duly elected board. Irrespective of whether I am vice president, irrespective of when, that is paragraph 1 of my writ petition and paragraph 4 of my writ petition. I am a resident. I have elected somebody. I have elected a valid board. That board has been wrongfully removed. I am entitled to be administered by a board which I have elected, irrespective of whether I'm a member of the board or whether I'm an ordinary resident. My lord, the circumstances in which these gentlemen tendered their resignation, my learned friend said, is not read. Nothing is written in the letter that coercion, etc. Factually incorrect. Pages 30 and 30 pages 30 and 34 of the competent authorities affidavit of the opposition. 50 to 70 people gherowed the office of the board and forced them to resign. This was the situation in which all these people submitted their mass resignation. Competent authorities fully. And this argument is self-defeating with the greatest of respect. 16B2, the power which has been exercised, is to supersede a board. My learned friend argues that board has already resigned. Then you cannot have power under 16B2. I can supersede a board which is existing. So on the one hand, he argues the board has already resigned, gone kaput. Therefore, I appoint an administrator. Then 16B2 power cannot be exercised. 16B2 is only when there is a board which requires to be superseded.
I'll put this matter up for judgment on 30th of January.
Please, Malad.
Along with the other writ petition for hearing.
Malad,
pass my order in this and immediately therefore take up.
And in the meantime, Milord, what happens to the your lordship has been kind enough to extend, though I am not appearing. He is appearing for the
competent the administrator.
The administrator is to continue.
Yes, definitely.
Of course, till 30th. Now comes number 3.
Yes, Mr. Chaudhary. Argue from there. Argue from there.
I'm sorry, Milord.
Argue from there.
Yes, no argument, Milord.
Yes.
3 things, Milord, I've essentially done.
You are for the
I'm for the administrator. Because your lordship added him, Milord.
Yes, last year.
So, Milord, he's come with.
No, I'll extend his tenure.
No, Milord, I'll just tell you, lordship, 3 things. Number 1 is what we have done is there was patchwork required on the roads. We've done that. Number 2, Milord, what we have done is that we've divided the towers and we have allowed each tower to do their own under supervision and control to do their own.
Who was appointed as an administrator?
Retired, Milord, army man.
No, there is no allegation regarding your functioning.
No, Milord. I just want your lordship to say this. This is number 1, number 2. And number 3, Milord, which, Milord, I've got very strict instructions, Milord, to indicate to your lordship. The most important thing we have tried to do is to create a situation of bonhomie in the society. That's very important because
that's absolutely nice on your part. I mean,
we've had, my lord, a situation where Group A is, my lord, warring with Group B, and there are, my lord, other residents, and there are unsavory situations where, my lord, somebody is beaten up. I don't want to know who's responsible, but, my lord, a situation must be created where, my lord, residents can live in peace. So, my lord, bonhomie is very important. If required, my lord, some, my lord, independent person may, my lord, conduct elections, whatever your lordship.
I still have a tenure of 3 years. My learned friend will not take up arms.
No, I am not taking up anybody's arms.
Very obvious where you're coming from when you suggest election.
But what is my lord, important is, my lord, the human aspect of it, that there is some intervention of court, my lord, required because things have gone beyond control.
That has nothing to do with your job as an administrator.
No, that has nothing to do with me. But I see, my lord, difficulty coming.
No, Mr. Chaudhary, I won't take your advice on that.
No,
I mean, not me. I'm not.
My submission.
I mean, I sounded wrong. I'm not
no.
saying that you are advising me, not me as me. I mean, you need not be heard on that issue as an administrator.
Well, otherwise, I don't think I'm part of this.
As a well-wisher of the society, definitely, Mr. Chaudhary, you have a point there, and you are right on that also. But in this particular case, in your capacity as an administrator, you cannot be heard on those issues.
No, I don't. I don't want to be heard, and I have nothing to do with.
And you are absolutely right on that. But altruism takes a backseat when litigation comes up.
Yes, that's true, Milord, but it's reached a very unsavory situation.
It is undoubtedly in within a single society where so many respectable people are there apparently.
Yes, and they're all, Milord, respectable, well people of stature.
Definitely. It appears
in
to
court
from the
about who's going to keep the lawn mode.
Milord,
that's Milord shocking.
Since the administrator is present, I have one humble request, Milord. We have not used an affidavit in opposition to 1700 because in the intervention we were removed. Now we do not have access to the records of the association. Let him just give us access to the office.
No, this is important, Milord. This is very important.
Mr. Thakkar, I'll not pass an interim order. I'll pass my final orders on
this.
I must, Milord.
No, I'm not asking any interim order in this matter.
No. Mr. Thakkar, I must indicate
when I take up 1700, I'll decide.
Very well. Please, madam.
Milord, this is where I'm in difficulty. Though, Milord, I've been there for 3 months, they've effectively not given me the accounts. I've only 3 days back been given some hardware, which my lord has nothing. Whatever I've done on my own. So don't now say give it back.
No,
I
my
don't
They
have
give
anything.
accounts.
They
The
have
accounts are in
nothing
the
to
office.
account for. They have
Yes,
eaten after breaking.
everything,
in
including the
view
building.
of the fate of WPO 1700 of 2023 being, in the opinion of the court, dependent on the outcome of WPO 1755 of 2023, since in the latter writ petition, the removal of the board of managers has been challenged, WPO 1755 of 2023 is taken up for hearing, hearing is concluded and judgment is reserved, the matter shall be listed for judgment on January 30, 2024, along with WPO 1700 2023 for hearing.
Grateful.
Needless to say, the tenure of the administrator is stands extended till disposal of WPO 1755 of 2023. So that there is no doubt on that, even if I cannot
Yes,
sit on that date, suppose.
somebody has to be there. Somebody has to.
So,
Mr.
my lord,
Chaudhary is very
nothing really which is required to be done every day. It's my lord overall control. That's all.
grateful, my lord, deeply obliged.
Do you think? Combine order. 1700